Court officer, am I audible?
Yes, sir, you are audible.
Court officer.
Thank you, madam. Court video is not being seen. That's right.
Madam Court Officer. Court Officer. Yeah.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದ್ದೀರಾ?
ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು.
ಸರಿ ಇದೆಯಾ?
Court officer.
MFS ಎಲ್ಲ ಲಾಂಗ್ ಡೇಟ್ ಹೋಗುತ್ತೆ ಬೋರ್ಡ್. ಇಲ್ಲ ಫಿಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಬೋರ್ಡ್.
ಮೇಡಮ್ RPFC ಮೇಡಮ್
RPFC ಎಲ್ಲ ಅಲ್ಲೇ ಸರ್.
ಎಲ್ಲಿ?
ಹೇಳಿದ್ನಲ್ಲ, ಕನ್ಸರ್ನ್ ಬ್ರಾಂಚ್ಗೆನೆ there is a standard direction as soon as you comply all the office objections it will be posted before
ಅಲ್ಲ
the court ಅಂತ.
ಪೆಂಡಿಂಗ್
ಆದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು. ನಾವ್ ಹಂಗ್ ತಗೊಳಕ್ ಬರಲ್ಲ, ಓನ್ಲಿ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಡೈರೆಕ್ಷನ್ ಅಷ್ಟೇ. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಹೇಳಿ ಸರ್. ಹ್ಞೂ ಸರ್.
Court officer.
ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ವಲ್ಲ ಸರ್, ಹೇಳಿ
Madam.
ಏನ್ ಬೇಕು ಹೇಳಿ.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಯಾವಾಗ ತಗೊಳ್ತಾರೆ ಮೇಡಮ್? ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಆದ್ಮೇಲೆನಾ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಾ?
ನೀವು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ ಕಮೆಂಟ್ಸ್ ಮಾಡಾದ್ಮೇಲೆ ಫಾಲೋ ಮಾಡಿ ಸರ್. ಐ ಆಲ್ಸೋ ಡೋಂಟ್ ನೋ ವಿಚ್ ಲಿಸ್ಟ್ ಈಸ್ ಟೇಕನ್.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಅದೆಲ್ಲ ನಲ್ಲಿದೆ.
Yes,
Lords.
Yeah.
List 3, serial number 2, my lords.
out of the list,
Madam, memo for peace.
memo for, yes. Let's do tomorrow.
Memo for your lordship. Date is given this in this matter already. Date is given. The agency is the maintenance has been stayed. The respondent is.
It will be
kindly have
listed
it on
according as per the
No, the agency,
convenience
the
of the
school
court.
fee is to be paid on this month. The last date is with the school fee. Maintenance has been stayed.
Take that and
22. Date given is on the 8th and 10th of September. I would wish to have it on 22 or
no,
28.
there is no urgency for that.
No,
Yes.
the respondent is wholly dependent on the
Then you file execution.
on the last day or your
You
lordship.
file the execution.
No, stay application I have filed for vacating stay of application I have
We
filed.
will not
Please
take it
hear
up.
on it.
We will not take it up before that date. Yes.
Madam, for withdrawal of the amount, madam.
Hmm?
This is the amount, madam. Withdrawal of the amount.
Serial number, sir.
Yeah, madam. Memo.
Posting for withdrawal.
Posting. Madam.
Look at it.
Ah,
Yes.
ನಾಳೆ.
Call page wise.
Page wise adjournment, list 1, page 2, serial number 5 and 6, page number 3, serial number 7 to 11, page number 4, 12 to 16,
15, my lord.
On behalf of?
on behalf of.
On behalf of applicant, my lord, Nayak advocate, my lord.
The request, this is matter on 27th of October.
What's out? Serial number 15, my lord.
Yes.
Serial number 15 on 2 weeks. So far as file in appeal and counter appeal so far as on 2 weeks collected from other side appeal memo.
Land counsel Mr. D. Vijay Kumar shall serve the copy of the appeal memo on the counsel appearing for the respondent. This is matter on 16th of October.
Page number,
Serial number 18, I pray, on behalf of the appellant, I pray.
page number,
Two,
sir, I
Serial
have
number 18.
5, serial
18.
number 17 to 20, 18.
18,
Yes.
I pray big standing.
Why?
So appellant counsel is not, he is held up in another court, little bit.
You know, matter will take some time. If he is held up, will come. Let him come. Yes.
Page number 6, serial number 21 to 23,
My lord, serial number 21, my lords. There is some personal inconvenience, my lord. Senior won't be able to come. Kindly list it after 1 week.
Have
Date may
informed
be
the other
fixed.
side. Inform the other side.
We have informed the other side.
Yes, 21. This is matter on 29th of October. Yes.
page number.
Serial number
7,
19, my lord. Serial number 19, my lord.
Yes.
Kindly along with another 2 appeals are connected matter, claimant appeal, my lord.
Where are the numbers?
2926 for 2023 and 2924 bar 2023, my lord.
Yes, along with those two on 30th of October.
Kindly call for TCR, madam, one time.
Page number 7, serial number 24 to 28, page number 8, 29 to 32, list number,
Serial number 30, my lord. Senior had some medical emergency, my lord, since kindly have it out for 2 weeks, please.
Request. This is the matter on 31st.
Much of.
My lord, serial number
1st of October. What all the dates now I have said is all in October. Yes.
list number.
My lord, serial number 31, for the appellant seeking for time, my lords. Senior is having some.
Why all these matters are, if you're asking for adjournment, 23 appeal, what is the reason?
Just for compliance, my lords.
Unnecessarily matters which are, who wants adjournment, all those matters are listed. People who are waiting, their matters are not being listed. List a matter on December 17th at the request of learned counsel for the appellant. Yes.
List number 2, page number 2, serial number 6 to 6 and 7, page number 3, serial number 8 to 12, page number 4, 13 to 20,
Serial number 20, Your Lordship, and for the applicant, I pay for a week's time. For the petitioner.
20 coming up for preliminary hearing.
Your Lordship, there are the documents that we are relying on. I want to translate and put the copy. A week's time maybe.
No, what, for a preliminary hearing, what are the translations and all?
Some inconvenience.
Because you filed some writ petition which has no grounds, that's why you seek adjournment. This is matter in December 17th.
Your Lordship, I pray for
Why?
next week, Your Lordship, I request.
This is a matter on 16th of September. Anybody who asks adjournment, will be given a long date. Some matters on next year also. Yes.
page number 5, serial number 21 to 26. Page number 6.
Number 24, madam. 24 for respondent, madam. Only a week's time is that.
Why?
Lord, undercut council is went to native place for family function.
Interim order is there. If interim order is there, this is matter on 30th of October. An interim order earlier granted is extended. If interim order is not there, look at the file. If the interim order is not there, list the matter on 11th. At the request of non-counsel for the respondent. Yes.
11-9.
Interim order is there on 11th October, 11th of September. Yes.
Page number 6, serial number 27 to 34.
Serial number 28, my lord. Serial number 28, appearing for the respondent. A short adjournment may be given, my lord. In the first
I appeal for the petitioner, my lord. 28.
There should be a reason for seeking adjournment. It's not fair.
short adjournment.
List this matter. You have a stay in your favor?
Yes, my lord. Interim order is there. Last occasion, lordship heard this matter.
On 27th of November. Interim order earlier granted is extended till then.
That
Yes.
will be a little longer date, my lord. I am not seeking adjournment. Shorter date, my lord. September first week.
You have an interim order in your favor. Yes.
Right, my lord. Lordship heard this matter. That's the reason, my lord, already. And they were, my lord, directed to find out if there is any possibility of a settlement. This is not the covered and 125(4), my lord. Lordship heard me last occasion. Short date, my lord. Any date.
Heard 10 times adjournment, waste of court's time, nothing else. This is a matter on 10th of September. No further adjournments.
That's
At the
What
request.
10th of
Fixing a
September.
date.
10-9.
What she said.
Page number 7, serial number 35 to 42.
My lord, I appear for the petition in serial number 37, my lord. There have been some change in circumstances. The grant that was given by the military has been cancelled. I need to update the documents with the memo. Kindly have it on Monday, my lord. I'll file the memo before that.
Have you informed the other side?
No, my lord, I am not.
Then wait for the time.
I'll inform, I have the,
No,
I'll
what is
inform.
there? See, we'll hear them. Yes.
List number 3, page number 1, serial number 1 to 3. Page
List
number
number 3, serial number 2, my lords. I have filed withdrawal memo on 13/8, my lords. So it may be dismissed as withdrawn, my lords. I'm for petitioner.
Which case?
13/8, ma'am.
Which case? Third list, second matter. Then why it is not, cause list is not indicating that?
because today morning.
The memo is filed that the petition is not intended to prosecute the matter. Memo is taken on record, dismissed as not pressed. Yes.
Page number 2,
Great for my lords.
serial number 4 to 6, 48. Page number 3, 9 to 12.
For serial number 8, my lords. I have already complied with the memo for conversion from RPFC to WPFC, my lords. I'm for the petitioner.
Memo is filed for
Serial number 8.
We'll see when the matter reaches. How can we, what we can do now? Yes.
Serial number 11. Can you have a separate?
This matter on 10th of September at the request of non-counsel to the petitioner. Have you informed the other side? Yes.
page number 4, serial number 13 to 17. Page number 5, serial number 18 to 22.
Serial number 22, my lord.
Mr. Mushtaq Ahmad is not well. He is under treatment. He is bedridden, my lord. Yes, 3 weeks time.
The matters. 22 lists on 23rd of October. It is submitted that the council is unwell. Yes, next.
Serial number 2324. List 1.
My lord, serial number, second list, serial number 33, my lord. Kindly 1 week adjournment, senior inconvenience today, my lord.
Second
Proceed
list.
in
Serial number 33.
33, please, my lord.
You are
Second-
appearing for whom?
Petitioner, my lord. Aishwarya.
Have you informed the other side?
Please, my lord. Inform ಮಾಡಿದ್ದೀವಿ. Inform.
It is submitted that there is some person and it is informed to the council for the respondent. The request lists the matter on 18th of September.
Please.
Yes.
Serial number 1 for being spoken to. Shipatri Shastri. This is Shivanegowda.
Right, in this case,
What is this? Who are you?
A petitioner, 14%.
What is the memo?
Change in circumstances and 340 application.
No, it is a.
340 section. 340 perjury. I have filed IA. So.
What is that petition?
No, it is not this.
RPFC. RPFC. RPFC.
RPFC.
Listed someday. Yes. Why, Mr. Shastri, for everything you are getting so confused and.
But para 2 of the judgment, as per the tribunal order, both the vehicles are liable to pay 50-50. But in para 2, it is held that man only Bolero vehicle is held responsible.
It says it is because of the negligence of the driver.
Both the vehicles.
Both
the vehicles.
Driver of
Thereafter, in para 2 of the order portion, 2 and 4 are liable to pay compensation.
1 minute.
Seven, 8, 7, 7, it is
Paragraph?
Order portion, 8 para 8. Order portion. The second respondent company shall deposit. It is second and fourth respondent.
Respondent number 2 and 4.
4. B. Pradeep name may be shown for the fourth respondent which was left out. In a connected cases also your lordship has written the same thing.
Appearing for fourth
respondent.
The matter is placed before this court. Land counsel and the caption for being spoken to. Land counsel for the petitioner appellant submits that. Land counsel for the respondent submits that. In the order, at paragraph number 2 of the order, instead of mentioning that the both vehicles are responsible, it is mentioned in the order that only the driver, because of the negligent driving of the driver of the Bolero van, the accident had taken place. And further, the fourth respondent insurance company's counsel's name is not mentioned, and in the operative portion it is only held that respondent number 2 is liable to pay the compensation when it is order of the award of the tribunal that both 2 and 4, both the respondent 2 and 4 insurance companies are liable.
Equally.
Considering the submission, at paragraph number I have written here, which is paragraph number 2, so and so shall be incorporated. Paragraph end of paragraph number 5, so and so to be incorporated. And at paragraph number operative portion of the order at 8.2, so and so to be incorporated. The corrected copy.
Respond number 4 is at liberty to recover the same from the respond number 3. Pay and recovery order is there.
Please next.
Serial number 2 for dismissal. Serial number
Recovered
2.
from the third respondent.
Hmm?
The fourth respondent
Yes,
is
he is at liberty.
50%. Thereafter, recover the same from the owner of the vehicle. Third
That was order of the tribunal.
Order of the tribunal.
So the PN
Yes.
recover, and the fourth respondent is at liberty to recover it from the third respondent. Same second, that operative portion, which I have not written, that you have. Otherwise, in the order I have written it. Yes.
Serial number 2, Keshav Rao Mohite.
We have taken steps as per the address mentioned, Lord. A week's time may be given because some of them have returned. Last time I was not able to present due to my knee pain. A week's time may be given. The same address which were the respondents who were the petitioners before the trial court.
Fifth respondent is served.
Yes, he is the driver of the vehicle.
No, 1, 2, 3, 4 have to be served.
Yes, my lord. I will take another fresh step.
2021 MFA.
No, my lord.
A week's time is granted for taking steps. The issuance of notice to respondents 1, 2, 3, and 4. If the steps are not taken, the appeal shall stand dismissed without further reference to the court. Delete from the caption dismissal. Next.
Serial number 3, Syed Abdul Sabur.
Needful has been done, my lord. I am appealing.
Who are the respondents?
My lord.
Who are the respondents?
Respondent owner and owner of the bus as well as insurance.
Who is
And
Which
this,
company is that?
my lord, 14917 of 22. This common judge.
Insurance company, who appears? You appear? Mr. V.C. Sivanagowda is directed to take notice on behalf of the second respondent insurance company.
My lord, this is a connecting matter which has been disposed before honorable division bench. Huh? Sorry.
Connected matter.
Connected matter.
Let the direction.
No, whatever it is, somebody has to appear on behalf of the insurance company.
Yes.
Mr. V.C.
The
Sivanagowda is
liability is
directed-
on insurance. It has been in the division bench has passed liability on insurance. Earlier it was the.
Mr. Sivanagowda is directed to take notice on behalf of the insurance company. It is submitted that already process is paid. List this matter after service of notice. Delete from the caption for dismissal. And the council shall show the copy of the memo on the council appearing to the insurance company.
Serial number 4,
Yes.
Dabali FS.
Appeal for the corporation order. The claim petition was filed, a lot of damage to the was sustained by the corporation. In the tribunal model has not awarded not the loss of revenue during idling
Loss
charge.
of?
Revenue not loss of income during repair period by relying on the single judge of this honorable court. Now that matter has been referred to the division bench model. It may be awaited model.
It is submitted that the issue in question.
I'm appealing for appellant in first
The
matter,
relevant,
70.
the issue in question with regard to the liability to pay the
Loss of revenue not during
loss of revenue
idling charges.
and the loss of revenue to the corporation. The issue is pending before the division bench. Delete from the caption dismissal list the matter on 12th of November. Yes, next.
Serial number 5, for orders matter.
Case is disposed with observation for transfer of the petition on 21st March 2025.
The CP is listed before me.
Principal senior civil judge and JMFC Maddur. Has to be clarification.
Which court is this?
This is the third edition senior civil judge, the
No,
first
no.
court.
I think in the operative portion, you must have written that it has to be transferred to the principal district judge and session judge Mandya.
Mandya.
Let's see the prayer of yours.
So
Come to
senior,
the prayer in the CP.
senior civil judge court is at Maddur. It may be
Is
transferred
pending
to
before
the
the
same
senior.
court.
No, let's see the prayer I'm asking. Prayer in the CP. Then why in the order copy it is mentioned like that? Where is the order copy?
This is the, madam.
In Madhur, there is a family court.
There is no family court. A
Then it
specific
will be
family
senior
court is
civil
not
judge.
there,
It
but
is not-
senior court is there.
Huh?
Senior civil judge court is there. Where in the earlier court also senior civil judge and JMFC at Devnalli. The matter was proceedings.
No, the letter is written by the judge saying that that court has no jurisdiction to decide
That is
the family
junior.
court matters.
Yes, that is junior. Principal civil judge means junior court. It has no jurisdiction to entertain the divorce case. Whereas senior court can be entertained. Or the district court otherwise.
It is for you, when you're seeking a transfer, it's for you to say which court is having jurisdiction.
I will
It's not for
apologize.
the court to do the workout.
I'll pad on with this.
Find out from the registry which is the court. R&S. In Madhur, which is a court who can deal with the family court matters. Password. Yes.
Cell number 6. K.R. Nagaraja.
Referring to appellant side, my
Who is
lordship.
R1?
R1 driver, my lordship.
Why is he always a
Owner of the driver. R1 is the driver.
liability on whom?
R2 general insurance company.
Then in that case, why notice or why it is waiting from that time?
Liability is
On the insurance.
probably is not aware
Let's
of the
see.
case fact.
Let us see, let us see.
Claim petition has been dismissed on the ground that for one so negligence, he cannot maintain a claim petition under ECA.
Kindly.
What happened to the earlier notice? When was the notice sent?
28 2020.
Like that.
Already 24/7/2025 notice.
Huh?
Against the provisions of the act, matters to remanded to consider on merit point. The judgment which was passed relying upon our the Honorable High Court judgment, one single bench judgment. Under the ECA, they have to prove the accident. Negligence is not the court has taken the negligence on the part of the injured
Whatever
himself.
we have to do, the person,
But owner has
party should be represented. When was the notice sent? When was it? It says await service of notice, not process, not paid. They have paid, it says await service of notice. When was it sent?
Dismissal.
It will be there in the file. They must have mentioned when it is sent. Turn to the other side. Well, wait. This
They
is
have
matter.
not served appeal memo to me also.
I already-
Let the direction
This is
be
matter after
issued
service
to
of
them.
notice. Land counsel for the applicant to serve the copy of the appeal memo on the counsel for the respondent, insurance company. Yes, next.
Grateful.
Serial number 7, Gururaj R. 7, Gururaj R.
Yes.
R1 is the claimant, your lordship.
R1 is the claim. You're
R1
the
is
owner of the
claimant.
vehicle.
I'm the owner of the vehicle.
The
I'm for the respondent.
Liability
to
is
my-
placed on me.
needful shall be done within a week, or else the appeal shall stand dismissed.
Serial number 8,
Yes.
Obliged.
appellant Saroja.
Who will take the steps, sir? What happened to that? The as the council is no more, this court has ordered notice to the appellant on 24/7/2025, returnable by 28/2025. And as for the Shara, the appellant is no more. Hence appeal is dismissed as awaited. Yes, next.
Serial number 9. Serial number 9,
My lords, I appear for the petitioner. Weeks time may be granted to comply with office objections.
Which one?
Serial number 9.
You have instructions to file wakalat.
that's the appellant's
All
names are-
appellants,
Sandeep.
your, which list you are, this is MFA.
List number 1, sir.
Apologize, my lords.
When was the notice sent? This is matter after service of notice. Next 10.
Serial number 10,
I number 1 of 20 is filed to condone the delay of 28 days.
And for the appellants.
The stated delay is condoned. Admit post for final hearing, call for the DCR.
serial number 11,
11.
May I request for persistence in this case, this is serial number 10. May I request for any date, my lord? It is pending since 5 years. Claimants are serving.
The list is matter on 25th of September. Yes,
Great.
11.
11,
I permitted to withdraw the appeal.
Take that.
11.
The memo is filed seeking to withdraw the petition. Dismissed as withdrawn.
Please.
serial number 12, serial number 12 for admission matters.
I appear for the second respondent.
Sripadvi Shastri.
Admit post for final hearing.
Serial number 11, 13, Ravishankar Shastri Ji.
Where is Pradeep?
Question
P.
of
Pradeep.
Admit post for final hearing.
Serial number 14, FS Dabali.
Death of a minor child aged about 14 years.
Peter DS.
Death of a minor boy aged about 14 years. 5,62,000 has been awarded. Only rate of interest not 9% has been awarded, but that can be.
Where is other side? I'll pass over, ask them to come. Pass over.
Yes, sir. Serial number 15, urgent. Serial number 16, urgent. Serial number 17,
15, I'm for the appellate, my lord.
Already adjourned. This one
Please,
for
ma'am.
date. Yes, 17.
17,
appearing for appellant Malad, B. Pradeep.
Yes, for Cholamanla.
B. Pradeep advocate also filed an appeal Malad 672/21 Malad.
In 17, Ms. B. Pradeep is asked to take notice on behalf of the insurance company. It is submitted that there is a cross appeal. List along with crops so and so.
Problem Malad. MFA. Yeah. B.
MFA itself you filed.
B.
List
Pradeep
along
advocate.
with the MFA number so and so.
R1 B. Pradeep Malad.
That's what I said.
R1.
This is matter on 23rd of September. Yes, 18.
18.
Direct interest ಮಾಡಿದಲ್ಲ?
Yes.
18. G. Lakshmi Rao.
Admit post for hearing. Call for the TCR.
Serial number 19 urgent. Serial number 20 final hearing. 20. SV Ekde Mulkan for
For
appellant.
representation. This is a matter on 15th of December. You appear for
Serial
this?
number 20.
No representation for the appellant. Counts for the respondent is present. Yes.
Serial number 21. 21 urgent. 22. Serial number 22. G. Lakshmi Rao.
Same. No representation on behalf of both the parties. List the matter on 18th of December.
Serial number 23. Serial number 23. Girish B. Baldare.
Lordship.
Janardhan Reddy.
Where is he?
Then next week, some more judgments is required, but it is self-accident, my lordship.
No representation on behalf of the appellant in MFA 2347 of 2021. This is matter on 7th of November. Yes.
Serial number 24. Prakash MH.
Appearing for the first respondent. Case of death, my lord. The date of accent.
Give it. Ask Devraj to come.
2018.
Ask Devraj to come. Tell him. Today there is one more this thing like that. Let him apply and get it. Yes.
Date of accent is 11/3/2018.
11?
11/3/2018. The income taken, my lord, 9,000 rupees per month, my lord, para 37, my lord. He was aged about 22 years.
9,000. It should have been
My lord, 12,500.
12,500.
40% future perspective.
Comes to 5,000. It comes to 17,500. Bachelor.
Bachelor. $18
8,750. 8,750 into 12.
18 million. 18 lakhs 90,000.
18 lakhs.
90,000.
Who are the?
For the appellant.
Who are the?
During the pendency of the petition, her father died.
Anyhow, 88,000.
Other second.
And 36,000, 10,000. So the entire amount is my mother is entitled now.
The contributory negligence 20% has been fixed against the deceased Millard was going as a more than 1 billion rate of proceeding on a motorcycle. That basis, 20% contributory has been fixed against.
Your Lordship, that is one of the violation wherein he is violated. Apart from that, this is not the main reason. It is being caused for the accident.
Judgments are on their side also. That because it's a triple riding that it can.
6 Millard regarding that. The contention of the first respondent that deceased was riding a motorcycle.
He is the rider.
Pillion rider.
Pillion rider. Yes. Then what is?
Pillion riders, consumption of alcohol, 2 pillion riders of proceeding on a motorcycle.
Your Lordship, nowhere it is been.
Observation.
Vehicle is ridden by the rider. The pillion rider. In the accident, whatever it is, what accident he will, what is his contribution? It can't be.
Only by the pillion riders of proceeding, my lord, without consumption of alcohol and all, my lord.
Your Lordship, there are contradictory statements they have given stating that lorry was stalled and they came and hit the lorry by riding zigzag. But nowhere it is come on record, Your Lordship.
He is not driving.
Yes, Your Lordship.
Contributory negligence could be to the rider, not to the pillion rider. 20,000, 20 lakhs, 24,000. How much was granted?
14 lakhs 30,000.
Please come.
Convinced that 40,000 is available.
What is that?
Consortium 40,000.
Because as on the date when he died, if the father was alive.
Please, Your Lordship.
So now this amount will be payable to which respondent is she? Appellant?
Appellant, second,
Second.
the mother of the deceased.
First is no more.
Yes, Your Lordship.
During the pendency of this appeal.
Yes, Your Lordship.
In the pendency of petition.
Petition itself.
Before MSCT, not here.
Deleted as dead.
Yes, Your Lordship, it's been deleted.
Agreed with the orders passed in, award passed in MVC number 1747 of 2018 dated 26 November 2020, whereby the court had granted compensation of an amount of rupees 14,30,000 and also passed in the contributory negligence and 20%. The claimant is before this court seeking enhancement of the compensation. The accident, the claim petition is filed seeking compensation of an amount of rupees 30 lakhs for the death of the deceased. The accident had taken place on 11/3/2018. According to the respondent, the deceased was riding a motorcycle. I think this is wrong, Mr. Pradeep.
Please, madam.
The deceased was riding the motorcycle. That's wrong, I think.
Deceased was not riding the motorcycle.
The deceased was a pillion rider and there are three of them, there is a triple riding and all of them have consumed alcohol is your case. And all of them.
He was, he himself was riding money, alias money content. Is that deceased?
Yes.
He is the rider. He is the rider. That's what we have para 6, I am going to read that.
But then where is the finding?
Finding para 19.
Para 19.
In support of the petition of the second petitioner, I recommend an eyewitness to some equivalent to. In the bottom word, while overtaking the vehicle in the bottom 16, on the extreme right side of the rash and negligent manner dashed against motorcycle in which the deceased was proceeding. As a result of the deceased sustained severe injuries, all of the body succumbed to the injuries. PW2, next month. Said to be an eyewitness, in Russian also observed. After that, the criminal.
So the evidence of PW2 is in favor of them. Then who are the witnesses examined on behalf of you?
One Tippeswamy, Your Lordship, and the other one is.
No, I'm asking Pradeep.
Please.
On behalf of the insurance company, no, there is evidence of PW2. How the evidence of PW1 is demolished by whom you have examined?
Para 28, there is a discussion. 28. And the relevant to note that the first and second respondent did not dispute the death of money content in RTA, but denied the fact causing death of the driver of lorry. Death by the driver of lorry. However, the respondents have not made any attempt to examine the driver of the lorry to show that there was no negligence on the part of the driver of the lorry, and it is on the part of the deceased. The driver of the lorry would have been the best witness to speak about the occurrence of mode of violence that spent in the absence of any contradictory evidence and advised instance has to be drawn against the respondents insofar as the defense raised by the respondent about the contributory negligence on the part of the rider of two-wheeler.
Then in that case, why did the court fix the contributory negligence?
Accident occurred due to two-wheeler.
No, that court says it can't be. That is not the reason. If you see, court says it is not the reason at all for the accident. Then in that case, why contributory negligence is fixed? Where do you get the contributory negligence? Where is that paragraph? Simply,
45.
as discussed supra,
45.
Conclusion is that para 45.
without any basis.
Para 45. As discussed supra, alleged accident.
What he discussed supra, contrary to that, he has given a finding. Yes.
Driver of the lorry has not been examined. Finding is that valid, but contrary to that.
What is that? No, according to the respondent, the deceased was a rider of the motorcycle. He was riding the vehicle along with two other pillion riders. And as he was going on the road in a zigzag manner, the accident had taken place. And there is contributory negligence. Because of the contributory negligence on the part of the rider, the accident had happened. The accident had taken place. The tribunal, considering the income at 9,000, had granted the compensation as per the table given below at page 43. When it comes to the contributory negligence, the court has held that the evidence of PW2, who is an eyewitness, shows that because of the negligence of the driver of the opposite vehicle, the accident has happened. The court also gave a finding that as there is a triple riding, there is no evidence to show that the accident has happened because of the triple riding, and the insurance company has not adduced any evidence to show that the accident has happened because of the triple riding and negligence of the deceased. But when it comes to the order, it is mentioned that in the reason stated supra, there is a contributory negligence of 20%, and accordingly granted compensation of an amount of rupees 14,30,000. Next one, learned counsel appearing for the appellant claimant submits that the accident has occurred in the year 2018 as per the chart prepared by the Legal Services Authority. The court ought to have taken 12,500. It is submitted that the fixing of contributory negligence at 20% on the claimant, on the deceased, is without any basis and contrary to the findings of the court. It is submitted that on all counts, the compensation needs to be enhanced. Then counsel appearing for the respondent insurance company submits that as there is a triple riding which contributed to the accident, court had rightly fixed the contributory negligence at 20% and there are no grounds to interfere with the well-considered order passed by the tribunal. Next, for having heard the counsels on either side, peruse the material on the court. The first, coming to the compensation, this accident had taken place in the year 2018. As per the table, this court is inclined to take the income at 12,500. Looking at his age is 23. 22 years, future prospects at 40% comes to 5,000. Then his income is 17,500. As he is a bachelor, 50% has to be deducted towards personal expenses, and his contribution to the family is 8,750 into 12 into 18. The loss of dependency is 18,90,000. Under the head of loss of consortium, 88,000. Loss of, not loss, funeral expenses, 36,000. In the light of the law laid down in make losses, so insert 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 20,24,000. Then coming to the contributory negligence, this court has perused the order. The findings of the court and the ultimate order passed by the court is contrary to the findings. In the court has observed that there is no contributory negligence and the insurance company has failed to prove the same, but still has held that there is 20% contributory negligence on the deceased, considering the fact that the evidence of PW2 is inspiring confidence in the mind of the court and no contra evidence is produced on behalf of the respondent. There cannot be any contributory negligence. Accordingly, the appeal is partly allowed by enhancing the compensation from 14,30,000 to 20,24,000, which the insurance company is liable to pay. Yes, all other conditions will follow. The enhanced amount shall carry 6% interest. Yes.
Cell number 25, Vijay Kumar T for appellant,
Obliged.
Janardhan Reddy.
Yes, take this.
Case of injury for enhancement.
Come to the table. What What are the injuries?
My lord, injuries are subchondric fracture right femur and fracture distal radius right forearm, my lord. In page para number 24, my lord.
Two fractures.
Two fractures, my lord.
60,000 is reasonable. Next.
My lord, the doctor assessed, my lord.
We'll go. Please come to the table.
Table, please.
Medical bills as it is, madam.
Medical expenses as it is.
Income was taken by the tribunal 25,000 rupees.
1 minute.
6 months.
It's food. How many? 50,000. How many days he was in hospital?
25 days, madam.
25 days.
Already enough amount.
Yes, madam. Amenities is a little.
My lord, the doctor assessed for.
I said, please look at the table. Look at the table at page number 43.
23.
Paragraph number 47 of the order.
What is? My lord, there are two claim petitions, my lord.
Which is this one? MBC?
MBC, my lord, 4149.
Page number, which page is?
23, my lord.
Paragraph number 36.
36, my lord. Parents of suffering 60,000 was awarded.
That is reasonably granted.
The doctor assessed, my lord, of 48% disability, my lord.
What we do is, we'll go step by step.
Please.
Pain and suffering, 60,000. Medical expenses, 2,52,000. Loss of income during laid up period. Any dispute in this?
No. My lord, prior to the accident, my lord, the offer letter was produced, my lord.
Yesterday.
Yes.
That's what I said. That's how it is adjourned. If you want it to be, if you want to examine anyone, we'll remind the matter.
If taking into consider, my lord, if taking into consideration, my lord, as per the appointment offer letter, my lord, 6,50,000 per annum, my lord.
Document is in a.
That's how it is adjourned, Mr. Counsel, yesterday.
Please.
If you want it that way, we will demand, or else I'll calculate it, like as per the income.
The nature of injury and fractures and disability, the compensation awarded under the head of pain and suffering is on lower side, my lord. 60,000 is on lower side.
How many days he was in hospital?
My lord, 25,000, 25 days, my lord.
Two fractures.
2 fractures.
40,000 plus 20,000, 60,000. Medical expenses, next loss of income, how much the court had considered? Income per month?
25,000 per annum.
25,000, 6 months laid up period was granted.
1,50,000 reasonable.
Amenities.
Future income. Future income also it will come if we don't increase.
Sorry.
Only amenities is lower side, Lordship.
Amenities only 25,000. Future medical, my lord, the doctor, my lord, doctor deposed that for removal of implants.
Loss of amenities, how much?
Loss of amenities.
What is the percentage?
48%.
18% is the whole body disability.
48% to the particular limb and whole body 18%.
Correct. 1/3 is.
So, how much has to be increased loss of amenities?
In addition, 50,000.
50,000 for 18%.
48 particular limb.
Yes, Mr. Anthony.
15,000.
That is 40,000.
40,000. Food and nourishment 30,000 because 25 days more than that.
Future medical expenses,
My lord, as
1,000 is
per,
reasonable.
my lord, as per doctor evidence, my lord, kindly see the
What did
evidence
he
of
say?
doctor, my lord.
What did he say?
My lord, a patient is advised to undergo 2 more operations for removal of implants from right femur and right radius, my lord.
How much it will cost according to him?
Estimated cost not produced, my lord.
So, future medical expenses, because 2 operations will grant another 10,000.
Please.
How many days he was in hospital? 25, 30,000 is granted.
Loss of amenities.
Loss of amenities is granted. Another total 40,000.
Please. Under the head of pain and suffering, another 20,000 kindly be awarded. My lord.
What do you say?
Resistance problem.
No, generally pain and suffering is awarded basing on the injury, how many fractures and all. So generally this is what is court awarding 60.
Please.
Fourteen lakh 85,000. From there it is coming to 15 lakh 20,000. Please come. Agreed with this award, MBC 419, agreed with award passed in MBC number 419 of 2017, dated 19th March 2020. The claimant is before this court. The claim petition is filed seeking compensation of 15 lakhs for the death, for the injuries sustained by the claimant. Which paragraph is that? As per the evidence of the doctor, he had sustained 2 fractures and he was in hospital for 25 days.
25 days.
25 days and incurred amount towards the treatment. It's evidence of the doctor that he had sustained 40% disability to the limb and 40% disability to the limb. Court had taken 18% as disability. When it comes to the income, where do you get that income according to the claimant? He has produced exhibit P14, online copy of appointment letter dated 31/20/25. That the claimant is offered the post of associate software engineer in IBM with annual salary of rupees 6,50,000. The claimant has not examined anybody in support of his case. Hence, the court had taken the income at 25,000 and granted the compensation as per the table given below. At paragraph number 36, you will get the table. The learned counsel appearing for the petitioner submits that on all the appellant submits that on all the heads, the compensation that is awarded by the tribunal is on the lower side. It is submitted that the court has failed to grant reasonable compensation. It is submitted that the court ought to have taken the income basing on the salary, basing on the offer letter, that is exhibit P14. Instead of that, court had taken 25,000. Even for the loss of amenities and pain and suffering, the amount that is granted is not a reasonable compensation. Next pair. Then counsel appearing for the respondent insurance company submits that in fact, the compensation that is awarded by the tribunal is on the higher side. And without examining anybody in support of exhibit P14, the claimant cannot seek expect the court, cannot ask the court to consider the income as per the said exhibit P14. It is submitted that the compensation and that there are no grounds to interfere. Next para. Having heard the counsels on either side, there is the material non-record. The claimant has sustained 2 fractures and the court has granted 60,000 under the head of pain and suffering. This court do not find any reasons to interfere. Even the medical expenses are also basing on the evidence. Then coming to the loss of income during the later period, as rightly observed by the court, the petitioner, the appellant had not examined anybody in respect of exhibit P14. Court had taken 25,000 as income and granted 1,50,000, considering 6 months loss of income under the head of loss of income during the later period. And even on this count also, there are no reasons to interfere. Coming to the loss of future income, the court had rightly considered and granted the amount. Coming to loss of amenities in life, considering the injuries and the disability, this court is granting 40,000. Future medical expenses, as the doctor opined that there are 2 surgeries to be performed. Hence, under the head of loss of future medical expenses, this court is granting an amount of rupees 60,000. Towards attendance, conveyance and other miscellaneous expenses, court had rightly granted 30,000. No grounds, there are no grounds to interfere. In the light of the law laid in Mekala versus so-and-so towards medical expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 15,20,000. Accordingly, the appeal is partly allowed by enhancement of compensation from 14,85,000 to 15,20,000. Yes, next.
Cell number 26, Vijay Kumar T.
Appellant my lord, rising out of same accident, different claim petition my lord. My lord, page number 24 of the judgment my lord, para 38, the injuries.
24
of the
38 of the judgment.
para 38 of the judgment. There are 2 fractures and 1 head injury my lord. In page 24 of the judgment. Fracture neck, right femur, head injury, fracture neck
This is at
of scapula
36
with
is,
fracture right near
para 36 is what just we have seen in the other case.
But 38, my lord.
38.
8.
38.
What amount?
No, I'm talking about the table. Where is the table?
Table my lord, page number 34. In page 34, para 48 my lord.
Yes.
Lord, there is 1 head injury my lord.
Let's see. Which paragraph number?
36 my lord.
No.
38.
38.
38. Fracture neck of right femur, head injury, fracture neck of scapula with fracture right
head injury
navicular.
with fracture of neck of scapula with fracture right navicular. Yes, what do you say? Will increase pain and suffering for by another 20,000.
Yes.
There inpatient for a period of 45 days my lord in this case.
Look at the table and then tell the court.
Please.
Medical expenses as it is.
Madam, my lord, in respect of medical bill
Expenses.
construction, my lord, I have produced the additional medical bill, my lord, along with
Here is the
document, my
When
lord.
is the IA filed?
My lord, on 22/7/2025, my lord.
Served a copy on them.
Please,
You
already
file your
served.
objections to that.
no, my lord. So 48,000 is there, my lord.
45,000 is there.
No problem. It can be taken.
Because subsequent to that, the same hospital he was admitted, my lord.
So,
Yes,
so that IA number, what is IA?
For additional.
IA number 1 of 25 is filed. Seeking production of the additional documents. That is the medical bills of an amount of rupees
45,000.
45,000. The IA shall be considered along with the main petition. That's a docket order. Then now medical expenses, that is
55,940.
55,940 plus
45,000.
9 lakhs 940.
1 minute. 8,55,940 plus 45,000. It comes to 9,940. Then how many days he was in hospital?
45 days.
Reasonable amount.
Plus.
Income was taken 41,300, my lordship.
Then loss of income, yes.
Yes.
How much was taken?
My lord, 56,000 something.
As income. He's working.
As earlier.
Last salary is
Not working, my lord.
41,300, my lordship.
As per the
Anyhow, then what is
salary certificate.
what enhancement he is asking in this?
No, my lord, I produced the certificate issued by the doctor along with additional document, my lord. It kindly see, my lord.
For what
The
purpose?
doctor has opinion that, my lord, may kindly read, my lord.
No, we are on the loss of income during the later
Please,
period.
my lord,
For that, what is the?
on account of disability, he cannot able to childbearing and childbearing, my lord.
No, all that will be
Difficulty.
considered by this court now. How can it be?
Kindly consider, my lord.
No,
Because
they
as
should-
per,
Support of that.
as per the offer, as per
Have
the
to examine the doctor, is it not?
no, my lord. As per appointment letter, my lord, per annum 6,50,000 was offered.
You are mixing two different issues. We are on the loss of income during the later period.
On account of disability also, my lord, the husband of the appellant has filed a divorce petition also, my lord.
No. Loss of income during the later period, how is it concerned with that? We have to
The
only
loss of
see about
future income.
I am on loss of income. That's why I'm asking you repeatedly to look at the table so that you will be able to assess the court properly.
Please,
So
please.
now we are on column number 4, loss of income during the later period. What is the enhancement here?
My lord, the tribunal, as per salary certificate rightly taken. My lord.
Taken, yes. So that is 2,47,800. Next column, loss of future income. Yes. What is your submission here?
And he said, my lord, on the ground of humanity, my lord, it may be considered because of the disability and fractures. Our husband has filed a MC petition seeking divorce, my lord.
Yes, not establish all those things before the tribunal, my lord. Only come up with this before this court only, my lord.
Good substantial amount is, what is the disability according to the
Disability
doctor?
48%, my lord.
To the limb.
To the limb. My lord.
How
Whole
much
body-
was taken?
Whole body 23 point, whole body
16, my lord.
16 taken. But as per the doctor evidence, my lord, 23.34% to the whole body, my lord.
So
Only is-
loss of future income, how much she got? 13 lakh? 48,032. This loss of amenities will increase
Yes, my lord.
another 50,000.
25.
Considering her
Yes, my lord.
25,000 is granted, we'll take 75,000. Future medical expenses. As it is.
Please.
It's coming to 27,61,772. Please come. This is MVC number
4150 of the 17 minutes.
agreed with orders passed in MVC number 4150 of 2017 dated 19th March 2020. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees
12 lakh. 12 lakh.
12 lakhs.
12 lakh.
12 lakhs for the injuries sustained by the double that it is already.
Tribunal also granted.
How they have filed a petition for enhancement here?
Lord, even though
No, at
even though
least you have
claiming
to
less
seek.
less compensation, my lord.
No. You have to seek amendment of court can grant excess amount. You want enhancement, either you should seek amendment of that prayer
My lord, in
or How can you file? Because you're already satisfied with what you have asked.
In valuation para only, I start the prayer, my lord.
What do you say? No, if somebody asks for 10 lakhs, court can grant 20,000, which is a reasonable compensation. But if he's seeking enhancement, against that, how can you?
The 26 before the tribunal, division bench, but he's asking for that difference of amount what the tribunal is granted, that future medical expenses, that one. But last occasion, I think this court only granted claim appeal was dismissed because the tribunal was the claimant was sought for some amount. Tribunal granted more than that compensation. So the honorable court dismissed the appeal, my lordship, on the same ground only.
Even
Because you ask for, no, that there is no, you ask for 12 lakhs, court feels just and reasonable, it can grant 30 lakhs, that is fine. But you cannot ask for enhancement now. And if it is the case, you should have asked for amendment of your claim petition.
Kindly see valuation para.
Valuation para in this
valuation para only, my lord. And
valuation, the total compensation claimed in the claim petition is 12. Tribunal awarded 26 lakhs. However, under the facts and circumstances, it is very strange.
In addition,
it is very strange how they have numbered and what is this valuation. You are not entitled. We can't do it.
Act and fair compensation kindly.
Fair compensation, you wanted 12 lakhs. Court grants 27 lakhs. How many times?
Considering the case.
More than double.
Out of which medical bill.
One thing, because how the appeal is maintainable is the question.
One submission. Refer the matter to Lok Adalat. We'll discuss and assist.
That's better. Because we can't pass such an order. Now I say the claim petition is filed seeking 12 lakhs. Court has granted 27 lakhs. He has filed an appeal. And court is now enhancing the compensation. You should be aggrieved by the order, isn't it? How are you aggrieved to prefer an appeal?
As per motor vehicle act, Malada, welfare legislature, Malada, and as per Supreme Court judgment, Malad, even though claiming less compensation.
That's what, absolutely no dispute. You claim less compensation, court will grant more compensation, which is just and reasonable. Now, when you say you are aggrieved by a particular award or a particular order, how you are aggrieved is the question. When court grants you already double the amount you are seeking, how are you aggrieved?
But
even for motor, because it is a beneficial legislation, we can't go by to everything.
Of the involved in the case, Malad, apparently, Malad.
Why did you ask for 12 lakhs? Yes, Mr. Ravi Samprati, what do you say?
You can seek the amendment of the.
That's what, without seeking amendment, without seeking amendment, you can't.
Can be done here.
And no, at this, no, he cannot seek amendment.
He can file an application for enhancing the claim amount.
It should be before the court, before the MACT, for the reason. Now, the court has granted, how can the 12 lakhs, he can ask 15 lakhs, 16 lakhs. Court grants 27 lakhs. What we do is, Mr. Counsel, the best part is we'll refer it to the Lok Adalat. That's where you can get the relief. Whatever that 1 lakh and all there, both the parties submits that the matter may be referred to the Lok Adalat. Places the district is directed to place it before the Lok Adalat. Yes. Which application? It is ordered. It will be considered, not ordered, it will be considered at the time of passing judgment. That's what I said. IA number, additional evidence can't be, there can't be any order on IA. Yes.
Malad, if that application is not allowed, then it will not consider in a Lok Adalat, Malad.
We'll just have some other
Because additional evidence, we cannot pass an order independently. any application that's filed under order 41 rule 27 will be considered during the course while passing the judgment.
Otherwise, I will file necessary application for seeking amendment. My lord.
That also can't be allowed at this stage. Let's go, first work out. He says
Otherwise, they
that
will
some.
not consider medical bill,
No, they
additional
will
medical
also
bills. My
see,
lord.
they will also see the medical bills. Yes,
Just for other rates, my lord.
yes,
Other judgment.
yes, next.
Cell number 27.
Amount I'll borrow.
Cell number 27.
That appears with the appellant.
Yes.
The claim is made by the insured against his insurer, claiming compensation while he was traveling in the vehicle which is insured with the appellant. It was contended that the claim petition is not maintainable before the Motor Accident Claims Tribunal. The insured cannot maintain a petition against his own insurer.
What is that? It is, because of his negligence accident.
No, it was not his negligence. He was traveling as an occupant in the vehicle. The insurance company contended that he cannot maintain a
Third
petition.
party insurance.
Yes. The tribunal, without discussing the defense which has been taken by the insurance company, blindly allows the petition and grants a compensation of rupees 80,700. That is under challenge. Well, even under personal accident coverage.
How much 1 lakh he'll get? Personal accident coverage.
Personal accident coverage 1 lakh only in case if it is 100% disablement, not otherwise. Here the doctor is not examined. The injuries are not.
No, personal accident coverage is 100% disability.
Yes.
Otherwise it is not granted.
The schedule attached to the policy is very clear that it covers only in the event of death or 100% disability, like loss of eyesight, like loss of limb.
What do you say?
It's a comprehensive policy.
What a comprehensive policy. It's a third party insurance. In case of you insure and the indemnity, whatever the bond is, to indemnify in case of a third party. Will allow? The agreed with the award passed in MBC number 1166 of 2018, dated 18 November 2021, whereby the tribunal had granted compensation of an amount of rupees 80,700. The insurance company is before this court. The claim petition is filed seeking compensation of an amount of rupees 8 lakhs for the injuries sustained by the claimant in the road traffic accident. The claimant and his wife were traveling in their car, and the driver of the car drove the vehicle in a rash and negligent manner and hit to the tractor. As a result, he has sustained injuries on his head and left eye. Now the claim petition is filed against the insurer of his own vehicle, and the insurance company had taken have filed their objections. Where are your grounds for that? You have not taken any such ground.
Not such ground is taken, but it has not been discussed in the judgment, my lord. And the evidence I have also.
Your response is discussed at paragraph number 4.
No, that has not been discussed in the judgment. That is not forthcoming in the judgment.
It is a case of the insurance company that the owner of the vehicle cannot file a claim petition against their own insurer, and the policy only covers the damages, the third party claims. That aspect was not considered by the tribunal, and tribunal had granted the compensation. Then counsel appearing for the respondent submits that it's a comprehensive policy and the insurance company is liable to pay the compensation. Next part, having heard the counsels on either side, there is a material on record. The owner of the vehicle has filed the claim petition against his own insurance company seeking compensation for the injuries sustained by him. While granting compensation, the It has to be governed by the terms and conditions of the policy. As per the policy is issued for the damages or any injury to the third party, but not to the owner of the vehicle. In those circumstances, the insurance company is not liable to pay the compensation. Even to claim the personal accident coverage also, this is not a case of 100% disability or loss of life, but only a case of injury. In that view of the matter, the appeal of the insurance company is allowed. The amount in deposit shall be forthwith. You will withdraw here or transfer to the bank?
No, we'll withdraw here on.
The insurance company is at liberty to withdraw the amount in deposit.
Apply.
Yes, next.
28. Renuka HR.
Here for Renuka, week's time may be granted. Ma'am. In this, Shivana Gowda is directed to appear on behalf of the insurance company with Oriental Insurance Company. He is not in the panel. Any other advocate may be directed.
Oriental Insurance Company.
Oriental.
Mr. A. Ravishankar is directed to take notice on behalf of the second respondent insurance company. Delete the name of Mr. B.C. Shivanagowda for taking steps. A week's time is granted. Default order.
Oblige.
Cell number 29. 29. Rangagowda NR.
Claimant's appeal challenging the 20% contributory negligence fixed against the
Only on the ground.
deceased. Then, my lord,
It's a case of death or injury.
please, death case.
Please come to that particular portion of the order.
My lord, paragraph 12 of the judgment, my lord, detailed discussion.
Please read.
My lord, exhibit P2 is the first information lodged on 23/10/2020 at about 7:30 p.m. stating that between 6:10 p.m. while deceased was crossing the road, the KSRTC bus bearing number so and so came in rash and negligent manner and dashed to the deceased and went away from the spot without stopping the bus. On that basis, exhibit P1 came to be registered against the driver of the KSRTC bus. The exhibit P4 is the inquest mahajar in which there are statements of witnesses which also clearly supports the narration of made in exhibit P2. In column number 7 of exhibit P4, there is mention about the cloths which are found on the head, found on the dead body of the deceased. And now here in the said column number, it is mentioned that there was a extra lungi available on the dead body of the deceased. But it is clearly mentioned that one white color lungi, cement color knicker, blue color checks shirt.
What do you say?
The trouble relied not on the exhibit P7 was the sketch. Internal page 13 of the judgment, almost in the middle of the internal page 13.
What is the amount awarded?
My lord, the amount awarded is 10,85,800.
We'll reduce it to 10%. We'll reduce it to 10%.
Yes.
My lord, the driver of the bus not examined before the tribunal.
You know that it's a
Charge sheet
highway.
Conductor has been.
The highway, there is no crossing. You have crossed the road.
Conductor is examined before the tribunal.
What he said?
My lord, I may read the cross-examination of
No, the fact is,
RW1.
you were crossing the road at a place which you are not supposed to cross. It's a highway.
Please.
That is sufficient. We'll take, we'll reduce it to 10%. Please come. Any other enhancement?
My lord, conventional, it's my lord, granted. Loss of consortium 2 lakhs, ex gratia may be granted.
No, how many are the claimants?
Claimants, my lord, one, two,
Wife, major sons and
Five,
married
five.
daughter and mother.
5.
five.
So it should be
2 lakh has been awarded.
5 into 44 is 2,20,000.
The 2 lakh has been
2
awarded
lakh
by the
is
tribunal.
granted.
Huh?
2 lakh
is
awarded by the
granted.
2
tribunal.
lakh is not.
Awarded.
That we can announce. Please come to the table. Where is it? No table.
No table, my lord.
In your appeal memo, there must be a table.
In synopsis, my lord,
Where do you get?
synopsis, loss of dependency 11,48,472. Loss of consortium 2 lakh.
Huh.
Transportation of the
So
dead body and
11,48,000, no dispute.
please,
Then consortium here 20,000 is added. Then transportation of dead body and funeral, here it is 36,000.
please,
Then again, loss of estate is given, when that is compensated.
please. That is
Corona, it is already, yes. Another 10,000 will add for the legal expenses.
please.
The agreed with the award passed in MVC number 4122/2020, date 20th December 2022, whereby the court had granted compensation of an amount of rupees 10,85,000 and fixed a contributed negligence at 20% on the deceased. The claimant is before this court. Then counsel appearing for the claimant submits that the tribunal ought not to have fixed the contributory negligence at 20% on the claimant, on the deceased. It is submitted that the respondent corporation has failed to examine the driver of the vehicle. And when there is no evidence with regard to the contributory negligence that is adduced on behalf of the claimant, on behalf of the respondent corporation, the court ought not to have imposed the contributory negligence at 20%. It is submitted that the court, without any basis, has held that there is 20% contributory negligence. Next parallel, and counsel appearing for the respondent corporation submits that court has examined the sketch, and when the deceased was crossing the road or crossing the highway, when there is no zebra crossing, and evening at 6 o'clock. In fact, the contributory negligence that is fixed for the court is on the lower side. It should have been 50% on the deceased. Next part. Having heard the counsels on either side, peruse the material on record. As rightly argued by the learned counsel for the appellant, the corporation has not examined the driver of the vehicle.
But conductor has been examined.
But examined the conductor.
RW1.
The evidence of the other witnesses show that there is a negligence on the part of the driver of the corporation. But however, the sketch reveals that the deceased was crossing the highway, and the court has held that there is contributory negligence of 20%. No doubt there is contributory negligence. However, this court is inclined to reduce the same to 10%. Accordingly, the contributory negligence that's fixed on the claimant is reduced from 20% to 10%. The compensation that is awarded is 10,85,000 and 10% comes to 1,08,500, and the amount that is payable by the insurance company
No, after deducting the interim compensation of rupees 25 lakh.
1,08,500. It comes to 9,76,500. They have paid the interim compensation of
25,000.
25.
That has been deducted by the tribunal.
It is deducted already.
After deduction, only 10,85,800.
It comes to 9,76,500, and in the light of the law later, make a loss so and so 10,000 towards the legal expenses. It comes to hence respondent corporation is liable to pay 9,86,500. Accordingly, No, where do you get that exact amount? That is not mentioned. From 10 lakh 85,000, they have not deducted 20%.
No, after 13 lakh 88,472 has been
Awarded
awarded.
amount, my lord,
13 lakh.
88,000.
Huh?
Awarded
13
amount,
lakh 88,472.
13 lakh,
13 lakh 88,472.
13 lakh 88,000.
472.
But then
After
why are you
deducting
not
the
saying-
20% contributory negligence, my lord, awarded
The
10
court
lakh
is-
85,800.
court is, deducting it from that, you're not
Please,
telling the
please.
court that, the compensation that is awarded is 13 lakh 88,000.
472.
472.
After deducting 20% contributed negligence,
It comes to my lord, 10 lakh 85,800.
8 lakh 472. 10 divided.
11 lakh 10,800. Then, my lord,
It comes to the 10% contributory negligence comes to 1 lakh 38,847. In this 25,000 is has to be deducted,
yes, ma'am.
and 25,000 is already paid by the, as interim compensation, which needs to be deducted.
Twenty-five thousand already deducted, my lord.
Ali, total amount of deductment.
Trial, in trial courts
From
award.
13 lakh 88,472.
Please.
It is already deducted.
Already
No, no,
deducted.
Out of my 11 lakh 10,800, then deducted by 25,000, then 10 lakh 85,800 has been awarded.
13 lakh 88,472 minus 1 lakh 38,847 minus 25,000. It comes to 12 lakh 24,625. And 10,000 legal expenses. It comes to 12 lakh 34,625. According, same is partly allowed. Yes.
Serial number 30, 31 adjourned, 32. Serial number 32.
We will take a chance before the
Certainly.
claim before Lokada.
Lok Adalat.
Tomorrow, day after
It is
tomorrow.
The registry director places matter before the Lok Adalat. There is a likelihood of settlement. Yes.
Serial number list number 2, parted matter, serial number 1. Banu Prakash Vijay, S. Raj Prabhu.
No representation on behalf of either of the parties. List this matter on 15th of October. Yes.
Serial number 2 for dismissal.
For the petition, blood. Last occasion, we given a proposal to the other side, blood. Yesterday, they told that they are not agree for the amount what we offered 50 lakhs for one time, as a one time.
50
settlement.
lakhs.
50.
What they want?
They want 1 crore. She is earning. I have one son, Minna.
This is arising out of what?
Out of the application filed by her under section 24. Maintenance application. This is the husband's petition.
You want to give 50,000 as permanent element.
50,000 was granted by the trial court, Minna.
I mean, not 50,000, 50 lakhs as a permanent element.
Permanent alimony. We offered that thing. And we are ready for giving the divorce.
Inform, we'll take it up 230.
No, they told yesterday that they are not interested to.
That's
for
why
that
at least then the matter has to be heard on the merits of it. It is only writ petition arising out of IA.
One date may be fixed for the hearing, Lord.
One date for the,
Today they
to
are not.
understand the course difficulty also. 22nd September, no representation for the respondent. Delete from dismissal. Yes.
Serial number 3. Master CR.
On 21/3, This matter has come up before the court on 21/3/2025. On the day, there is no representation on behalf of the petitioner. Again, on 26/2025, there is no representation. Then the matter came up on 31/7. Again, on the day, there is no representation on behalf of the petitioner. Hence, the matter is directed to be listed under the caption for dismissal. Today also, there is no representation. It appears that the petitioner is not interested to prosecute the matter. Dismissed for non-prosecute. Dismissed for non-prosecution. Yes.
Fourth, Deepak Shree for the appellant.
Respondent, my lord. My lord, till now, the amount is pending. What is the amount ordered by the lower family court? They have not paid even single NP, my
What
lord.
is the impugned order? I mean, the interim order by this court.
There is-
Your Lordship, that challenging the annexure A that's passed on 3/8/22, the impugned order by the trial court for the medical expenses on the basis only on the memo filed by the respondents annexure F and G, only on the basis of the memo and the estimate list issued by the Shashi Nursing Home. Kindly, I'd like to bring to your notice for me what they have given. This is to certify that Srimati Sundarama aid about
Is the impugned
52.
order passed?
That is to
My lord,
pay
and-
90,000 lump sum expenses.
I said,
And
which is
per
the
month-
date of order?
3/8/22.
Per month, 5,000, my lord.
From 3/8/2024,
22, my lord.
22 is from.
22, writ petition is filed in 24.
Yeah.
Yes,
That is
sir.
the order, my lord. Lower court order, family court order.
I think
Third,
one of
8,
you
20
answered my question. I think it's easy for me to understand. Impugned order dated what?
3/8/2022.
22.
3/8/2022 order is questioned before this court in 2024.
Yes.
Yes, my lord.
Yes, when I appeared in the previous, I explained to the court that I was lack of knowledge about that. Just it was orders passing on, because in the e-court status we don't get the detail of this family court. So I was due to my lack of
So,
knowledge.
an order that is passed in the year 2022 is questioned in the year 2024. No interim order by this court, but the order of the court from 2022 till 2025 is not complied with.
No,
In
ma'am.
spite of no stay being granted by this, no, though there is no stay by this court. Why should we hear this matter now?
And my lord, the
Please wait, please wait. Yes. Why should we hear this matter? When you do not have any respect to the orders of the court.
It's not the orders for me. It was just going on orders. Since finally it
Whatever
came
it
to
is,
the arguments.
22 order is passed, 24 you have come before this court. You have not sought for any stay. No stay is granted by this court, and still you have not complied. So who will answer to the delay of 22 till 2025? Why should the orders be passed? Why there is no complaints of the orders? There is no sanctity to the order of the
I'll
court
apologize the court.
from 22 to 25. Will not, I will dismiss this writ petition on the ground that an order that is passed in the year 2022 till 2025 is not complied with. You have no respect
I'll file the
to the orders of the
applications.
court.
I'll file it the condonation of delay applications.
No condonation of delay. It is not about condonation of delay. We'll dismiss it on that ground. Where is the impugned order? Page number of the impugned order?
my lord, page number 9, order dated 14, my lord.
Yes.
Page number 14.
The present writ petition is filed, agreed with orders passed in I number 5 in criminal miscellaneous number 595 of 2014, dated 3rd August 2022, whereby the court had directed the husband to pay 5,000 per month from the date of application till the disposal of the petition, and also directed to pay rupees 90,000 in lump sum towards the medical expenses. That order dated 3rd August 2022 is questioned before this court in the year 2024, that is 7/2/2024, almost after, nearly after 2 years. The Like counsel appearing for the petitioner submits that petitioner husband that they have not realized that such an order is passed. And once they realize that the order is passed, they have come up before this court by filing the writ petition. The court, the family court, has done the exercise and passed an order on 3rd August 2022. And this criminal miscellaneous is of the year 2014. When an order is passed by the court, either the party has to comply with it, or they should file an appeal within the appeal/revision within a reasonable time. And they should make the efforts to get an order from the appellate revisional court seeking stay of the impugned order. In this case, the petition is filed after 2 years from the day, nearly after 2 years from the date of order, and the matter came up before the court for the first time on 15/4/2024. On the day, as per the order, it discloses that there is no representation on behalf of the petitioner post this matter after ensuing summer vacation. Then it came up on 23/9/2024. On the day, this court has directed to issue notice to the respondent and directed the matter to be posted after the Dasara vacation. Then on 26/2025, when the matter came up, even on that day also, there is no representation on either side. So the court observed that to give a fair opportunity, list the matter on 31/7/2025. Then the matter came up on 31/7/2025. Again on the day, the order sheet reveals that the court observed that the learned counsel for the respondent is present. There is no representation on behalf of the petitioner. Hence, the matter was directed to be listed for dismissal today, for dismissal on 28/2025. Accordingly, the matter is listed under the caption for dismissal today. All the conduct from the year 2022 till 2025 shows that the petitioner has no intention to prosecute the matter, and the petitioner has not complied with an order that is passed in the year 2022, and he has never made any efforts to press for the IA seeking stay of the order impugned. In these circumstances, this court do not want to go into the merits of the matter, and this matter do not require any consideration in the hands of the court where the litigant is not vigilant, and also there are no bona fides in filing this petition after 2 years. Accordingly, dismissed.
Cell number 5,
Great way.
Somshekaraya RP, 5.
4, serial number 4.
Cell number 5,
Serial number 4, adjournment, I think, is asked. Is 4 is what is happened now?
So they have not, last time, few occasions they did not appear. They have not also paid,
number 24, sir.
list number 24 is.
Then why is it? In which case they have appeared? List number 2, now that lady advocate, how do you like the
ಅಲ್ಲ
lesson?
ಬೇರೆ ಕೇಸ್ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ನಮ್ದು 3 ತೋರಿಸ್ತಾ ಇತ್ತು 4
3 is DNP.
4 WP 5884 of 24. 5884 of 24.
That is 3.
3, sir.
That is 3. Your matter is 3, not 4.
But somebody has appeared. So I am for the response.
What appeared now is 4. What is over now is 4. Yours is 3. What happened to 3?
DNP. Dismissed.
None for response.
Yes, 5.
Cell number 5, Somshekaraya RP.
Give the order sheet. On 2012-2024, order dated 2012-2024 disclose, it is observed that the petitioner undertakes to pay entire areas of maintenance within a period of 4 weeks and is in undertaking this placed on record, and that notice was issued to the respondents. On 23/7, as there was no representation on behalf of the petitioner, this matter was directed to be listed for dismissal on 28/2025. Same, dismissed for non-prosecution.
For orders matters, serial number 6.
Yes.
Number 6, Interim for dismissal.
This is a writ petition of 2023. When the matter came up on 1/8/2025, this court has directed the petitioner to file the translated copy of the order and directed the matter to be listed on 28/2025. By that time, if the translated copy is not filed, the writ petition shall dismissed without further reference to the court. Today, there is no representation on behalf of the petitioner, and the translated copy is also not filed. List this matter tomorrow for dismissal.
Serial number 7. Serial number 7, Zamir Pasha.
Please.
My lords, a small submission. We have given NOC in WP 19557, but still the name has been reflecting, my lords. Respondent.
If you have given no objection, then you have to file a memo. If you file a memo, then it will be, just because you have given no objection, court will matter, your name will not be deleted.
Okay, my lords.
Yes.
Lord, these are the husband's petitions. Lord, the first petition, WP 24314, is, my Lord, arising out of the proceedings pertaining to the dissolution of marriage. Dissolution of marriage. Lord, since 2019, the proceedings are pending. And Lord, very often the respondent wife, Lord, changes the counsels. And since 2 years, more than 2 years, Lord, they have not conducted cross-examination.
In 7, for the petitioner, for the respondent, one advocate is appearing. In 7.2, some other, there is no advocate in 7.2.
7.2, Lord.
Sujita. In 7.2, another advocate is appearing. And in 7.1, the advocate who is appearing, learned counsel submits that they've given up wakalat. Learned counsel for the petitioner submits that the respondent is repeatedly changing the advocates and the matter is kept pending for more than 2 years. No representation on behalf of the advocates representing the counsel for the representing the respondent. List this matter on 2nd of September. On that day, even if there is no representation on behalf of the respondent, the matter will be heard and orders will be passed.
Lord, there is an interim order in one.
Look at it wherever interim order is there, extend.
Great.
Serial number 8, party in person, Devrata for dismissal. Withdrawal.
The petition is filed. A memo is filed seeking to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes, next.
Serial number 9.
Lord, I appear for the petitioner. 1 week time may be granted to rectify office objections.
Appearing for the respondent wife in this case.
Yes.
My lords, I'll be filing the wakalat in the office.
So and so submits that he has instructions to file wakalat.
My lords, in this case, in 18/4/25, Earlier on 7/7 in another writ petition 19/3/382/25, it was ordered to be connected with this matter. So this both needs to be got connected.
Take that number.
Connection number.
So and so has
19382.
instructions to file wakalat. List this matter along with so and so.
My lords, a small submission. In this case, the translation in page number 25 of this petition, it seems to that they have done more translation than what is required. They may have
See
to,
when the matter comes on the day.
yes, this matter also may be referred to mediation if they are willing to do it, because this is a custody matter. They are seeking interim custody. Visitation right is there.
Let it be posted at the next earliest opportunity. We'll decide. We'll have to reconcile with the parties first.
Nine,
Have to seek
this is a matter
representation.
on 9 September. Yes, next,
Cell number 10.
along with so and so.
Details. Cell number 10, G. Ravishankar Shastri.
For as the hand summons is concerned, my lord, it was filed yesterday, my lord.
What is the name of the advocate?
Sridhar, my lord.
As per the order passed by this court, the petition has taken out hand summons and filed a memo to that effect. Where is the memo?
It was filed yesterday, my lord. Our difficulty was, my lord, 1/8, my lord, was pleased to pass interim order. Hand summons were given to us on 13/8, my lord. 14th,
Why that much delay is happening?
it seems there is a workload, my lord, in the office. We have went several times, my lord, and persuaded, but still we have served, my lord, on 19th, and acknowledgement was filed on that date yesterday.
Let the district director put up the memo.
Please.
Yes, let this matter on Saturday. Yes, 11.
Cell number 11. Harish Yanna.
What are the objections?
The objection is, my lord, one objection is with regard to mentioning of IA number. IA number is not given before the trial court. Second objection is, my lord, to production of amended petition. Amended petition itself is not filed.
What is the impugned order?
Impugned order is attachment order is passed, my lord. Page number 64, my kindly say, my lord. 64. The petitioners are the legally wedded wife, 3 minor children, and mother of the deceased K. Sadashiva. My lord, the respondent is the, my lord, claims to be the son of the first wife. My lord, divorce decree was granted. We are not arrayed as a party to the proceedings, my lord.
17/6/2005 is the impugned order.
Please, my lord.
Come to your prayer.
The prayer is, my lord, to set aside the order dated 17/6/2025. Annexer K. Same order I am challenging before the honorable
Then
court.
what is this objection that you have a remedy before the?
Please, my lord, my lord, objection is with regard to maintainability of writ petition. They are saying, my lord, I have to approach this same court by filing separate application or recall that order. That is the objection they have raised, my lord. How this writ petition is maintainable when they are entitled to file application before the
You are
same
not a
court.
party to this.
No, my lord.
And then
I am not arrayed as a party to the proceedings. After death of my husband and my father, my lord, we are not arrayed as a party, and behind the back as, my lord, they have impugned order is passed, my lord. Therefore, principle of natural justice is violated.
No, I'm not able to understand this. Please come to the cause title.
First of writ petition, my lord.
Not the writ petition of this, the proceedings before the court, criminal miscellaneous
Annexer B,
cause title.
Annexer B kindly missing. Annexer B, page number 33 is the cast title. But the respondent is the father of the petitioner number 123.
Master Manish is the petitioner.
Is claims to be the son of the first wife of late Sadashiva, the respondent therein. We are the.
Who are you?
I am the my lord, 3 minor children after decree of divorce to the mother of the petitioner therein. My lord, petitioner number 4 is married to the respondent.
Don't confuse yourself and confuse the court. Come to page 33.
Please, ma'am.
Okay. Mr. Sadasiva, what is the relation of Mr. Sadasiva to you?
Petitioner number 1 to 3 are the children of Sadashiva. Petitioner number 4 is the wife of the Sadashiva. Petitioner number 5 is the mother of.
Is he no more?
Is no more. During
he
the
died?
pendency of these proceedings.
When he died?
He died on 17/4/2025. He died. After the death, death was reported before the family court. Even after reporting the death, there is already sufficient material to show that we are also LRs of the deceased.
my lord, behind the back, this page number 64 order is passed, attaching the death benefits, my lord. Even there is no notice issued to us, my lord. Without issuing notice and without providing opportunity, my lord, order was. Even, my lord, my husband filed objection to this petition, wherein he has admitted.
Your petition seeking impediment,
Impediment application not filed, my lord.
then?
After this notice, coming to the notice of this order, my lord, we challenged it before this honorable. Moreover, my lord, this late Sadashiva filed RPFC before this honorable court. But after his death, this RPFC also came to be dismissed for non-prosecution. He has deposited sufficient of maintenance amount as per the order of this honorable court. He has deposited, that was admitted before even before the my lord, executing court. He has deposited sufficient. Even in spite of that, my lord, we have, my lord, 3 minor children, mother and wife.
No, as rightly observed by the, as rightly taken, objection taken by the registry, why you cannot move the court?
My lord, principle of natural justice is violated.
Family court, what justice this court will give, the same justice family court will also give.
My lord, what urgency is, my lord, page number 64, attachment is order is passed.
Ordered, you are not a party.
I'm not order is passed.
So
Even
can't you file an application before the court seeking to plead yourself in the petition that as he is, no, how can they pass an order against this dead person?
my lord, death person order, that was the, my lord, that is.
That's what I'm saying. You should implead yourself in the case.
My lord, even
Instead of
please.
these many litigations, one before the high court, one before the family court, why can't you go before the family court?
Prior to that, my lord, one page number 63, there is also observation that, my lord, we are the LRs of the, kindly see page number 63, third paragraph, my lord. The minor petitioner represented to the guardian has filed the petition under section 144(3) of BNSS for recovery of arrears of maintenance. The respondent in this objection dated 14/3/2025 has admitted he has married to Gayatri, that is petition number 4 here in Malad, on 26/4/2007, and out of wedlock he is having 3 female children. Therefore, there is every possibility of second wife and children of the deceased are likely to claim entire death benefits. This is the there is a clear notice of the family court that we are also necessary parties. In spite of that, impugned at this past, attaching entire death benefits. We are 3 minor children, mother, wife are there.
I understand the merits of the matter. I'm asking you, why not before the family court? Why before the high court?
Well, please, in spite of having knowledge, the family court passed the act.
Can you are not on record.
I'm not heard, my lord, before the trial.
You should file an application. You should impede yourself that he is no more, that we are the children, they have nothing to do. That's something you should say. No, you can do it unnecessarily without coming to know. Court has issued notice to them. They have to come to the high court again. All of you have to be sent to the family court.
Please, my lord. Even there is no notice now. Even now and also, my lord, they are acting efforts to, my lord, withdraw the amount. That is my grievance.
The order is passed on 17/6/2025. By this time, you could have filed an application. You could have got an order from the court.
They are making active efforts, my lord, to withdraw the amount.
From 2 months, nothing has happened.
I filed a petition on 28/7/2025, and my lord, therefore there is urgency in this matter, my lord.
Maintainability, the issue that is raised by them is correct.
But my lord, there is urgency somewhere. They are pursuing.
Not urgent. For urgency, there will not be. You can't come to the high court for the sake of urgency. Trial court will also understand your urgency. The office objection with regard to the maintainability is sustained.
My lord, may I request, my lord, since, my lord, liberty may be given to, my lord, approach this.
And the petition is at liberty to approach the family court and file an appropriate application.
If this honorable court grant, my lord, some interim not to release the amount, that is all my prayer.
That is your purpose is served. That's why you have come here.
Interim protection. I'm not claiming withdraw of amount, my lord. Only protection not to release the amount.
How can I pass such an order without notice to the respondent? If I'm interfering with the order, there should be notice to them. No, not only your principles of natural justice applies to you, to them also.
Please, ma'am. Only my request is, ma'am, till my applications consider, let them not to disperse the amount. In that event, I will be, my lord,
If I'm entertaining this petition, such an order would be passed, not now. And the matter is kept pending. Yes, next. The application that is filed by any application that is filed by the petitioner shall be considered by the court expeditiously.
Disposed.
Yes, disposed.
Hearing on interlocutory application, cell number 12, Geeta Devi MP. Correction of the order. N. Gautam Raghunath.
My lords, insofar as IA number 1/25, I'm not pressing on it because it's become infructuous. The only point that your lordships in fact had directed the petitioner to inquire was the timings that I sought for to be changed. That was, it's 11 to 4. All that I'm asking is 1 to 7. At least if that could be to that extent until such time that the family court decides on my application. My lords, that is the only.
Lords, they're speaking from 1 to 7 p.m. My lord. Your lordship's order is 11 to 4 p.m. Now, my lord, the child comes at around 12:30. Again, he lunches at 12:30, my lord, and he sleeps at 7 p.m., 8 p.m. Now they're seeking from 1 p.m. to 7 p.m., my lord. And your lordship's order is very clear at operative portion of 9. Any modification to the with regards to visitation, my lord, father can seek in before the trial court, and he's already filed an application before the trial court for the same relief, 2 applications, as well as here and as well as before
My
the
lords,
family court. My lord.
the trial court application is completely different. I've sought for other reliefs
When the
as well.
court gives you a liberty, you should do it. Why for everything
My
High
lords,
Court?
this application was filed much prior to the expiry of 3
Come to the
months.
order. Please come to the order. What did the court say? Why should you
Court-
move this court?
Court put me
For
on.
any modification you require, when there is a liberty to
My
you to
lords,
approach
my
the
lords,
court.
that was granted. The visitation rights that were decided by this honorable court was for a period of 3 months. Your lordship in fact granted liberty to me. If you want to seek renewal or any change in the visitation rights, that would be after 3 months. This application was filed much prior to that.
So you
Timings is the only.
Every case we can't do this exercise.
But at least until such time that
IA
the
number-
problem is
IA
since this
number
honorable-
1 of 25. 1 of 25, it is submitted that the petition, the respondent is not pressing for the
Become infructuous.
said application, and the same is dismissed as infructuous. IA 1 of 24 is filed seeking correction of the order. This court has passed the order on on 4th of September 2024, and at this point of time, this court is not inclined to is not going to pass any order, as the court has already given liberty to the parties to approach the family court seeking any modification of the order. If the petitioner, if the respondent wants any modification, they are at liberty to approach the family court. Yes.
Please, my lords, let this order not come in the way of the family court, my lords, because what happens tomorrow is
I
there they
said,
go and say that this your lordship has not entertained. Therefore, that application should not. Please let this not come in the way of family
I
court.
said, I have
Please.
given a liberty to you to
Please.
go. That's why you're going.
Please.
Yes, next.
Cell number 13. Disposed of. Cell number 13,
Yes.
Gautam Raghunath.
My lords, on the last date, my lords directed us to take both the children. We have taken the again younger child stayed till 8 o'clock and then he came back. And the next date we compensated. Elder one stayed back. That has happened on the last date of hearing. And the younger one gets little anxiety, like when it comes to after 8 o'clock, he gets that anxiety thing, and then he's sent back to the father's house.
My lords, I'm really not able to understand the fact as to the younger one who was coming all these days, who would come to the mother, in fact expressed before your lordships that he wants to be with the mother. My lords, all of a sudden now
Not
we
go
are
into
happy
that,
that the elder
Mr.
one is
Varma.
coming.
We'll not go into that. Now, the elder one,
He's
who
coming.
is but why are you not asking that? The elder one who is reluctant, why is he
Yes.
coming?
That is what my lords is.
So for the children, for their behavior, for everything, we can't give an answer.
So I'm not stating that, my lords. Let this continue.
So
my
let it
lords.
continue for some time.
Let this
My
continue
lords,
for another period.
no
The
difficulty.
reason is, my lords, slowly,
My lords,
gradually he'll come.
Yes.
I have no difficulty. I can do it for another week and see how it goes.
That's
and
what,
we'll-
let
yes,
it continue,
Yes,
however it is comfortable.
yes.
Let the children keep on doing it.
Yes, my
Anyhow,
lords.
they're like, the elder one is staying from.
Please, we are very happy about
So, younger one, last time he went little early
Yeah.
than 8 o'clock.
Yeah.
Now he stayed back till 8 o'clock. Next time he
I'm
might
hoping
stay
for the
back
same
the whole
lords.
night. So let it go on.
Yes, my
We'll
lords.
have it after 2 months.
My lords, not 2 months. May kindly have it in the first week of September.
Please.
We'll see till then how it goes.
This court has already made arrangement by order dated 11/8/2025. And the matter came up today, the council submit that, both the council submits that the elder one stayed back with the father, had stayed back with the mother, and the younger one, he left, as he insisted, he left the mother by 8 o'clock, and the same was compensated on the next day. The, considering how the visitation is going on, as per the order dated 11/8/2025, the same arrangement shall go on the weekends till
3rd of September, my lord, 1st or 3rd.
Third,
this
I'm having it.
arrangement shall go
First.
on
Please.
till, no, he's having Saturdays, it's
That
going
is-
on Saturdays,
Yes, my lord, 22nd, 23rd and 30th.
23rd and 30th.
Yes, my lord.
We'll have it on 9th September,
Please,
23rd, 30th, 6th.
please.
Look at the earlier order, same date, same arrangement. List the matter on 9th of September.
Gratefully.
My lords, there's one request from the father. He wants to take the children out during the holidays.
Holidays.
This Dasra holidays.
Dasra will come later.
Yes, my lords. What he wants is that if passports can be given, the children's passport for the purpose of in case they are going
I'll
somewhere.
inquire, my lords. I'll have to just.
That will be because
Yes,
he's
my
a
lord.
resident of Bangalore, not that he will take away the children and
Yes,
go.
my lords.
Problem that is here is he'll also have to come with because the passports have been lost and an FIR has been filed. If they need a duplicate passport, the father should also come. That
The
only problem.
passport
I had
is
in fact
lost.
inquired
I
about-
didn't even know, my lords,
So
first
that's
time.
what, an FIR has been
First
filed.
time.
Then counsel for the respondent father submitted, the father wants to take the children out of country and he requires of passports. And counsel appearing for the mother submits that they've given a complaint that the passports are lost.
Even her passport is lost. That is all the thing.
Her mother's and the children's passports are lost, and to have the duplicate, even the father's presence is required. Accordingly, the parties shall coordinate and
Yes.
and see
Let
that
them
they
coordinate.
obtain the duplicate passport. Yes. Yes, next.
Bill number 14, preliminary hearing. Firoz Nizam. 14.
No representation for dismissal on 15th of October. Yes, next.
Chair number 15. Sharat Gowda GB.
15.1, I appear for the petitioner, my lords. I will request time till Friday, my lords.
Well,
Only
as
that's
last
it.
date of hearing, they filed the.
Affidavit of assets and liabilities is filed by the husband, my
Why do you
lords.
require adjournment
But
every
senior
time?
wants to appear in the matter, my lords. He's held up at Dharwad bench, my lords.
My lords, one
Till
submission-
Friday, I am requesting time, my lords.
One submission, my lords. While filing their assets and liabilities, my lords, they did not file their IT returns.
If they don't file, they will pay for it.
No, if
They
I'm
haven't
having
filed,
no
only
income, there is no
bank
question of
transaction
filing.
has been
I'm not
filed.
employed now, my lords.
Whatever it is, we'll consider it.
Please, my lords.
At the request of the counsel, the respondent, your respondent husband.
Husband,
or wife?
husband, please.
Respondent husband, list this matter on 11th of September.
Please, my lords. Great.
Chair number 16, Chetan B.
Apparent. My lordship, today, yeah, day after tomorrow, my lordship.
Why
Today-
day after tomorrow?
Today.
Note, not, in a 24 matter, till now, notice is not ordered.
Please.
And you ask for time. How reasonable it is? Let's see the impugned order. Is it a matter to be, respondent is hereby ordered and directed to pay 8,000 per month to the petitioner as interim maintenance from the date of the application till the disposal of the case. Pay rupees 20,000 towards one-time litigation expenses. The petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect by 2nd of September. If the memo is not filed, the writ petition shall stand dismissed without further reference to the court. A 17.
Bill number 17, MD Raghunath.
I appear for the petitioner, my lords. As my lord's order, I have served the counsel of the respondent as well as the respondent, my lords.
Where is the memo?
There's no memo, my lords, but the acknowledgement of serving it to them has been filed before the registry. If I may bring to my lord's attention, this was dated 6/8/2020.
Passed by this court. The petitioner, it is submitted that the petitioner had served the notice on the counsel appearing for the respondent before the trial court,
As well as the respondent, my lords.
as well as the respondent, and the advocate's name is K. Tejas.
Yes, my lords.
In the name of Mr. K. Tejas, this is matter on 3rd of September.
May I seek for an interim
18.
order, my lords?
Huh?
May I seek for an interim order, my lords? It's an interim custody that I'm seeking
No,
for.
no, first of all, the name, what is the purpose of giving, yes, next 18?
Madhukar.
I understand.
Yes,
Madhukar
18.
MP, 18.
Seek for a passover, my lords, the argument concerning the end of. Maybe
Passover, yes, 19.
Serial number 19. Gangadharaya, AN.
For the petitioner, please. An order passed on section 24, my lords.
Hmm.
Literally, it was an ex parte order, my lords. Though I intended engage the council at Mysore, they kept me in dark. Unfortunately, an order was passed ex parte. Early grounds that I was earning a package of 15 lakhs per month, per year.
How
As
much
a
you're
ma-
earning?
Lords, my salary is 18,000 rupees per month.
No, why have you not filed your statement of assets and liabilities?
Objections was filed, my lord. He happened to be a resident of Bangalore, my lord.
No, this MC is filed
In
in the year
Mysore.
2024.
Yes,
When is the
madam.
IA filed?
IA
IA
filed,
is also filed that time. When did
Yes.
you enter appearance?
IA filed on 18th of August, my lord.
Yes, 18th August.
1st August 24 was the IA filed, my lord.
When did you file your wakalat?
My wakalat was filed after service of summons, I think,
Then,
Yes,
once you have filed the IA, and when you are supposed to file the statement of assets and liabilities, why you did not file?
Lord's council there, you have not informed the party, my party there in my lords, and grounds.
These kind of allegations on the advocates
No,
will
no,
not do.
I'm not making the allegation, my lord. It's a genuine cause. He is working with some in a Mofussil area of Bangalore, my lords, and he is drawing a salary of rupees 18,337. I produced the salary certificate also, my lords.
80,000 or 18,000?
18,000. It is not that he is.
It is submitted that the court had granted 20,000 as maintenance and the income of the petitioner is 18,000 and all. It is submitted that in view of the communication gap between the petitioner and the advocate, he could not file a statement of assets and liabilities, and court had granted 20,000 as maintenance. Considering the submission, there shall be stay of all further proceedings on the condition that he shall pay an amount of rupees 9,000 by 5th of every succeeding month, and arrears also at 9,000. Next, hand summons shall file a memo to that effect by 3rd, or else the petition shall stand dismissed. List this matter on 25th. Yes,
25th, my lords.
of September.
September.
But memo has to be filed. What is the date I said?
39.
39.
39.
Obliged, my lords.
Yes.
Serial number 20, adjourned 21. Varun Jaykumar Patil.
Yes.
Petitioner filed proceedings under section 25 of the Guardians and Wards Act, your lordships, along with an application for visitation, IA number 3. Lordships, may kindly take page number 26 onwards, annexure C. That is the order sheet. It was first taken up on 22/8. Notice was issued, and the respondent did not appear.
When is the JNWC filed?
Your lordships,
JNWC is filed
28/2024.
28/2024.
On 10/1/2025, my application was heard.
No. When is the IA filed?
IA was filed along with the petition. On 10/1/2025, my IA was heard, your lordships. Lordships, may kindly take page number 29.
Which court is this?
This is Chandraipatna, your lordships. Principal District and Sessions Judge, Chandraipatna. The matter was posted for orders on 15th. And again on 21st, it was posted for orders. Then they say that no, it is posted for petitioner evidence.
What is the set aside the order dated 21/1/2025?
21/5, what the court does is it posts the matter for petitioner evidence instead of passing orders on the IA number 3.
So instead of going into all this, we'll direct the court to pass orders on IA number?
Consider my application as expeditiously.
IA number?
3, your lordships.
Then the present petition is filed, seeking the following prayer. When counsel for the petitioner submits that the GNWC is filed in the year 2020 on 28/2024, and along with the GNWC petition, they have also filed an IA seeking visitation. And he has placed before the court the proceeding sheet, which shows that how many times the matter is adjourned. And the court till now has not considered the application for visitation. Next para. This court repeatedly passing orders on the judicial side, also on the administrative side, directing the courts to pass orders on the visitation maintenance within 1 month from the date of the receipt, from the date of the appearance of the other side. In spite of that, it appears that the courts are not passing orders as per the timeline fixed by this court. When the IA is filed in the year 28/2024, even after 1 year, why the application, that's IA number 3, is not considered, this court is not able to understand. Hence, this court deems it appropriate to dispose of the writ petition. This court is not issuing notice to the respondent, as this court is not passing any adverse orders, and disposal of the petition is in the interest of both the parties. Accordingly, the court is passing the following order. The trial, the so-and-so, the senior civil judge and JMFC Chandrai Patna, Hassan, shall dispose of the pending IA number 3 of 2025 within a period of 3 weeks from the date of receipt of the copy of the order. See, notice to the respondent again in the operative portion also.
Well, hearing B group, serial number 22, Jai Simha KP. For petitioner.
For withdrawal.
For petitioner, my lord.
Your Honor,
Withdrawal.
in this case, pendentality was there. Pendentality application was there. It was challenged, and maintenance was reduced to 4,000 rupees from the 10,000 rupees. And now the case is disposed of. I want it to be enhanced, Your Honor, not the 4,000 rupees. Mother and daughter is there.
When an interim order is passed and you are not you have not filed the petition.
I have, no, he has filed the petition. I have filed my objection.
They want to withdraw the writ petition
I
and
have-
you want it to be enhanced. How can it be?
No, it was 10,000 rupees was granted, and it was reduced by this honorable court
Correct.
by
No, what will
4,000
happen
rupees.
once he withdraw the petition, the order that was there. Now
10,000
because the interim order will merge with the main order, MC. So question of deciding that will not arise.
10,000 rupees will be, it will be granted, okay. Because now the child
memo is filed seeking to withdraw the petition as MC number 3102 of 2018 is disposed of on 14/7/2025. Hence, the memo is taken on record.
One, I
and the
would like
petition
to
is dismissed
clarify
as
your,
withdrawn.
4,000 rupees was the interim maintenance granted by this one and reduced 10,000 to 4,000 rupees. So now the 10,000 rupees will be there. Is it right?
Okay, why should the court clarify all this?
No,
When he is
just-
withdrawing the writ petition, along with that, whatever the interim orders, all will go.
Please.
So nothing to be clarified in this.
Please.
Yes.
Please.
Mahesha
Much
V.
obliged.
For petitioner, B.
Yes.
Purandara.
24 application was challenged, madam, to this court. Section 24 application filed by the wife, my lord. She filed a petition for a decree of divorce before the trial court, my lord. In the year
What
2000,
is the amount that is granted?
amount, my lord, 8,000 being awarded, my lord.
Hmm.
And this honorable court has stayed, subject to pay 5,000 rupees per month, my lord. That was paying, my lord,
Now
regularly.
let's see what is wrong with how much is the amount you are getting?
One submission, my lord, I have not filed any objection to the IM, my lord. During the COVID-19, my lord,
At least now you tell the court what is your income.
I'm a driver, my lord.
Yes, driver. will
Driver,
earn
my
something.
lord, due to the COVID, my lord, I lost my job, my lord. I am running a taxi, my lord. So I met an accident, my lord. I have sustained injury. I went back to my native, my lord, village. So I have 1 acre of land, my lord. I have 3 brothers. I'm doing an agricultural coolie, my lord. And last occasion, my lord, I offered some amount to them, my lord. They are not agreed for that. Already 2 lakhs been as paid to the petitioner respondent, my wife.
To the MC,
MC is
Now
pending,
it
my
is
lord.
pending, my lord. Cross-examination is going on. PW1. My lord, in this case, they offered, it matter was settled for 7,50,000, my lord. Even today also, we are ready for receiving that amount, 7,50,000. But they are, now they are saying that only 3 lakhs they are going to give.
They already, my lord, 2 lakhs been paid. 1,80,000 was deposit before this court. Further amount, I am ready to deposit. They are saying extra 7 lakh rupees, my lord. Where I can get, my lord. 7 lakhs, my lord, already, my lord, almost 4 lakhs been as paid, my lord.
how much now it is paid? You are paying now as per the interim order?
5,000 rupees, my lord.
Pay another 3,000. Let the court decide the matter.
Pay?
Another 3,000, 8,000.
8,000 is too much, my lord.
My lord, he is running tours and travel business, my lord. He is earning rupees 90,000 per month, my lord, by the tours
It
and
may be
business only.
decided on merits, my lord, itself. I am ready to argue, my lord. Otherwise,
Argue?
please, my lord.
Yes, where is impugned order?
Impugned annexure, my lord. Annexure is the impugned order.
Yes.
She filed a petition for decree of divorce on, my lord, on 23 to
Come to
2000.
the impugned order and read
Please,
it.
ma'am.
Those are all not relevant. We are concerned with IA. Where is the IA order? Yes.
The operative portion, my lord, application filed under section 24 of the Indian Marriage partly allowed, respond
Five.
hereby directed to
Paragraph number 5.
Para 5.
para 5, my lord. In this case, the petitioner had paid for a maintenance of 50,000 per month and also litigation expense to 25,000 from the respondent. The petitioner has submitted that the monthly income of the respondent is 90,000 and he is having 3 acres of agricultural land in his village at Kavanapur of Ramnagara Taluk, and he is having income of rupees 5 lakhs per year from the agriculture. But the petitioner has not produced any RTC relating to the agricultural property of the respondent. The respondent petitioner has only produced the bank statement of the respondent to prove his income. The perusal of the entire bank statement of the respondent for the year 2013 to 25 shows that this income is not definitive income. There are fluctuation in the income of the respondent. Therefore, as of now, there are no prima facie material proof that respondent is having a monthly income of 90,000. Considering the above bank statement, the approximate monthly income of the participant may asset 40,000 per month. My lord, in this case, my lord, they not filed any assets and liability before the trial court, my lord. And the petitioner also not filed an objection, my lord. Because, my lord, there is a COVID-19, my lord, courts are closed on that day. She filed an advance application, my lord. Kindly see, I filed the order sheet, produced the order sheet, my lord, page number 36, my lord. After 1.5 years, my lord, she filed an application for litigation, section 24. After filing the petition in 2018, she filed an application on 2019, filed an application for maintenance, my lord. Thereafter, my lord, courts are closed on 16/6/2020. And matter was posted on 14/12/2020, closed are closed. She filed an application for advance for consideration of the application. Within 4 days, my lord, I could not come to the court, my lord, thinking that courts are closed. Therefore, I not filed any objection to the application, my lord. This is nothing but expert in, my lord. I maybe opportunity may be given, my lord, file an application. I comply the order of this honorable court. I'm paying the till today. I'm paying the amount.
Yes, please come. Agreed with orders passed in the application section 24 of the Hindu Marriage Act by so and so by the senior civil judge JMFC Channapatna dated 23/7/2021. The husband is before this court. The court had granted maintenance of an amount of rupees 20,000. The wife had filed the petition.
And one more thing, my lord.
8,000.
Annexure A is the, my lord. One more thing, my lord.
It's 8,000 per month.
One submission, my lord. Annexure is a FIR, my lord. In FIR, she says that, my lord, she is working as a nurse, my lord. Kindly see annexure A, my lord. Occupation is a nurse. She is also working, my lord. And there is no issues at all, my lord.
My lord, in this case, respondent is present. She is only studied up to SLC only, my lord. She has not any nurse coursing. She has not done any nursing course.
Working in a hospital. Their own document, my lord, FIR.
Is
That
she working or not?
My lord,
Working or not?
she is not working, my lord. She is not working, my lord. She studied only up to SLC, my lord.
and also, my lord, that offense 498 case has been filed, my lord. That is ended with acquittal, my lord.
Month is granted. The Lynn counsel appearing for the husband submits that husband earlier was running a taxi and during the COVID season, and as he has sustained, he met with an accident. He was staying at his village and is working as a daily coolie. It is submitted that the court that he could not file, the wife has not filed his statement, her statement of assets and liabilities. He also could not file his statement of assets and liabilities. Within a short time, the court has passed an order. It is submitted that it's more or less an ex parte order, and the order may be set aside, and the matter may be remanded back to the trial court for fresh consideration. It is submitted that the court, without giving a proper opportunity, has passed this order. Next parallel counsel appearing for the respondent by submits that wife is in his contention. She's working as a nurse. Then counsel appearing for the respondent by submits that she studied only till 10th standard.
Yes, 10th standard.
10th standard, and she has no other income. In fact, husband is having sufficient income. He's working. He's running a travel business. It is submitted that the amount that is awarded by the court is only 8,000, and there are no reasons to interfere. It is submitted that the order passed by the court is a well-considered one and no interference is confirmed. This court has perused the order. The wife had filed the petition seeking maintenance of an amount of rupees 50,000 and also litigation expenses of 25,000. And according to her, the husband's monthly income is 90,000 and he is having 3 acres of agriculture land. And he is having income of 5 lakhs from that. But she has not produced any RTC relating to the agriculture property of the husband. But she has produced the bank statement of the husband to prove his income. The perusal of the entire bank statement of the husband for the year 2013 to 25 shows that income is not definite income. However, looking at the bank statements, it may be assessed at rupees 40,000 per month and accordingly granted 8,000. Even assuming that he is working as a daily wage laborer and also he is having agriculture land, and without even considering that his income is 40,000, still the amount of 8,000 that is granted by the court, in the considered opinion of the court, is a just and reasonable compensation, and there are no grounds to interfere. Accordingly, and this court finds no reasons to interfere. The MC that is filed is of the year
2018, man.
2018, and the family court is directed to dispose of the matter by 15th of December.
My lord,
One
amount in
submission,
deposit
my lord.
can be transmitted to the
One
trial court, my
submission.
lord. Amount in deposit, my lord.
Amount in deposit shall be forthwith transferred to the trial court, and the wife is at liberty to withdraw the amount.
One submission, my lord. In para 6 of the impugned order, my lord, they given a bank statement in pertain to the year 2013 to 15. Marriage,
I have not considered that
only
income.
marriage on performed on 2018, my lord.
No, I have not considered that income at all.
I have compared that 5,000 is reasonable, my lord. Otherwise, my lord, it is very difficult to, in a small village, my lord, in Chenpatna village, my lord, it's not a city, my lord.
Yes, next.
8,000 rupees is too much, my lord.
Yes, next.
Serial number 24, adjourned. Serial number 25,
Yes, 25.
Arun Govindraj.
4 connected matters.
For the petitioner, it may be passed over, my lords.
My lords, if I could request your lordships to take it up after 4 p.m. because the learned senior counsel is on our legs before court hall 15. It will go on for some time in the afternoon. Beyond 4 p.m. if I could request, my lords.
PC, if you can take it at 4 o'clock, we'll take it up or else some other day.
Please, please.
Serial number
Obliged.
26. Serial number 26.
A lot of short accommodation may be granted. Seniors,
Respondent, my lords.
I favor the petitioner. Senior is unwell. A short accommodation may be
The
granted. my lord.
request of Lund counsel, the petitioner, list this matter on 16th of September.
Serial number 27. 27, Kapil Dikshit.
For the petitioner, my lord.
Where is the respondent?
The respondent, my lord, the respondent has been served.
Give that.
There's a petition, my lord, where I've challenged the grant of interim maintenance.
How much?
My lord, a sum of 25,000 was granted.
What is your income?
My lord, my income as of now, my lord, is 1,57,000, my lord.
On what ground you are questioning this?
My lord, the divorce petition, my lord, was filed by me on the basis of adultery and cruelty that I have faced. And during the course of the marriage, it also came to my attention that she has been receiving constant mails from certain matrimonial profiles, which, my lord, certified my allegations of adultery against her. My lord, she is also a working professional, and my lord, she is earning around 45,000 is what is being declared in her assets and liability statement. Now, my lord, as per my assets and liabilities statement, if I may take your lordship's attention to page number 117 of my petition. My lord, the expenses that I incur on a monthly basis is 1,37,960 rupees.
What you do?
My lord?
What you do with 1,37,000 a month? Page number?
My lord, the expenses are listed out at page number 116 and 117. These are the expenses that, my lord, I incur on a monthly basis. I pay towards rentals, electricity, groceries, gas, and medical expenses. And I have certain EMIs also to incur, my lord. And I have other miscellaneous expenses with regard to other bills, and also all such miscellaneous expenses are also come into picture. Now, my lord, I'm the only earning member in my family, and my mother is also dependent on me, towards whom a huge load of medical expenses
Heard and
incurs, my
accounts
lord.
for the petitioner, no representation for the respondent. Leave this matter as part heard on 3rd of September.
Fine.
Cell number 28, urgent 29, Sharath S. Gogi for petitioner.
No representation. Yes.
Your Lordship, appearing for the petitioner has filed a petition seeking relief against the order passed by the 4th Additional Family Court in the criminal miscellaneous 23 of 22.
To use the mic.
Am I audible? Your Lordship, the court has ordered the petitioner to pay 30,000 rupees as maintenance, as interim maintenance, and the petitioner has been complying with the said order.
What is the order of the family court?
Your Lordship, that on the condition that the
Court had
petitioner shall pay
directed you to pay an amount of rupees 20,000.
20,000 per month to the respondent number 2 and 10,000 to the wife, and that has been complied by the petitioner.
No, 20,000 each, that is 40,000. By the family court, impugned order at page number 34. Look at 34.
Yes, Your Lordship.
For both the petitioners, it is 40,000.
Yes, Your Lordship.
This court has directed you to pay 30,000.
Yes, Your Lordship.
That you are complaining.
Yes, Your Lordship.
Come to the merits of the matter. We'll see why it is, on what ground you are before this court.
Your Lordship, if there might be a shortage, senior will be able to assist the court.
No, there is notice is served on the respondent, no vakalat is filed. At the request of learned counsel for the petitioner, list this matter on 8th of October. Yes.
Number 30,
Much obliged.
Chandrasekhar K.A. Ashok Patil.
Responding units. Yes.
Judge, they have already deposited the 50,000 rupees, ma'am.
The model is not compliant.
50,000 deposited. Kindly for 2 weeks time, another
Or 2
40,000.
weeks time, we will decide it. You argue the matter first. Then whatever is to be done, they will do it before the executing court. Please argue.
Yes, ma'am. Page number 22 in the impugned order, madam.
Yes.
20,000 awarded, my lord, total. Wife and 2 children, my lord.
10,000 to the petitioner and
Yes, ma'am.
5,000 each.
Each 200, page number 2 and 3, 5,000.
10,000 to wife, 5,000 each.
Yes, ma'am. Petitioner working as a vegetable seller, my lord. Earning 5,000 per month, my lord.
You should tell some figure which is court at least should believe. Please come to the order.
Yes.
Principal Judge, Family Court at Mysore.
Yes, please.
Hmm. Come to paragraph number 12.
Yes, ma'am.
Paragraph number 12 of the order.
Yes, ma'am. The respondent has admitted that he is working as earning, but the petition number 1 is not admitted. The petition number, respondent number is working in a flower business, madam. Earning more than 30,000 in per month, my lord. But she is not admitting that.
Please read.
Yes, ma'am. The respondent has not produced any material before this court to show the through flower vending and watchman working. She is earning 30,000 per month. Therefore, I am on the view that all the contention of the respondent.
What do you say about this? 60 lakhs, 61 lakhs, 64,741.
This is my father property, ma'am.
You will not get anything from that. You will not get anything from that.
My share is
How many children your father is having?
Lords, they got 1,75,000 compensation by the land acquisition, lords, and they not proved the income of mine because they are saying for the for this order only they have made this kind of statement here, my lords, to prove that they not produced any document.
This is my father property, my lord.
My father property, son has no share.
My sisters and brothers.
How many brothers, how many sisters?
4.
Where from you? Where from you?
Lords, they are only the son, my lords.
Sisters already.
How many sisters are there?
No. Don't have instruction, my lord.
Huh?
Don't have instruction, my lord.
Does this matter? Heard the council's in part, as part heard on 15th of September. Yes,
Bill
next.
number 31.
Interim order.
Your ladyship, I'm appearing for the petitioner in this matter. Wife's petition, your ladyship, seeking enhancement of maintenance. Maintenance of rupees 20,000 was ordered when the husband has challenged the same order. Both the writ petitions are connected. Your ladyship, the operative portion of the order is at page number 79. 20,000 was ordered, your ladyship. It was my specific contention before the family judge that the affidavit of disclosure of assets and liabilities filed by the husband was incomplete. The bank statements were provided without the deposits column and without the balance column. Your ladyship may find my objections at page number 61 of my petition, the main petition. This has not been taken into consideration. Incomplete bank statements. The entire bank statements of HDFC Bank were given without the deposits column and without the balance column, your ladyship. Page 61, your ladyship, of my petition.
Have you filed the statement of assets and liabilities as per the judgment?
It's filed, your lordship.
As per the judgment. In Rashish versus Neha.
Correct. We have filed the,
No,
and it
please
is
see.
considered, it is
Let's see
considered.
the memo. Let's see the memo filed by them. It's page 61.
If at all, if your lordship,
They say that the account statement of the respondent's HDFC Bank so and so is incomplete. That is from 1/9/2020 to 31/8/2021.
I'm okay to produce, your lordship. Like in any case, if they claim
What about okay to produce? As per the judgment, when you are supposed to do, and you don't do it before the court and you say that you will do it here, why should we do all, why
your
should we look
lordship,
into
like
all that?
I've, in respect of that particular memo, that I have no clue about it. Like, let me just verify that particular thing and submit before this court.
Yes, if you have not, we will, the adverse inference has to be drawn. Because we can't keep on, giving a,
I'll look into it.
setting
I'll
aside the
look into it and submit.
orders and again remanding the matters. Let's not waste the time anymore. This is matter.
Your
on
ladyship, since I apologize, since the date of passage of order, not a single rupee has been paid, your ladyship. If the arrears may
15th
be
of
directed to be paid,
15th of,
may I
in
request,
your matter, there is a stay.
there's
Pardon
no
me.
stay
Your
anywhere.
case, there is a stay.
No,
This is matter on 16th. Yes, next.
May I request for the arrears, your ladyship? She's facing hardships.
No, no, yes. In 31.1, Mr. Arun Gondraj is directed to take notice and the council shall serve the copy of the writ petition. Yes, next.
Cell number 32.
I've
Sir,
received a copy, your ladyship.
then
Then
is
file my
directed to
record.
take notice. Yes.
Cell
It
number
is submitted
32.
at the note, the copies are already served. Yes, 32.
32.
My lord, undertaking to file wakalat and objections in this matter.
My lords, in fact, copy was served to them about in April, my lords. They wait till now when the respondent has been placed ex parte. Now they come before this honorable court. They've not been giving me visitation as well as per the court orders.
My
She's
lord,
been just going according to her whims and
Matter
fancies.
on 3rd of September.
My lords,
sure.
may I request second, third, it's not possible, no, second. My lords, in fact, may I please let them at least comply with the order. They're
May I
not
make a
even
submission in this regard, my
Not
lord?
even hearing the party. How will the court decide, Mr.
Well, it's
Gautam?
because the number of
Whatever it is, I have to
messages.
hear them. I have to hear
Please.
the matter. Second, this is a matter on second. We'll pass orders on the day.
Please.
Kindly, my lord.
Yes.
You messed it up.
Yes, next.
Serial number 30, 33, adjourned, 34. Serial number 34. 30 my
For the
escape.
petitioner, my lords, matter may be passed over.
Pass. Yes, 35.
Serial number 35.
For the petitioner, my lord.
My lord, the impugned order has been challenged, stating that the court has not taken the contention that there is already
The counsel for the respondent.
there's a wakalat that is filed, my lord.
You have an interim order in your favor.
Yes, ma'am.
Counsel for the petitioner is present. No representation for the respondent. List this matter on 15th of October. Interim order earlier granted is extended till then.
Serial number 36.
I appear for the petitioner in this matter, Lordship. This is challenging annexure E, wherein two application was filed. Application was filed by.
Which one? 38. It's already. We'll take then 35 all. Which is there.
35.
Where is the advocate? 35.
35. Allah, our advocate for respondent. Subramanya PD.
Give a short date. This 35 matter.
Yes,
This is the matter on 2nd of September.
Yes.
Don't have to write no representation. The list is matter on so and so. Yes. Afternoon.
Lordship, if I could get a short accommodation in this matter, Lordship.
Why everybody is? I'm not taking up any adjournments now.
My lord, in regard to serial number 27, the interim order may be extended, my lord.
Yes.
My lords, list 3, serial number 20, matter is settled, my lords.
List number?
List 3, serial number 21. In connected matter, they have filed a memo, my lords.
List 3,
Serial number 21, my lords. There are two matters. One is filed by wife and one other one is filed by husband, my lords. Matter is settled. They have connected matter, they have filed a memo.
Take the. Where is the memo?
It is already on record, my lords. In 251, RPFC 251 of 2023, they have filed a memo.
We will see. Then they have to take out the bundle.
Serial number 36, Lordship.
Look here, 615 or 28, we have filed memo for modification of judgment. I am representing for respondent to insurance company. But in earlier judgment, it is 50% of the.
First, I want to know why are you making a mention at 140?
No, we have already filed, but what happened, you know? Third, it was listed, but.
Yes.
Lordship, serial number 36, Lordship, which is called. Lordship, a slight inconvenience in the afternoon, Lordship. A date for tomorrow at least could be given, Lordship.
Serial number. Sir, ನೀವು ಏನ್ ಹೇಳ್ತಿದ್ದೀರಾ ಮೇಡಮ್ ಅಂತ
Passovers.
Passover matters. List number 1, serial number 5. Tura Mitzi.
Roll. Transfer of case.
Then what is the problem? That is what is ordered. So it is principal. This court by order dated 21st March 2025 has disposed of the CP and as prayed for by the petitioner had transferred the MC 10 of 2024 pending on the file of the third additional senior civil judge and JMFC. The MC number so and so is withdrawn and it is transferred to the file of the principal civil judge and JMFC Madhu. Now a letter addressed by the a letter is addressed by the principal civil judge and JMFC that the court has no jurisdiction to conduct the MC to conduct the a court has no jurisdiction to try the family court matters. Accordingly, sought for a clarification. It is submitted that only the senior civil judge Madhu is having jurisdiction to decide the family matters. Accordingly, the order dated 21st March 2025 in CP number 530 of 2024 is modified and modified accordingly the following order. MC number 10 of 2024 filed by the respondent pending on the file of the third additional senior civil judge and JMFC at Devanahalli is withdrawn and the same is transferred to the senior civil judge Madhur. The court shall issue notices to the parties. Yes.
Serial number 14. FS Dabali for appellant.
Where is the other side?
Reader DS.
Death of 14 years old boy.
There is no representation on behalf of the respondent in the forenoon as well as in the afternoon. List this matter tomorrow as part heard. Yes, next.
List number 2, serial
Tomorrow,
number.
whether he is there or not, we'll pass orders. Yes.
List number 2, serial number 18. Pass overs in list number 2, serial number 18. Madhukar MD.
Morning the matter, the morning passover is sought, no representation when the passover is called. This is matter on 22nd of September. Yes.
Serial number 25. Arun Govindraj. 25 Arun Govindraj.
But it's not Arun Govindraj. The name has changed. I think the list does contain my name. I'm not sure.
The name is there.
Yes, I have filed my NOC.
NOC.
Yes.
SK Pratima.
Because there are 4 petitions, my lords.
SK
One is regards the.
Where is the senior is available or you want to tell?
Post 4 o'clock, my lords, if I could request. After 4 o'clock, she's on her legs before court on
That's convenient
15.
to you?
4 o'clock is
Call
fine.
at 4 o'clock. Yes, next.
Serial number 34. Serial number 34.
Yes.
In this. This regards the maintenance that was sought by the wife. The family court has awarded only educational expenses, my lords. Both are doctors. He is a surgeon.
Page number.
Well, it's 73 is the impugned order, Lords. However, I'll come to the end portion and then go to the observation, Lords. IA2 filed by the petitioner at page 82, Lords. IA2 filed by the petitioner under section 24 and 26 is partly allowed. Respondent is hereby directed to pay entire educational expenses of the child master author during the pendency of the proceedings from academic year 24-25 and is directed to make the payment towards the school fees directly to the school on receiving the relevant particulars of the child. Plus, may I kindly request your lordship to come to page 6, internal page 6, my lords, page 78, ink page of the order itself. May I, my lords? The fourth line, the respondent failed to furnish all the particulars as per the guidelines issued by the Honorable Supreme Court of India in
Paragraph number?
My lords, this will be 10, my lords. Starts from page 5. However, I am reading out at page 6, internal page 6 of the order, in page 75. The respondent failed to furnish all the particulars as per the guidelines issued by the Honorable Supreme Court of India in Rajneesh versus Neha case. The respondent did not furnish any information relating to column F, details of income of the deponent, as stipulated in Rajneesh case. The respondent produced a copy of his bank statement maintained in HDFC Bank. The contents of bank statement reflects the bank transaction held by the respondent with his banker. The bank statement of the respondent reflects huge amount of transaction held with the banker. The respondent failed to file his affidavit of assets and liabilities, placing all relevant information and supporting documents as per the guidelines issued by the Supreme Court in Rajneesh versus Neha. Plus, the next para, 11th para, the last two lines on the next page, milords. The bank statement of the respondent, milords will get it at, the bank statement of the respondent clearly shows the transaction held with the banker and inference can be drawn regarding their financial ability. However, regards his income, milords, he remains silent. Plus, next.
What is his income?
Plus, his income is 8 lakhs per month because he's a surgeon in various hospitals. And in fact, the fee for the MD is paid by the respondent's father. The respondent's father has provided a bike, a car, fees for his MD course, yet he says, I do not want you. Plus at page para 13, milords, internal page 9, again, there is an observation at 11, line 7 to 8.
She has sought for maintenance for herself and also the daughter.
Milords, for the child. For the child.
How much she
Milords,
sought?
the maintenance that is sought was 75,000 per month. From the date of application and litigation expenses of 1 lakh.
According to you, what is her income?
Milords?
Your income.
Plus my income is 25,000 at page 60, milords.
Yes.
In page 60. Heading F. Name of employer, RV Dental College, Bangalore. Details have been furnished. Designation lecturer. Monthly income 25,000. Everything, all details are enclosed. Whereas the same thing, if I were to see the income of the respondent as per his affidavit, assets and liabilities.
According to him, he is receiving only the stipend.
Milords?
He's only receiving the stipend.
He's only receiving the, I'm sorry.
He's doing his post-graduation.
Well, that is what he is telling. He has finished MD, he is a surgeon.
When he finished MD?
Milords, now he is doing a course, milords. MD was finished, milords. The qualification MBBS, MS, MCH. I stand corrected. MS, MCH. Probably he is doing MD right now. For this MS and MCH was funded by the father of the petitioner himself. Milords, his affidavit at page 68, milords.
Para number?
Milords, this is an affidavit.
Page number?
Page 68. plus all the loans that he has availed.
You said 58 or 68?
My lord, 68, my lords. This is affidavit. Starts from 68. At point number 7, my lords, personal information. General monthly expenses of the applicant, house rent 20,000, though, and bank loan, Bajaj Finance 37 lakhs.
6.
My lords,
You read 6, point number
date
6.
of separation.
In E, in F6.
F.
No, it's not F, it appears to be E. Page number 70, point number 6.
Point number 6, whether any financial support is being provided, my lords, that is being provided by a third party for the educational expenses of the children. Details of the income of the deponent, name of the employee, professionally doctor, not exact income, keeps on fluctuating, 3 lakh per month.
And why the court has considered about the 40,000 and all it was discussing about?
Because he says that I'm doing a course right now.
And what are his expenses? Where did he say?
Because he says expenses are 20,000 per month house rent, which is at column A, starting page 68, Milots. General monthly expenses of the applicant. House rent 20,000, bank loan Bajaj Finance 37 lakhs 72, hand loan taken from Amar Mysore 20 lakhs, Cholamandalam car loan 17 lakhs 30,000, mortgage loan from ICICI Bank 3 crore 43 lakhs is what he states under the general monthly expenses.
Yes.
My lord, this is a fancy litigation for the petitioner, my lord. She is a daughter of one of the wealthy person in Bangalore city. Owns about 100 acres of land in Jayanagar land. He is a big landlord. I am not concerned about that. Your lordship may kindly see the application filed by her at the ink page number 49. For the reasons shown to in the accompanying affidavit, it is prayed that this honorable court may be pleased to direct respondent to pay a sum of rupees 75,000 per month as maintenance pendental light to the petitioner and the minor son. She has asked for herself and her son. From the date of the above petition until disposal, the petition has been filed on 18th June 2018. I have filed an objection to this petition at the earliest stage of time on 19/8/2019. Your lordship may kindly see page number 54 which they have produced. This respondent being ambitious of higher studies, that is the respondent herein, after completing his MS in general surgery, has now joined the MCH neurosurgery course at Vide Medical College, Bangalore, by successfully getting said seat through NEET entrance exam, and the respondent is not having any earning now, and he is getting a stipend of rupees 40,000 per month, and the respondent is now staying in Whitefield in a small house and paying rent of rupees 10,000, and for his personal expenses he need rupees 30,000 per month, and also that he needs future amount for procuring his study materials, and the same is being provided to him by his friends. Knowing all these facts only to harass respondent, the above case is filed by the petitioner for wrongful gain. There is next para. The petitioner has absolutely no problem to look after the minor child Athar. If the petitioner has any problem, the respondent will pay the
When did
child.
he complete his studies? When did he complete his studies?
2021. 2021. Till 2021, he is a junior most neurosurgeon now. He will not get a salary of 8 lakhs rupees. If they pay 8 lakhs rupees salary in any hospital, he will join that hospital. No problem.
What is, as per your statement of assets and liabilities?
No.
You said your income is 3 lakhs.
No. That I will come now. Now, in my assets and liabilities, I have stated my salary, my income is at page 70, para number 6. Professionally, doctor, not exact income. It keep on fluctuating rupees 3 lakhs per month. Rupees 3 lakhs per month. Now, my lord.
So what does it mean that he is getting?
Now, what happens is, in Bangalore city, there are a number of senior neurosurgeons. He cannot compete with them he has to work in a district headquarters for a good experience. He is in Hassan, which is 200 kilometers. It is a district headquarters. In one hospital he is working where he is being given a salary of 80,000 rupees per month. Each operation that he conducts, he will be paid and remuneration according to the operation that he has conducted, which varies from 20,000 to 40,000 rupees. On an average, 4 or 5 operations he does per month. So he has to look after the patients in the hospital. He will not get any remuneration because he is taking salary. If he completes 5 years in a hospital in a district headquarters, then in a hospital like Manipal Hospital or Vikram Hospital, which are good hospitals in Bangalore or in other country or in his state, he can get an experience on the basis of his experience, a job. Now, my lord, the order of this honorable court, your lordship may kindly see, which my learned friend has not brought to your knowledge. The respondent is hereby directed to pay entire education expense of child master author during pendency of this proceedings from the academic year 2024-25, and he is directed to make payment towards the school fee of the child study on receiving the relevant particulars of the child from the petitioner mother. This order is dated 3/3/2024. Till today, they have not given the particulars. Humpty number of times I have requested in the open court. This matter has come before this court at least 10 times. Give the particulars. We will go to the school. We will request the school authorities to receive the fees. We will pay to the child some pocket money, everything. They are not giving. Even at this stage, they are not giving. On 2021, I have filed court of supplies. I have filed application for interim custody of the child for 15 days. For 15 days for Dasara vacation. They have not. They said that you give the your proposals, how you are going to take the child and how you bring. Even today, orders are not passed. I'll just read out two paragraphs of this application.
I don't
The
have
petitioner has to. The petitioner has to permit the respondent to take the son to on first Saturday by evening 5 p.m. and 8 p.m. to Lal Bagh, Bangalore with respondent and drop before 9 p.m. on the same day. Not complied. The petitioners has to bring the child to Mysore, drop near the park and permit respondent their parents to take the child on third Saturday at by 5:30 p.m. On Monday, they bring back the child on morning 7 a.m. to the petitioner's house. Not complied. The petitioner has sent the child 20 days from April 15 to May 25th to respondent house at Mysore. Not complied. Then why they are fighting this litigation? Recently, one of the high courts has said that husband is not a ATM machine. Your lordship may kindly see the assets and liabilities that I have produced. During the time of my studies, I have incurred certain liabilities. About 60 lakhs rupees loan I have got. I have to pay 37 lakhs 22,000 rupees, 72,000 to Bajaj loan. Finance, it is borne out of record. I have to pay hand loan to my friend 20 lakhs. I have to pay Cholamandalam 17 lakhs 30,000. ICICI Bank, I have to pay nearly 3 crores 43 lakhs. When these are my liabilities, she is a professor in RV Dental College. According to the UGC scale, 1,60,000 rupees is the scale for a professor. After 4 o'clock, she works in a BTM layout in a private dental clinic, and she earns about 5 to 10,000 rupees per day. Now my submission is this, my lord. If a particular party can wait for 3 years for a maintenance compliance by not giving any of the particulars, why they have to fight this kind of litigation to waste the precious time of this honorable court? It is not her case that she is unable to maintain herself. She is a well-educated person. Her claim is for 75,000 rupees. That has been negatived by the trial court. All that has been said is to meet the education expense of the son. Yes, I am ready to give. Give me visitation right. Give me the details of the school authorities. There in the family court, they don't allow the progress of the matter at any point of time. Moment we file an affidavit, they will say that they want an time to file an affidavit. The court said that file a memo before the court to hear the visitation right, and they don't file it. And they come to the court after the vacations are over. This is the habitual tactics of the present petitioner before the trial court. In 2018 matter, and one of my friend was telling recently, anything can wait in this world, not age. 8 beautiful years of both the parties are gone because of the conduct of this petitioner. She is not allowing the progress of the matter, makes one or the other allegations. And I have already stated in the case in page number 35, para number 9. I am just repeating that in Kannada, my lord, your lordship can understand. Kannada and Telugu has got similarity. Nannanna avaru mane aliya agbeku anta, they wanted me to become the son-in-law of the house. I am a self-respected person. I have made this allegation. Her parents always wanted the respondent to be their mane aliya. There was certain issues. Fees had to be paid to the bank without the knowledge of this respondent. The father of the petitioner has gone to the bank and paid the money when the relationship was good. Later on, the petitioner's respondent's mother has returned that money to them. He goes to the respondent's petition.
All those things are not
No,
necessary.
my submission is only this, my lord. My submission is only this, my lord. It is not a case for enhancement. It is not a case for any maintenance to the wife. Subject to the visitation right which your lordship will grant to me now. Let them give the memo before this honorable court with an affidavit, the details of the place where son is studying. I will go to that school and pay his all till his graduations are over. Not today or just if he is studying up to the age of 25, I am ready to pay. But visitation right now 10 years till the age of, but now maintenance to her, my lord, because she is earning more than 2 lakhs rupees per month. I have demonstrated it before the court.
This seems to be more of directing the court than praying the court. Your lordship will direct now.
I am requesting the court. I am not directing
submitting.
You please answer why you are not giving the details of the school. You give me the details of the sons where he is studying.
I do not want any cross talk.
You have not complied the order of the family court. How your writ petition is maintainable?
Yes.
You are directed to give the details of the school, son where he is studying.
Yes, Mr. Senior Counsel, let her argue. Yes.
May I just come to the memo that they have just given?
Let's not go into all that.
Correct. No, even there, application under section 26,
I'm not
so and
interested
so.
to hear any of it. Please come to the impugned order.
Yes,
Now,
Lords.
the wife is working as a professor or
her
not?
salary is 25,000.
Professor?
She's
working
a
as
lecturer.
professor.
RV Dental College.
So that for them, there are no guidelines for the salaries and all?
The
Usually-
salary as of
it is
now
not
is 25,000. I can file an affidavit to that extent again before this court. I have no problem. I can do that.
That is one.
That is
Now, when you want maintenance, filed an IA seeking maintenance, when the court had directed you to give the details, bank details and other
That is
school
from 24.
details, why it
Correct.
was not given?
Plus, that is from 24-25. What happened?
Please let it be. No,
I understand.
whatever money that comes. When you are coming before this court will grant.
Because there is no dispute regarding that. In fact, even before the family court, the party already has details. When this matter came up, after submissions were made, immediately on the first hearing date, it was referred to mediation. The parties were mediating. Probably this is the third or the fourth time that the matter is coming, and your lordship has also intervened in the chambers between the parties. So I would say this is the first time that is coming for arguments, my lords. Because he has refused to take her back.
May
And-
I interrupt, my lord? This is the fourth argument. On one of the occasion, His Lordship Justice Pradeep Singh Yarur directed her to file a salary certificate from the college and also to give the details of the, there was no order to that effect, but there was a portion of the order reflects that to give the details of the son's school education where he is studying. She has not complied that. Outside the court, we all requested her give the details of the school. He will go and talk to the school. She did not give.
I don't think such false submissions are required.
If I am not,
I do not know why such false submissions are made.
Yes.
In fact, on the first date of hearing, it was referred to the mediation because they wanted mediation.
It's a very simple issue.
Yes, my lord.
We don't require this kind of lengthy arguments
Please,
from
my
either
lords.
of the side.
Please.
What is
I'm
relevant
willing
for
to produce her
granting
salary
maintenance is-
certificate before this
What
court
is
if that is
relevant
what.
for granting maintenance is a very one or two grounds which I need to know.
Absolutely.
Nothing else.
Yes.
Even if husband is very bad, wife is very bad, doesn't matter.
Absolutely, my lords.
Court
The
is
child is
granting
entitled
only-
to a
Court is
maintenance
only
and the
deciding an
education.
IA,
Absolutely.
that too pertaining to the child.
Correct.
Yes.
But still now, though he himself states in his objections that he now stays in Bangalore in Whitefield, contrary to what we are stating that he is in Hassan as a surgeon earning there. He is not in Bangalore. But till today, no effort is made to come and see the child. All that he even praises, the court may direct, the court will direct. This is the prayers. If the application is, orders are not passed on that application, he has to approach the court in a different way.
Yes.
He can't be adjudicating his grievance in my petition.
Yes.
Plus, all that I'm saying is, why is the court directing from 24-25? What is the reasoning that is given? In spite of the
What is the
observation
age
by
of the, what is the age of the boy?
my lords, now 2013 is the 16 is the birth of the child, 13 is the wedding, 19/7/2016.
When was the IA filed?
Well, as IA filed 2018 when MC restitution petition was filed, my lords. 18/6/2018. He filed divorce after that, 12/7/2018.
When he completed his studies?
Well, it's completed. The respondent in 2021. 21. That is MS, my lords. He's talking about MS. When they
No,
were married,
while
they were already doctors.
Yes.
Plus, if I may just invite your lordship's attention to one para of mine in the writ petition, page 6, my lords. Page 6.
Yes.
Second para, I'll only read the relevant lines, my lords. The engagement and marriage expenses were borne by petitioner's father and as demanded by him.
Why are you reading that for what purpose?
Why I'm saying the financial help that is extended in the next para, my lords.
That is also,
7,20,000.
even if it is extended, not extended, that is not going to
Even-
be the decisive factor. Please come.
Please, my lords, please.
Agreed by the orders passed in. I number 2 in MC number 3121 of 2018, dated 3rd April 2024, whereby the court had directed the father to pay the entire educational expenses of the child from the academic year 2024-25 directly to the school on receiving the relevant particulars of the child from the petitioner mother. The mother is before this court. The mother has filed the IA seeking maintenance of an amount of rupees 75,000 per month for herself and the child from the date of the application and litigation expenses at rupees 1 lakh. It is the case that she is working as a she's a dental doctor and her salary is 25,000 per month. And the husband is a general surgeon and working for NDRK Hospital, Hassan, and his income is not less than 2 lakh per month. In spite of it, the husband refused to maintain her and the child, and she is in need of 75,000 per month for the maintenance for herself and the child to maintain the same standard of living. The husband has filed his objections, denied the income. According to him, as on the day, he is getting a refund of stipend of 40,000 per month. It is stated that he is not having any problem to look after the child. If the wife is having any problem to take care of the child, he is ready to take over the custody of the child, and his parents will take care of the child. The court, by order impugned, had directed the husband to pay the educational expenses from the academic year 24-25. However, no amount is granted as maintenance. The court has also observed that the respondent in his affidavit of assets and liabilities referred about the details of his liabilities and payment to be made towards EMI and other loan transactions. The respondent failed to furnish all the particulars as per the guidelines issued with the Honorable Supreme Court of India in Rajneesh versus Neha's case. And also the respondent did not furnish any information relating to column F details of income of deponent as stipulated in Rajneesh case. He has produced a copy of his bank statement maintained in HDFC Bank. The contents of the bank statement reflects the bank transaction held by the husband with his banker. And that statement reflects huge amount of transaction held with the banker. He also failed to file his affidavit of assets and liabilities as per the guidelines issued by the Apex Court. Court had discussed about the contention of the husband with regard to the wife's income.
Page 70, item number 9, I have stated furnish the copies of bank statement of the last 2 years, HDFC and ICICI bank statement.
The court has observed that the wife is residing in the parents' house along with the child. The documents that are placed before the court clearly leads to the conclusion that the wife is capable of leading decent and dignified life with her earnings, and she cannot be termed as dependent, and she is not entitled for maintenance. Court also observes that the husband failed to produce his IT returns. Intentional withholding of relevant document compels the court to draw adverse inference. Hence, the court has directed the husband to incur expenses for the maintenance of the child, directed to meet the educational expenses of the child. Next para. When it comes to the litigation expenses, the court has not granted, as both the parties are capable of prosecuting the litigation. The court had not granted the litigation expenses. Land counsel appearing for the petitioner submits that the husband is working and earning more than 8 lakhs and is capable of paying the maintenance, but he has not paid the maintenance, nor he has made any efforts to see the child. It is submitted that the court, when the application is filed seeking maintenance of 75,000, court had granted maintenance from the year has directed the father to pay the educational expenses from the academic year 2024-25, and the application is filed in the year 2018 itself. And the court ought to have granted it from the date of the IA application. It is submitted that the salary of the wife is 25,000 and the husband is earning in lakhs. He has a responsibility to contribute for the maintenance of the wife, who have to live the same standard of living. It is then counsel summons the argument submitting that the amounts needs to be enhanced and it should be from the date of the IA. Then senior counsel appearing for the respondent submits that though the impugned order was passed on 3/3/2024, directing the father to take care of the educational expenses and to pay the same to the school, and there is an obligation, and that the mother has to furnish the details. Till now, no such details are furnished. It is submitted that this conduct of the wife makes it clear that she do not require any maintenance, only for the purpose of litigation. The application is filed. It is submitted that father was never permitted to visit the child, and even their IA that's filed seeking visitation rights is adjourned on some pretext or the other, and it is a submission that the wife is not cooperating with the pending proceedings before the family court. It is submitted that the respondent husband has completed his studies in 2021 and is working in Hassan as submitted by the land counsel for the petitioner. His income is not 8 lakhs. 8 lakhs. And according to him, how much? 3 lakhs. And he is earning an amount of rupees 3 lakhs per month. As the wife is the wife, according to the senior as per instructions, the wife comes from a wealthy family, and she do not require any maintenance. She is practicing as a doctor, and also she is having her own clinic, and also she is working as a professor in a dental college, and the court had rightly not granted maintenance to her. Next one. Having heard the learned counsel for the petition, the learned senior counsel on other side, there is the material on record. Both the counsels have extensively argued beyond what is required to consider in this petition, going to the extent of what has transpired between the parties, what is the financial status, what made them to file the conduct of both the sides for deciding this application. All those aspects are not relevant for this court. While granting maintenance, the court has to see the financial capacity of the parties, the requirement, and balancing the both. Court has to pass an order granting maintenance. Both of them are doctors. According to the wife, her earning is only 25,000. And both of them, according to the wife, husband has not filed all the documents. According to the husband, wife has not filed all the documents. Court has also gave a finding about how all the documents are not placed before the court by both the sides. The husband is after his post graduation. What is that? The next DCA. What is that?
MS, MDS is what is qualification, Lords. He's MBBS, MS, MCH.
No. MD and MCH, he has completed his MCH in the year 2021. When he has filed his statement of assets and liabilities, he stated that even at that point of time also, it would be fluctuating from an amount of rupees till it would be approximately 3 lakh per month. Now, even now, it is stated that his income is 3 lakhs. When both the parents are earning, they have a responsibility to take care of the welfare of the children. Basing on the income of the parties, proportionately, they have to take care of they have to contribute to the maintenance, educational expenses of the child. Admittedly, the boy is residing with the mother, who is aged about
11 years.
Who is aged about 11 years. As per the evidence on record, the wife's income is 25,000 per month and the husband's income is 3 lakhs. When the court has passed an order directing the husband to pay the educational expenses, it ought not to have been from the academic year 2024-25. Whenever an application is filed seeking maintenance, generally the maintenance order should be from the date of the application. If in any exceptional circumstances, court is passing an order from a subsequent date, there should be a reason for that. From the order, this court do not find any reason why such an order is passed from the date of for the academic year 2024-2025. When the husband says that he is capable of taking care of the child, the court considered that and also the aspect of 3 lakhs income. In that view of the matter, the husband is directed to take care of, shall pay the educational expenses of the child from the date of application and shall continue to pay during the pendency of these proceedings. What is the amount that the wife has incurred towards educational expenses? The receipts of the same shall be placed before the family court by way of a memo within 10 days from the date of receipt of the copy of this order. And the husband is at liberty to file his objections, and basing on the amount that is arrived at, the husband shall pay the expenses within a period of 8 weeks from the date of determination of the said amount. Then coming to this part, this is pertaining to the educational expenses. The boy is residing with the mother. Hence, for the maintenance of the boy, the father shall pay an amount of rupees 10,000 per month, accordingly disposed of. But I can't decide in this. The application that is filed by the father seeking visitation rights, the court specifically directing the courts to dispose of the matter within a month. it is submitted that the application is filed in 2021. The court shall dispose of the IA seeking visitation rights within 1 month from the date of receipt of the copy of this order. Which one is this? Which year is this? As the main petition itself is of the year 2018, the same shall be disposed of by December 15th.
Cell number 36.
Look, one submission, maintenance from the date of application.
That is it, sir.
Cell number 36.
Lordship, I appear for the petitioners here.
Inter-alia.
The respondent sides have told they're out of station today, so in the morning they're asked to seek for a short accommodation. It's a question wherein both the.
How many times this matter is listed, you see?
It's a short question, Lordship. For the next date, it can be decided wherein both of us have filed an application.
This is matter on 16th of September. No further adjournment shall be granted.
Interim
Yes,
order
next.
may kindly be extended, Lordship.
Interim order earlier granted is extended till then. 38,
Cell number 37.
which 37 is adjourned.
I appear for the petition. It was not adjourned, my lord, because the respondent was not available in the morning. My lord,
They're
this,
seeking adjournment.
Bhargav Devi.
She want adjournment.
my lord, because I need to file a memo to bring to the notice of this honorable court that there have been changes. The
Matter of the
deliberate-
counsel for the petitioner.
kindly have it on next week, my lord.
Not, short date not possible. There are so many matters on 15th of September.
It's only to bring to the notice of this honorable court that the military has rejected the grant of maintenance.
15th of September, next.
Apply.
8. Rupesh Kumar, 38.
Petitioner, my lord. His wife's petition, my lord, for enhancement, my lord.
Yes.
Wife's and daughter's petition. The amount that is awarded is only 7,000, my lord, towards the daughter, my lord.
Wife is rejected.
Against wife, it is rejected, my lord.
On what ground?
On the ground that she is working as a cluster supervisor at Taluk Panchayat office.
Well, how much she is earning?
25,000, my lord. She's earning.
25,000.
Yes.
What is the husband's salary?
He's earning around 50,000, my lord. That he has
50,000.
admitted. And
So why you want maintenance for yourself when you're earning
I am
25,000?
residing in a rented place, my lord. And I'm all alone, my lord, and I have other expenses as well, my lord. Towards the minor child, my lord, the award is very meager, my lord. It is only 7,000, my lord.
How much you sought for?
My lord?
How much you sought for?
40,000, my lord.
What is the age?
Age, she is around 15 years, my lord. Sorry, 18 years, my lord, now. She is 18 years. And she has been admitted to Christ University at Bangalore, my lord. And for entire educational expenses and maintenance, my lord, the only amount awarded is rupees 7,000, my lord. The admission, the hostel fees, my lord, itself comes to around 18,000.
Why don't both of you bear half of the educational expenses of the child?
My lord, 75%, my lord, at least.
Now, apart from the maintenance of 7,000, let the educational expenses be borne by both the parties equally.
My lord, not equally, my lord. 75%.
No, you are getting 7,000.
My lord.
This maintenance is there already.
That is there, my lord.
So 25 plus 7, how much it will be?
That will, even that would be very less, my lord.
But
Because
then,
as per the document, my lord.
No,
per
no.
month, my lord.
1 minute, 1 minute. Now 32,000 is your, no, your, because that 7 is also, maintenance is given to you, it is 32,000.
Yes.
His thing will be 43.
3,000. And he has other income as
So,
well, my lord.
no law says that more than
Yes, I agree, ma'am.
100%, 50% of maintenance amount should be granted towards maintenance.
My
It's
lord.
generally, we are looking at 25 to 30%.
I agree, my lord. But the educational expenses only.
That's what I said, half of it, both of you are earning, do it.
But he has other income also, my lord. Apart
Is
from
there on
salary-
record?
Yes, my lord. Yes.
Let's see, what is there on record?
It is stated in the affidavits of assets and liabilities, my lord, that he has agricultural income as well.
How much?
My lord, he has 4 to 5 acres of agricultural property. My lord.
That's what, how much he earns from
Actual
that?
income, I do not know, my lord. I have to ascertain that.
Get instructions from your client about, is he ready to contribute 75% of the educational expenses? 75% of the educational expenses? 75% of the educational expenses, and this maintenance, this we will continue, 7,000. Then counsel for the respondent shall get instructions with regard to the husband's contribution towards the educational expenses. When? Mrs. Marta on 30th.
39.
Why? If you want your matter to be heard, we'll hear it only on Saturday.
No, 29th, my lord. Even I am not in station on Saturday.
Then it will go along for list on 4th of September.
Serial number 39, Geeta Devi MP, petitioner,
Appearing for the petitioner, my lord.
Gautam
The
Raghunath,
petitioner is challenging 3 impugned orders, my lord. Maintenance, residence, and the summoning application, my lord. Maintenance is claimed towards the son, my lord.
When is this application numbered? Why, how can you go, how can you question all the IAs in one
But it's
petition?
common order, my lord. 3 and 4 is the common order.
Let's see the order.
Please, my lord. Annexure A, my lord, page 21.
This is one.
Please, my lord. And what summoning application is kept in abeyance, my lord. It's not considered my application.
That is another IA.
Please, my lord.
And then that also is questioned in that.
Please, my lord. Lord, because prior to
Huh? First of all, without going into that, I will not interfere, I will not pass any orders in this writ petition unless and until you file a separate writ petition for that another IA, third IA.
short date may be given, my lord.
Yes.
Seek instructions.
The 3 IAs are questioned in this writ petition. 2 IAs, a common order is passed. And for the third IA, though it's a separate order, still this writ petition is filed. The petitioner shall question the order by way of a separate writ petition. Once a separate writ petition is filed and necessary amendments are carried out in this writ petition, list this matter. Whenever you do, it will come.
serial number 40, YP Vijayavasanta Kumari,
In this case, I appeal for the petition. My only prayer before this honorable court is that this honorable court was pleased to grant an order on 17/7 of last month, directing the petitioner to pay the arrears of rent within 1 month from the date of the order. He is not a permanent employee, my lord. I'm praying for installment to pay the arrears of maintenance as installments, my lord, in 3 or 4 installments, because he is not having any savings account. His earnings is only 25,000.
All that we cannot consider. This is an interlocutory order. On this condition, stay is granted.
No,
If you are not ready to pay, what the court
No,
can do?
already 50,000 has been paid, my lord. Remaining 1
How
lakh,
much is the amount, remaining
2
amount?
lakhs 30,
Substantial amount is pending.
13,000. No, my lord, 50,000 has been paid. The
I
remaining
can
amount
understand
is,
you paid 2 lakhs and 50,000 is outstanding. You
No.
pay 50,000 and 2 lakhs is outstanding.
no, 1 lakh, no, already we are paying monthly maintenance. We are depositing. Only the arrears is, it was 2 lakhs 63,000, my lord. Out of that 50,000.
Maximum a month, not more than that.
But he is not having any income, my lord.
But let
He
him,
is
let,
a
let- let them,
labor.
let them exercise like whatever is available for them. They will execute the order. We can't consider all that here.
At least grant me 1 month time, my lord. Within that, he will adjust and pay the arrears of
Anyhow,
maintenance.
some amount your client will get. Again, she has to go and file the EP. One month will grant for the arrears.
For
They're
the
continuing
arrears.
to pay.
I have no objection for going for
It is
mediation.
submitted that there is a likelihood of settlement. The matter is referred to the mediation for paying the arrears of maintenance. Another 1 month time from today is granted. No further, because from mediation it won't come, because there is a conditional order, it will be vacated, order will be vacated, that's why. The 1 month time is granted from today for paying the arrears of the maintenance. No further time will be granted. Parties are directed to appear Bangalore
Bangalore.
before the Bangalore Mediation Center on 3rd September.
Interim order may kindly be extended, my lord.
That's what is done now.
Yes, my lord.
Yes.
Final hearing, cell number 41. Muralidhar HM for petitioner.
No representation. This is matter on 24th of November.
Cell number 42. M. Veerabhadraya for petitioner. K.V. Narasimhan.
Huh? Why? To adjourn these matters, the court is feeling the inconvenience. At the request of land counsel for the respondent, list this matter on 17th of December.
Interim order based.
Interim order earlier granted is extended until further orders. Yes, next.
Cell number 43. 43. List number 3. For order, cell number 1.
Compromise petition by way of joint memo.
The last occasion on 14th, my lord,
Yes, yes.
I filed in the office. My lord, the total sum, my lord, towards permanent alimony is 5 lakh rupees. My lord, before this honorable court on the day 14th, my lord, I have paid a sum of rupees 2,50,000. My lord, remaining 2,50,000. My lord, we will have to pay before the, my lord, family court. My lord, in which, my lord, the petitioner has filed a divorce petition in the MC number. My lord, recently after
So then how can this petition be closed?
Because, my lord,
No, the procedure is you go before the court, you complete it. No, there should be some final settlement.
That is the reason, my lord, at least your lordship, my lord, till the conclusion, your lordship adjourn that matter also. We will dispose of both the.
Yes.
When
is the matter likely to come up there?
22, my lord.
22 February.
No, my lord, this day after tomorrow.
Oh, 22nd.
22nd of this month.
List this matter on 28th.
Please.
Yes. Yes, next.
Cell number 2 dispose, cell number 3.
What is the name of the advocate?
Well, I enclosed, I have produced it. What is it? Seal also in the summons and summons. Chowdegoda. Chowdegoda.
In the execution.
In the execution.
As per the order passed by this court, the petitioner, the counsel has served the and summons on the counsel appearing for the respondent in the executing court, before the executing court. Mr. S.T. Chowdegoda, in the name of Mr. Chowdegoda. This is matter on 9th September.
Interim order may be extended.
Interim order earlier granted is extended till that.
For admission.
Cell number 4.
Yes.
Rajesh Rao K.
I appear for petitioner in this case, my lord, for enhancement, my lord.
What is this awaiting mediation report?
Mediation not
Failed?
succeeded. All the.
Huh?
They
What
say
is
that
that?
they are ready, my lord, but
How many times the mediation will be done? Already mediation report is awaited. He says it is already failed. Why should we again, Why? There should be a reason. It was done on 28/7/2025. Argue the matter. Yes.
my lord, the petitioner, my lord, wife, my lord, the housewife, my lord, no job, no work, nothing, my lords. And
He was granted 5,000 per month as maintenance.
per month, my lords.
What is the husband's income?
Income, my lord, the kindly see that I have submitted the additional document, my lords.
Not, we'll see, we'll look at only the order. Please come to the
Order, yes, please. in the trial court deposition, my lord, I have submitted in the additional documents, my lord. His income is, my lord, now presently, he's earning more than 75 to 80,000, my lord. In fact, my lord, in his land, the mobile towers, 2 mobile towers are established, my lord. Out of which, from one mobile tower, he is earning nearly 40 to 45,000. It comes approximately about 80,000. But he refuses to admit that fact, my lord. And the said land is not belongs to him, he says. But the land is belongs to him only, my lord. I have produced the RTC and other documents with respect to the land. And he is also running a chicken center. Nearly 1 lakh, my lord. Approximately 90 to 1 lakh he is earning, my lord. And suppressing all those facts, my lord, in the trial court, he admitted that he is not having such an income. The trial court.
You have to prove that he's earning this much. We can't assume things.
I have produced the documents, my lord. Kindly see one
45,000, 45,000, 90,000.
2 towers photographs I have submitted.
The towers are installed there. What is the amount it will fetch?
My lord,
how will the court know?
Please, my lord. Now the case is already disposed, my lord, this maintenance case. Thereafter, this petitioner came to know that this mobile tower is established in the land. Because she is not able to go there, she is not in a position to, my lord, ascertain.
This evidence before the court, I will satisfy this order and remand the matter. To establish that his income is 90,000.
Please, my lord. My lord, one last submission. My lord, kindly see the document I have submitted. Additional documents, my lords.
Yes.
Kindly see page number 10, the deposition. It is in Kannada, my lord. I will translate, my lord. This in this, my lord, it is deposed by that the respondent that, my lord, ಎದುರುದಾರರಿಗೆ ಯಾವುದೇ ಆಸ್ತಿ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ, ಆತನ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. They only admitted, my lord, he is having only a small chicken center. Other than that, they are not having their admission. Further, thereafter, my lord, kindly see the cross examination of the respondent, my lord, at page number 17. Page number 17, second para. ನಾನು ಗದ್ದೆ ಕೆಲಸ ಮಾಡ್ತೇನೆ. He says that, my lord, he is a farmer. He is doing all this the agricultural work. In the chief examination, of the petitioner, they only admitted that he is having the chicken center. All matters falsified, my lord. Here they said, he himself said that I'm doing the agricultural work. The question of chicken center does not arise at all there. They all falsified. Further, my lord, non vyaparastha endare sariyalla. It is false to state that I am not a businessman. These are all the admitted facts, my lord.
How all those facts will help you?
My lord, after that is, my lord, I agree, my lord. After the disposal of this maintenance case, my lord, with great difficulty, the petitioner collected these documents, my lord.
Yes. How much your client is ready? How much your client is ready to pay? Interim maintenance. Maintenance, how much is ready to pay? Will grant 10,000.
They have no work. Wanted them. These are only no work. They have no proper job. Daily labor. Put all
We'll do one thing. According to his submission, that the cell phone towers are erected in your land. Please ask your client to file an affidavit before the court that in his land, oblique, the land belonging to the family, no telephone towers are erected. Then counsel for the petition submits that the telephone towers are erected in the land belonging to the husband, oblique husband family, and they are getting an amount of rupees 90,000.
In the land is in the name of George Thomas, my lord.
Who is George Thomas?
His father. He is an adopted son.
That's why I said.
Please.
No, in the name of the adopted father. The petition, then comes for the respondent, denies the same. The respondent shall file an affidavit to that effect that the telephone towers or not, whether shall file an affidavit whether the telephone towers are erected in the land belonging to his adopted father or not. Yes, this is matter on 11th of September. Yes, next.
My lord, not 11th, my lord, 8th or 12th or 13th, my lords, please.
18th of September.
Grateful.
5. Devendrayan.
Additional. Translation ready this week. Translation is the copy ready there. You put it order.
What is he saying?
Translation is the copy is ready this. Counter ready ಮಾಡಿದೀವಿ.
For filing the translated copy seeks time. This is matter on 15th October. Yes. Huh? Huh? He wanted to file a translated copy. Huh? No, translated copy of the impugned order. Impugned order is in Kannada.
Annexure A.
Give that.
Annexure A is in English.
First petition. Then what is the translation you have filed? It is submitted that the impugned order is in Kannada. That's why I asked you to file the translated copy. Yes. Yes, let him file. List the matter on 10th of September. Yes, next.
Cell number 6.
The officer has raised objection that the children are not made the parties, petition number 2 and 3. During the pendency of the petition, my lord, the father has taken the forceful custody of the children from the school itself. So when the impugned order was passed, the children were not.
They should be shown somewhere. Either if you're prosecuting it on your behalf.
Yes.
So then, but you should be shown as petitioner. The other should have been respondents, showing that the office objection shall be complied with within a week. Default order. Yes, next.
Cell number 8, 7.
List this matter after service of notice.
Cell number 8.
What has happened when warrant has been issued, my lord, for that reason?
What to do? Notice has to go.
My lord, notice already issued, my lord, before 1 month, my lord. It is not been served, my lord. In fact, my lord, warrant has been issued, my lord. He is not in a position to go to work, my lord. Because of the workplace also, they have issued us the copy of the warrant. For that reason, my lord, it is very difficult for him, my lord. Subject to deposit of 50%, my lordship may kindly consider the.
Because the court has felt that this is not a case for interim order. The court has not.
No, not like that, my lord. The delay was there for that reason.
That's what I'm saying. With that, how much is the delay?
Delay, my lord, 194 days delay, my lord. 196 days, my lord.
What is the reason for the delay?
My lord, the export order was passed.
Come to the year, let us see.
My lord, export order was passed, my lord. Recently came to know about the order, my lord. For that reason, the delay is there. Kindly see page number 11, my lord. Annexure A. The petitioner placed the export, my lord, before the trial court.
Court notice must have been, you have not appeared. Why you have not appeared?
My lord, notice has not been issued by the petitioner, my lord.
Have you made any exercise to know at least what has happened to the service of notice before the trial court?
Not served, my lord. Before the trial court, my lord, notice has not been served on the.
If it is not served, you must be having your own defense, sir. Unless and until the notice is served, why would the court hear the matter and set you ex parte?
Ex parte order has been passed, my lord. Annexure A, may kindly see. Page number 11.
What are you doing now?
My lord, 10 days back, my lord, after giving the copy of the warrant, my lord, the company also not allowing the petitioner, my lord, to go to the work, my lord. He's working as a temporary employee, contract basis, my lord, in the ISRO company, my lord.
ISRO?
No, my lord. ISRO, my lord.
Hmm.
On the contract basis, 24.
What is your?
He is getting 24,000 per month, my lord.
Hmm?
24,000 salary per month, my lord.
How much is granted?
My lord, 8,000 to the wife and 6,000 to the daughter, my lord.
14,000.
Please, my lord.
Pay 10,000. The
Till
land
then,
council
ma'am,
submits that.
Interim
What
order.
I'm saying, interim order.
Please.
Land council for the petition submits that the court had granted 14,000 as maintenance, 8,000 to the wife, and 6,000 to the son. He came to know about the same when he received the notices in the execution case. He submitted that his salary is 24,000. As no notices were served on him, he couldn't appear before the trial court. He couldn't appear before the family court, and the order is passed granting 14,000 maintenance. Considering the submission of the land council to the petitioner, they shall stay of all further proceedings on the condition that he shall pay 5,000 to the wife and 5,000 to the child by 5th of every succeeding month. Arrears also within 8 weeks, or else the stay granted by this court stands vacated. The
Not
petitioner is
50%.
permitted to take out hand summons on the counsel appearing for the respondent before the executing court.
My lord, 50% of the arrears, my lord. I'm requesting. Because 4 lakhs is there, my lord, is not in a position to pay, my lord.
In 8 weeks, 50% of the arrears. In the next 8 weeks, another 50% of the arrears shall be paid. Yes.
Till number 8, Deepak BR.
Office has raised the issue with regard to the maintainability, and a memo is filed seeking conversion of this RPFC into a writ petition. Accordingly, the office objections are sustained and the petition and the RPFC is dismissed, giving liberty to the petitioner to convert this RPFC into a writ petition, and for statistical purposes, RPFC is disposed of. Yes.
Till number 9, Aishwarya Hegde MV.
Petition, my lord. But there are office objections, my lord, regarding maintainability, my lord. You are challenging the final order, not the interlocutory order, my lord.
What is the order?
My lord, office has raised objection regarding
No,
the.
let's see the impugned order. Where is the order?
My lord, internal page number 13, my lord.
Yes. Office objection with regard to the maintainability is overruled as this RPFC is filed against the final order. Yes.
My lord, regarding other office
What
objections.
about the non-compliance of office objections?
I pray for a week's time, my lord.
A week's time default order.
Obliged.
Yes.
Till number hearing on interlocutory application. Till number 10, Shrikant.
Petition. I have filed an application for paper application, my lord, in respect of respondent. In my lord's Udayakala, my lord's
124 is filed.
Sipalapur edition, my lords.
So and so mentioning the date of on or before
4th of September.
mentioning the date of hearing as so and so. Yes.
Please.
Yes.
Till number 11, adjourned. Till number 12,
Notice.
I appear for the petitioner in this matter, my lords. My lords, the condonation of delay application is filed in accompanying the recalling application, my lords. 28 days of delays there in filing the application, my lords.
Notice has to go.
My lords, the notice had gone to him, my lords. However, we could not find out his address, and
What
then
if
we
he
were
seeks
asked to
further?
serve it by email, my lords, which we have done. It is served via email, my lords. He did not appear before the trial court also, so we do not. I have filed a memo, my lords, dated 17/4/2025.
Now, how many times there should be a order, then again recalling the order? And this is a RPFC of 2024. So far, process is not complete.
My lords, his address is not traceable, my lords. We have served it through email.
I number 2 of 25 is filed to recall the order dated 4/6/2025. This court has perused the reasons stated. Accordingly, I number 2 of 25 is allowed. And the order dated so and so is recalled.
That application 1 of 25 is for the delay.
How many days? I 1 of 25 is filed to condone the delay of 28 days in recalling the order dated 4/6/2025. Accordingly, the delay is condoned and consequently considering the reasons stated in I number 2 of 25, order dated 4/6/2025 is recalled. The office is directed to issue emergent notice. Yes, next.
Cell number 13.
Petitioner in this case, there was a conditional order. I was supposed to pay the amount on or before 4th of August. And due to my financial constraint, I did not do it. And on 5th, I have taken the DD through my father in Bangalore. He's in Australia. And one day there is a delay, Your Lordship. There was a conditional order that on or before, if I don't pay that, interim order stand cancelled. Now I'm requesting this court. I mean, the DD is ready with me, the up to date.
What is the amount?
Amount up to date balance 19/8/2025. That is 2,10,000 towards maintenance and 31,810.
DD is for what amount?
2,10,000. It is maintenance, regular maintenance from the date of interim order. And there is 31,810 arrears of maintenance after deducting that is 81,000, 1,81,000, which is already paid by the petitioner. And up to 19/8 I have paid, Your Lordship.
So with this 2,10,000 and 31,810, up to date you have paid.
19/8, up to 19/8.
I'll need to do the
Get
math on this.
instructions.
I'll do the math on that because we didn't receive anything till today. So we were under the impression they've not given us anything.
The counsel appearing for the petition submits that though there is a conditional order, on time they could not deposit the amount. And today he has come up with two DDs, one for an amount of rupees 2,10,000 and the other for an amount of rupees 31,810. And submits that with this they have paid the all the arrears and also continue
Up to 19/8/25.
19/8/2025.
But if there is any differences, let them file.
And they will continue to pay the amount.
Yes.
The same is received by the land counsel, the respondent, and he submits that he'll get instructions with regard to the arrears, if any.
Interim
order earlier
Restored.
granted is extended till
Maybe
the next
restored.
date of hearing. Let's this matter on 16th of September. Yes, next.
Much obliged.
Cell number 14. Sunil S. Narayan.
For petitioners, copy.
Short date may
Come up with the file your objections. It is the counsel for the petitioner had served the copy on the counsel for the respondent. It is submitted that they'll come up with objections and she seeks time. List of matter on 24th September.
Interim order is there.
Interim order earlier granted is extended till then. Yes, next.
Cell number 15.
Look at it. Interim order is there, then only extend. Yes. Yes.
Cell number 15.
Notice.
Appear for husband, my lords.
Notice.
Cell number
My lords, here, there is no iota of evidence they have produced. That is what in the impugned order it has been stated.
Then what are you doing from 123 days?
My lords, this is a legal service matter, my lords. I have undertaken. And then ink page number 31, internal page number. She has stated that 1 lakh earning is there, is a barber, my lords. But petitioner has not produced any iota or oral documentary evidence. to
How much
show
the
that.
court had granted?
My lords, 5,000 each, my lords, one is petitioner entitled 5,000 each per month towards their maintenance of the respondent and accordingly directed to pay 5,000
That is
each.
15,000.
15,000. And
What is his income?
my lords, 10,000.
What is he
Because
doing?
barber, my lords, even he doesn't have a shop. That is why they have not produced anything. And he's looking after his old age mother, staying at home as of right now.
Why he has not contested the matter?
Reason it's in Mysore, my lords. He can't leave mother and go there every
Then
time.
comes for the petitioner submits that the husband is a barber and his income is 10,000 per month and court had granted 15,000, that is 3,000, 5,000 each to the three petitioners and he is not in a position to pay the maintenance. Considering the submission, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 5,000 towards the maintenance of petitioners 1 to 3 and shall continue and by 5th of every succeeding month and also the arrears at 5,000 by within 10 weeks. Yes, default order.
Chair number
Issue notice to the respondent.
16, Srinidhi, please.
Lordship, the petition stands dismissed. The maintenance petitions before the trial court stand dismissed in my lordship on the ground that there is an already maintenance granted in the OS number. It was filed by the petitioners for the partition and maintenance, my lordship.
How much is granted there?
Lordship, 20,000, 10 for wife and 10 for a daughter, minor daughter, my lordship.
Then why again she has filed this?
Lordship, this is on OS, they have filed an appeal, my lordship. The respondent has filed an appeal, and there was a stay by the Honorable High Court in RFA number 1003 of 2022.
Amount is paid now.
Interim order was granted to pay the half of the arrears amount, my lordship. There is an amount of 9 lakhs pending. They have paid only 4 lakhs, and till today, no, arrears was not yet paid, my lordship.
My lord, RSA has gone disposed with the paying of 20,000 maintenance and half of the share, my lord, which has already confirmed, my lord. They have not gone for any appeal also. The copy of the RFA, my lord. And maintenance, I should take instructions whether he's paying or not. I don't.
Not that we are not concerned whether he is doing it in that or not.
That he should file an execution, my
What has happened,
lord.
disposed of?
Disposed
Yes,
of, my
ma'am.
lord.
It's
By
during the pending of the
Now 20,000 is ordered. And again you file 125 CRPC proceedings.
no, lordship. What happened is we have filed an OS, and that order wasn't passed, my lordship. During the pending of the OS, they have filed an
No, RFA is disposed of.
yes, my lordship. RFA.
You pursue that, we'll dismiss this RPFC.
Yes, my lordship.
Come in the order of the court.
But the order was passed in the RFA was meager amount, my lordship. That's why the
My lord,
education expenses is.
He was
also
a
not-
Many things
he was a
can't be done.
surveyor, my lord, and he has also taken voluntary, my
Please
lord.
come. There is order. Agreed by the orders passed in.
12, my
Criminal
lordship.
miscellaneous number 11 of 2019, dated 1st March 2023, whereby the court had dismissed the petition filed under 121 CRPC. The wife is before this court. Then counsel for the petitioner submits that the court has dismissed the petition on the ground that the wife had filed a OS for maintenance and partition, where the court had granted 20,000 maintenance, that is 10,000 each to the mother and the daughter, and also granted properties,
Property,
partition.
half of the share of
half of the share
Of
is
the husband,
granted.
of the husband.
Granted. The husband has preferred an RFA and there was a stay granted. As such as as the husband has not paid the maintenance, she is compelled to file this proceedings under 125 CRPC. It is submitted that the court ought to have considered the plight of the wife where she is not getting the maintenance and ought to have granted the maintenance. Next para. Learned counsel appearing for the respondent husband submits that in fact the order that is passed in the suit has attained finality.
My
And
lordship,
appeal-
small submission that RFA was filed an another review petition, and in that review petition, the maintenance was awarded 15,000 for the wife and 10,000 for the daughter, or it was reviewed, my lords. The RFA was reviewed.
More advantages for you
Yes,
then.
ma'am. That is.
How
it
it
is not-
can be reviewed?
No, my lord.
No,
No,
you
this
have
is-
not preferred any appeal. He has preferred appeal. In his
I was
appeal,
preferred
why would
appeal.
the court
No,
review
madam.
the?
Another advocate in RP number 557 of 24 has
Give
filed.
that? Give that?
But,
How can it be done in his appeal? How can maintenance be enhanced to you?
That was some ambiguities there, man. That's why they have cleared, because there is an order by the trial court that until charge is created over the shoot schedule property, maintenance was awarded. That was clarified by the honorable this coordinate bench of this honorable court, that until charge is created is only for the
Look
daughter.
at it. There is something.
Even I was not a counsel for that, my lord.
Look at it.
Even I should.
I don't know what is that order. Mrs. Mata as part heard on 9th of September.
It may be disposed of, my lord, on the whatever it is there, we can't change
No,
it.
that looks little strange. Look at it. I'm not able to understand that. Yes,
That
next.
RP was disposed of, my lordship. That's right.
Let him look at it.
Cell number 17.
Appeal is filed by you.
Appeal is filed by me.
Filed by you.
Appeal is filed by.
No, the court dismisses your appeal.
Dismisses our appeal.
In a review petition, his maintenance is enhanced. That I'm not able to understand.
When I
Look
want
at
to.
it.
Because there is an ambiguity, there is another order.
Let him assist the court. Yes, next.
17.
17, I am for the.
Patil.
Lordship, we have not received the petition copy, your lordship.
23 RPFC, when did you file your wakalat?
We are applying for response. Huh? Arrangement.
Petition copy court is-
Single.
And counsel for the petitioner shall serve the copy of the petition of the
Meanwhile-
counsel for the respondent. Admit post for final hearing.
Cell number
Alla, Your
6.
lordship may kindly see, my lord, this is against the interim order.
Then RPFC is why it is filed.
Please, my lord, initially an objection was raised, but coordinator of this bench has overruled that objection. Last time also your lordship has looked into and issued notice.
Take the papers. Give him the papers. We'll hear
I
it.
will give, but instead of admitting, my lord, let it
Yes,
be.
under the same caption. This is a matter on 10th of September. Yes.
Cell number
10th of
18.
September, my lord.
18.
Grateful.
Cell number 18. Geeta Devi.
Appeal for the petitioner, my lord. Interim order has been complied, my lord. I filed a memo to that effect.
They have deposited, as per the order, they gave me a memo yesterday stating that they have deposited 50,000 each on two children's name. But he is the person who is to operate and he need to encash that. But the wife is looking after the children, both children are being looked after by the wife. And no maintenance is being paid in spite of the order. And wife is without any job. You have to look after the two children. One child is a special child.
No, he says interim order is complied with.
Well, that condition of the interim order, my lord, that condition, of course, order has been stayed. No doubt. Now it is for admission. And in this, on account,
We'll go to that.
Yeah.
Whether the interim order passed by this court is
that
complied with or not.
a memo has been given yesterday.
Please get
Yes,
instructions
yes, Miller. But the condition is to safeguard the interest of the children. This money was directed to be deposited, some amount.
Why can't they have that money?
The fact is that I'll explain to your lordship, my lord. This is the husband's appeal challenging the same order, my lord, 125 proceedings. Marriage was in 2007, my lord. She left the matrimonial in 2022. The entire order, which it is not on merits, the entire trial has not been commenced, my lord. She has filed a memo saying that I'm ready to go reunite with my husband, my lord. Based on that memo, my lord, the court has come to conclusion that even though they are residing in the same house, she is residing in a separate room. Hence, she is entitled for maintenance, my lord. From day one till today, all the education expenses, everything, necessity, basic, everything is provided by me. She is not earning. And my lord, the property which we are residing even now, that is in joint name. And even for that, my lord, even I'm paying loan now. Now, my lord, they came and they filed like a seamless petition saying that I'm not maintaining, my lord. There is no any.
How much is awarded?
50,000 rupees, my lord. 25,000 is for the petitioner wife, two children, 12,500, 12,500, 50,000.
Then who is taking care of the educational expenses of the children?
Me, my lord. Even I filed a memo, placing the documents on record. From day one till today, it's me. I know, my lord, she goes into 22 in native, not here. They're residing in Bangalore. She goes to native and she files a 125 proceedings.
Your Lordship, kindly take page 15, para number 15 of the impugned order.
Entire trial has not been commenced. She has filed assessment liability. She knows that the present home is under loan. She says that I don't know.
Now, if you're taking care of the children, you must be paying all the school fees and other things. Where are the receipts?
He has paid the school fees of a daughter, eldest daughter. But so far as the second son, he is a special child. He requests special treatment and other things.
For him, are you taking care?
Yes, ma'am. Both the children are with me only. He is not looking after them at all. He is not looking
That is
after
their
them at all.
submission.
No, nothing is being paid.
The age of the children.
She is 12 years, my lord, first PUC now, sorry, 16 years.
15. Boy is 9 years
9
old.
years.
Boy is here also before the
And
court.
my lord,
only.
I have filed a
The
memo.
boy. Nothing has been, he's a special child.
I have admitted him to the
He
preserve school.
is suffering from autism. And he requires special treatment at school.
How can you say that
Nothing is paid.
what is that, where are the receipts to show that you are paying the fees of the
I
child?
have filed a memo, my lord.
The child who is suffering with autism?
Please, my lord. I've admitted for him school, but she has not sent
School he is studying now.
preserve school, whereas for therapy school where for special child.
How much you pay per month?
My lord, it's per academic. Totally I have paid is 2,37,000 for 2 years, my lord. And that is on record. And she has not sent the child for that school. She wants to admit the child in DPS with regular public school.
Perseverance is the school. He has paid for 23, 24. And that receipt he has produced before the court. And,
If, my
and
lord, if
till,
your lordship go through impugned order, your lordship may
till 23, 9, 24. There's a receipt he has produced before the court.
Where the parties are residing?
Bangalore, my lord, together.
They're not staying, there's a special, that's why I requested lordship to para 15. But their counsel has admitted before the court. I'll just read to your lordship.
Let the parties come, we'll see.
Please, my lord.
The parties are directed to be directed to.
My party is present before you.
He also has to come.
He was
Also
right to
has to
present,
come.
my lord, but today he has
but-
gone to an interview, my lord.
But some interim maintenance may be ordered because she has no education and she is jobless because she has to look after this child, special charge them. He is not in a position to look after himself. He'll have to concentrate on that.
Let the parties appear before the court on 28th. Let it, 28th.
Interim order may be
29th we
extended.
will pass orders, 28th.
28, Mila.
Or on the same day itself we can pass orders. Chambers,
Interim order may be extended.
interim order earlier granted is extended till then.
This blanket stay order, that is for that reason I'm.
That's what we'll pass or, we'll meet them on the same day I'll pass order.
Cell number 19, T. Prakash.
I represent the respondent.
Non-filing of acknowledgement for having paid interim maintenance to respondent.
We have not completed that order, my lord.
Then we will dismiss
And,
this.
My submission is, my lord, what my instructions are, my lord, they are trying to give the land itself as a share to the children. That is the information he has given and he
No,
is trying to-
I'll vacate, this court has passed an interim order on so and so. And as per the order passed by this
Lord,
court,
if he goes to jail, then there
What
is
we
no
can
question
do?
of settlement.
interim order is not complied with. Hence, the order stands vacated. The respondent is at liberty to execute the same. This is my admit, post for final hearing. Yes, next.
20, final hearing matters. Somnath H. for petitioner. Yes, Srinivas.
Respondent. May I please, your lordship? Appear for petitioner.
Yes.
This RPFC is filed challenging the semis which was granted to pay maintenance of rupees 12,000 per month to the wife. Impugned order is at page number 39. Husband has filed MC for divorce. 1,44,000 maintenance is pending, my lord. We have cleared all the arrears. Void
Where is
impugned
the
order,
operative portion of the order?
page 39, my lords.
39 is not the operative portion.
Page 39.
There is different, the Page numbers,
This was NOC.
12,000 is granted.
Please, my lord, 12,000.
What is your salary?
My lord, I was earlier getting 10,000 rupees, my lord.
Hmm.
At a point of time, my job, I was left out of the job, my lord.
Hmm.
I was residing with my mother, my lord. I'm taking care of my mother. That's what I has produced documents as well, my lord. Even wife is also working and she has lent money, my lord, for interest, and she is also getting some money, my lords.
So according to you,
all-
your present income is?
10,000, my lords.
What is your qualification?
I have got diploma in pharmacy, my lords.
Hmm.
Wife has got degree in BCom, my lords.
So what were
And
you earlier doing?
I was working in pharmaceutical company, my
How
lords.
much you were getting up that time?
15,000 rupees, my lord. 15,000.
10,000.
No, earlier I was getting 15,000, my lord.
Hmm.
Later, that company, I just left the job in that company, and then I joined some other company, my lord. I was working, I'm
Do
getting
not
10,000.
contest this matter.
Please, my lord, it was contested, my lord.
Then
The
what was the evidence
court
before the
below was
court?
held that I was filed petition for divorce, my lord. Divorce petition was pending at while this order was passed, and she has filed for RCR, my lord. However, my divorce petition was allowed, and her RCR was dismissed, my lord. Agreed by which they have filed appeal, and MFA is pending before the division bench, my lord. Now, she herself in a cross-examination have admitted that she has given loans to some other persons and she is getting income from that, my lords. What court below has considered is that I have got some ancestral properties and I am getting income from that ancestral properties and I am liable to pay the maintenance, my lord.
Whether you got the ancestral properties or not?
No, my lord. It was standing in
You
my
can see the
father's name and
page
it is,
31,
I
my
have
lord.
4 brothers, my lord. It was my father's property, my
What
lord.
are the properties? How many? What is the extent?
Extent all residential properties and sites, my lord. After the death of my father, it was standing in all my brothers' name, my lord. Till partition has not taken place in my name, my lord. No RTCs or revenue entries are standing in my name, my lord.
Please come to
Please.
paragraph number 14.
Whereas the respondent specifically denied the same in his objections, but he has not pleaded any facts in respect to his application, income and properties in his objections. He has also filed the affidavit of disclosure of liabilities in time. In his affidavit of disclosure and liabilities, he stated that his education qualified diploma in pharmacy. He is an unemployed, staying with his mother. He knows not could live depending on his mother.
So
His mother.
father is no
My lord,
more,
please.
properties are there. The rent that is received from the properties are taken by the sisters who are in America and Norway. And the property stands in the joint name of you and your father.
Please, my lord. My lord.
Okay, how is it believable?
My lord, my mother is also suffering from disease, my lord. She is aged about
It
70
is a
years.
different
I am
aspect.
taking care of her, my lord.
Aspect that your mother is, if your mother is suffering, what is the amount you are spending towards it is a different aspect.
Please, ma'am.
The issue is now you're having properties and you also admit that rents are received. Property stands in the name of your father and yourself.
Please.
But rents will be received by the sisters who are not in country. And a person who is getting 10,000 will not take any money.
My lord, the rents are received by mother, my lord. It is left to her whether to give it to her
You
sons
said
or mother.
so,
No.
that is received by the sisters.
Sisters and as well as mother also, my lord. But it was not pleaded, but it was.
It
rents
appears
are,
that for the purpose of evading payment of maintenance, this is a story.
no, my lord, that's not the thing, my lord. I'm ready because at the time when this petition was hearing before the court below, my lord, divorce proceedings were pending, my lord.
At least
And
what
no,
is
I
the
have to
rent you are receiving? At least have you stated so? What is the rent received by your mother?
Lord, that rent because some one or the year it will be increasing or decreasing. My lord.
That's
Sometimes
what, whatever it
sometimes the
is,
house will be vacant and we are unable to
that
get rents
those
from all the sense.
eventualities we can
Please,
take
my
care
lord.
of.
Even
But
I'm
we have
not.
to know.
Please, my lord. We are
But
not
we have to
getting
know
any
what is
rents, my
that.
lord. We are not. I am not receiving any rents, my lord. That is my contention. Rents were received by mother and her sisters, my lord.
But the property is in
He was
your name and you are not bothered about the income of it.
My lord, that is the partition suits, my lord. He has not the revenue entries are not standing in his name, my lord.
How could there is part of the properties are both in your name and your father's name? It is mentioned.
Father
my
is
lord.
expired.
Father has
Father
expired, my lord.
expired.
Please, my lord.
It will be transferred automatically to sons and.
The properties exhibit P1 to 12 was standing in the joint name of his father and himself.
Lord.
Paragraph number 20. For page number 20. Paragraph number 15.
Bro, it was standing in both the names, my lord.
Yes, then
60/40, even wife also got some properties from her assets, my lord.
Please
She is
don't,
also getting.
please don't jump from one to the other.
That's not my.
You
my
complete
lord.
this and then you can go, you can say what
Please,
is her properties and all.
Please, my lord. The affected partition allotted the properties to her and her other 3 sisters. They have given one side measuring 60/40 to her and her sisters. So on oral appreciation of evidence, both the parties evident that though petitioner is the degree holder, she has no any independent income for her. Lord. These are all the conditions of the wife, my lord. She is having 3 sisters and she has got properties, my lord. In
It's
this
not
one.
contention. Exhibit P1 to 12 was standing in the joint name of his father and himself. What is your submission on that?
Lord, it was standing in my name, my lord. But when sisters may file for partition, I may get only some extent of properties.
And
My
if you
lord.
have,
These properties are all standing in my joint name, my lord. But sisters are also entitled for equal share, my lord. I'm not sure whether
What is
these
there
are.
in your name?
Lord, as soon as father passed away, only the revenue records are standing in my name. That means only when the revenue records are standing in my name, that is not only my entire
Please come.
property, my lord. Because sisters are also entitled for equal share, my lord.
My lord, one more submission from my
And
side.
cruelty, based on the cruelty which was meted out by him.
Mediation can be referred, I think. Both are traveling in the same car and all the photos are here. You can see it recently.
That photos are all at the time of filing of before my MC, my lord.
Both are staying in the same hotel and lodges and all. The petitioner and respondent.
Twenty-six 1/2025.
That date, we don't know whether they have.
It can be referred.
Yeah, it can be referred, my lord.
Then counsel for the petitioner. Respondent submits that this go for settlement. Party shall appear before the mediation center where?
Bangalore Mediation.
Bangalore on 9th of September. Yes, next.
Cell number 21.
In 21, in 251 RFA, my lords, I am appearing for the petitioner, my lords. In connected matter, my lords, 132 of 2023 memo has been filed by the other side advocate, my lords, stating that there is a reconciliation and matter may be closed, my lords, by virtue of that memo. Even I have got instructions from the client, my lords.
Yes. Not 2:30, 2 o'clock. Because 2:30, in the chambers, I can't take up at 2:30. 2 o'clock.
That serial number 21, Malad. The parties have already settled the dispute.
Where is the memo?
Filed the memo on 29/10/2024, Malad.
Look at it.
That already instructed the office to put up the memo. They already say that memo has been put up, Malad.
Cause list. And the memo is there.
29/10/2024, produce the order sheet also, Malad.
A memo is filed stating that on 18/6/2024, the disputes between the parties are settled. That is invoice number 236 of 2022. And they have also filed a compromise petition. In view of the same, the petitions have become infructuous and the writ petition may be they are dismissed. Land counsel appearing for the petition in RPFC number 132 of 2013 submits that as they have entered into compromise, both the petition may be dismissed as infructuous. In the light of the compromise memo dated so and so so and so, petition is dismissed as infructuous. Yes, next.
Cell number 22 or 10. Cell number 23. Mukkanappa SB for petitioner.
Yes.
Lord, in connected matter, my lord, petition copy has not been served, my lord. I do it on next week, my lord.
This has been served long ago, my lord, 2024. But I'm appealing for the first matter, my lord, for the petitioner. Given long ago, it has been filed on 22/8/2024.
You appear in 23 or 23.1.
But I'm appearing for petitioner 183 of 2024.
Land counsel for the petitioner in the RPFC 183 of 2024 shall serve the copy of the petition on the counsel for the respondent. This is a matter on 8th of October.
Much.
May I seek for a shorter date for this reason, my lord. Huge amount is still pending from the
The
husband.
matter on 10th of September.
Please, my
Much.
lord. Please.
Yes, next.
Serial
Yes.
number 24.
For the petition in this, Fraxy Council in this matter, kindly have it on next week, my lord, some inconvenience.
They're seeking time.
Next week.
This is the matter on 16th of September.
Much.
Yes.
Pass over matter, serial number 25. Serial number 25.
Yes.
Your Lordship, double apology, Your Lordship. Twice I have really sorry.
Yes.
Plus there are
This serial number.
2, serial number 25.
So there are 4 petitions that are now pending before your lordship, my lords. The first one is regards the club bills that was sought by the petitioner before the family court in GNWC.
1 minute. WP number
Plus
230.
23044.
That is for?
That is for the summoning of club bills. The respondent is a member of various clubs in Bangalore, which he keeps visiting.
First of all, you please tell the court about all the cases.
Plus,
That is
the first, the 23044 is regards the club bills.
1860.
18064 was disposed of, but I have filed an application for modification of visitation rights. That is 18604. Otherwise, the matter has been disposed of, my lords.
Yes, next.
The
71.
next 7182 and 7678, both are arising out of an interim order passed in GNWC, whereby 30% of the vacations are granted to the father. Now he seeks enhancement, I seek reduction, arising out of the same order, my lords.
So let's start with the first one.
First one, 23044, my lords. This, plus the petitioner filed an application, IN number 10, seeking summoning of monthly club bills, including detailed liquor bills from various clubs, which he is a member of. And also his stay at ITC Gardenia during a particular date.
Where is the impugned order?
Miller's impugned order is at 107. Yes, if I have to come to the relevant portion, should I just come to the relevant portion, my lords? Would that be easier? Ink page number 115.
Dismissed.
I'll just read the para. In the case of deciding guardianship, the custody of the child, the welfare of the minor is.
You can come to 114.
114.
114 and the second para.
Please, my lords. Petitioner had sought direction to the persons named in the application to produce the documents, that is, the monthly club bill, including detailed liquor bills from January 2014 till date from Century Club, Baswangudi Club, Bangalore City Institute Club, and respondents stayed in the hotel ITC Gardenia. Similar applications was filed in MC number 1979 of 16, which came to be dismissed as per the order dated 25/1/2021, wherein the court is held summoning the bills relating to the liquor is not going to prove the petition averments, as it is not a conclusive proof that the respondent alone consumes liquor purchased by him. The petition is filed under section 7 of the GNWC seeking permanent custody of the minor child, Master Riyan Srinath Keshav. It is the contention of the petitioner that the acts of the respondent and his tortures and blatant disregard for human dignity and values, family life, welfare and upbringing of the minor child and his immoral way of life is detrimental to the upbringing of the minor child. The child needs a stable, decent, principled environment for their upbringing so as to mold their character in a righteous way. It is the petitioner who is taking care of the day-to-day expenses of the child, and the respondent had neglected the child. In the case of deciding guardianship, the custody of the child.
Where is the IA?
Millards?
IA.
IA is at page 97. May I, Milord?
Where is the affidavit?
Millard's affidavit is at page 99. Should I read the affidavit, my lords? My lords, I'll read from para 3.
So the whole thing is that he consumes alcohol.
Yes, ma'am.
Spends time with the friends.
Correct.
So to find out that you want this bills.
Yes,
to
how
be
much
summoned.
liquor does he consume? How often he visits the club and whom he hangs out with will be evident from the details that I have sought. So summoning of the documents from the various clubs was crucial to decide whether he would be an appropriate father to have custody of the child is what this thing was.
Yes, what do you say on that?
Your Lordship, such an application was already filed by her, similar one, same actually, was filed by her in her MC petition. And that application was kept pending, no orders passed on that. The final order of her divorce, that application was dismissed, but her MC petition itself came to be disposed of, where she was granted a divorce, which has come up in appeal and there is a stay. So at that point of time, that application which came to be dismissed was not challenged. Therefore, now what she does, that very same application in GNWC for round 2 is started. So all I'm stating is, when that application is already concluded, has attained finality, and whether principles of again res judicata in terms of very different terms ultimately, but the very same application and it is dismissed. Again, to bring that up again in the next petition and seek again a relief would not be right. At least if that was pending in appeal or she had exhausted some remedy, I would understand. Otherwise, Your Lordship, that I don't even need to argue with respect to club bills, Your Lordship. Club bills, how many people come, how many people drank, can a bill even reveal that? And then in a club, Your Lordship, quite often, the club member's card is taken, relatives come, friends come, whatever. By way of club bills, would it be even possible for somebody to even establish all of this would be difficult. And Your Lordship, now we have sailed past so many of those stages, come to a much subsequent stage wherein both have been able to show how well they're able to parent. So this, in fact, this has passed the test of time with respect to also the fact that it's been dismissed earlier and attained finality. I submit that she should have challenged that earlier order.
WP 23044 of 2020.
It's recorded in the orders. It's recorded in the order.
Agreed with the order passed to 9 number 10 in GNWC number 253 of 2017. Dated, what is the date of the order?
Let's.
And impugned order, one second.
This is the impugned order. This is the impugned order.
20. 3/8/2022.
3/8/2022, whereby the court had dismissed the application filed under 151 CPC. Is questioned before this court by the wife, by the mother. The husband, the respondent father has filed the GNWC seeking custody of the child. In that, IA is filed by the mother seeking a direction to the different clubs at Bangalore to produce and place on record the monthly club bills, including detailed liquor bills from January 2014 till date. It is a case of the wife that husband is addicted to alcohol and he spends more time with the friends, and that is not in the welfare of the child. And to prove the same, the present application is filed. The court, by order impugned, had dismissed the petition. While dismissing the petition, the court has observed that in MC that is filed for where the wife is already granted divorce, in that the wife had filed a similar application and that came to be dismissed by order dated 25/1/2021. In that the court has held that summoning the bills relating to the liquor is not going to prove the petition earnings, as it is not a conclusive proof that the respondent alone consumed the liquor purchased by him. The petition is filed under Section 7 of the Guardian and Wards Act, seeking permanent custody of the minor child. It is a contention that the acts of respondent and his tortures and blatant disregard for human dignity, values, family life, welfare and upbringing of the minor child, and his immoral way of life is detrimental to the upbringing of the minor child. The court felt that while deciding the cases and the guardianship, deciding the guardianship and the custody of the child, the welfare of the minor is superior to the rights of the parents. By summoning the monthly club bills with detailed liquor bills from 2014 will no way prove the character of the respondent. And the court also observed that already there is an observation that summoning the liquor bills will not prove the averments, and it is for the parties to prove their case. Just father being addicted to alcohol, or he being the member of the club, or his stay in the hotel is not a fact which proves the rights of the parties. Apart from that, nothing is made out by the fact that the husband is addicted to alcohol and his addiction is in such a way that he lost his stability. Hence, the court felt that such an the application is not necessary, and there is no necessity to summon the documents and accordingly dismissed. Land counsel appearing for the petitioner submits that as a husband is addicted to alcohol, and after consuming alcohol, how his behavior is and how it is going to affect the child. All this the wife wants to demonstrate before the court. As such, the application is filed, and the court, without considering the same, had dismissed it. Then senior counsel appearing for the respondent submits that in the earlier round of litigation, in the MC proceedings, already such an application is filed and dismissed, and the same has attained finality, and it is submitted that it is barred by res judicata. Further, from the date of application till now, the father has exercised the visitation several times, and also that aspect, as of now, it will not stand for scrutiny before this court. It is submitted that whether the custody of the child can be given to the father or the mother, what is the interest of the child, will be decided by the court on several other aspects, but not basing on this, and it is nothing but to delay the proceedings. This application is filed. Next, having heard the and considered the petitioner peruse entire material on record. The application that is filed before the court summoning several clubs and hotels to place the liquor bill is for the purpose of showing that husband consumes alcohol and it is not in the welfare of the child. No doubt, earlier an application is filed and it is dismissed, but that will not amount to a res judicata in these proceedings, where the earlier petition is a matrimonial case between the parties, and here the dispute is altogether different, and question of res judicata will not arise. But the reason for which she wanted those documents, those details to be summoned, has no nexus with the present case, and the court had rightly considered and dismissed the petition. This court finds no reasons to interfere. Dismissed. Next.
Plus 18604
Yes.
is an application for modification that I have filed,
Yes.
wherein the father was given, as per the joint memo entered between the parties, my lord, the father was given visitation rights every week on Saturday from morning to evening.
Here is that order.
Let's, that order, let's.
Order dated 13 December 2021.
13?
December 2021. It's a
13,
final
12,
order.
2021. Court office is the. This is wherein in our petition with the final order was passed because by then COVID was over.
The sides have been argued the matter.
Vociferously for some time now agree that COVID-19 pandemic may have greatly withered away. The arrangements in terms of joint memo dated 28/3/2018 be restored and a direction be issued to the court below to accomplish the pending proceedings within a period of 9 months, ordered accordingly, petitions disposed of. Liberty is reserved to the petitioner to seek enhanced visitation rights during winter vacation. This arrangement will govern the pending proceedings under GNWC 250 of 2017, pending before 5th additional. Copy of the order may be placed before the learned family judge. This they have sought for modification.
What is that?
Well, it's the joint memo.
No,
In effect, the joint memo, my lords.
If you look at it, nothing by this order. There is no direction.
Because
that-
I'm not seeking a modification of that order.
Then which order?
There is a joint memo. As per the joint memo, the visitation rights have to be restored, is what the court said in that order. Subsequently, what happened recently, that is last year, my lords, during the visitation time, the father was abusive to the child.
This is an order dated 13 December 2021. And
Plus-
the court has left everything for you to seek modification.
Correct. No,
Before
no,
the
I'm not
court.
seeking, my lords, not that. What I'm seeking is the modification of the joint memo, which the order refers. Plus, my application for
What
modification.
is impugned in this writ petition?
Plus, writ petition impugned was by them, not me. The writ petition was.
What is that? Then I'm not able to understand this.
Milas, I filed an application for modification on 3/8/2023, much after disposal of that writ petition. Recently, I have filed 2020.
Why should we do it in this writ petition?
Milas, because that is where the court said,
Court has not said anything by this
let's
order.
restore the arrangement as per the joint memo,
No.
is what the court says.
Please read it again.
Milas,
Your Lordship, it talks about the joint memo which was in the MC
The
petition.
arrangement in terms of the joint memo dated be restored.
Correct.
And a direction be issued to the court below. Both the sides having argued the matter, so and so, now agree that the court ban having agreed way, the arrangement in terms of be restored and a direction to be issued to the court below to accomplish the pending proceedings, ordered accordingly. Liberty is reserved to the petition, enhanced visitation during the winter. Will go on the pending proceedings, so and so, pending before the so and so.
Arrangement will govern this. Your Lordship,
As
what
per the-
happens? I'll just explain briefly. This arrangement, this joint memo was filed in the MC, but that the divorce petition filed by her, which was granted. This arrangement was to continue in the GNWC also. Now, if they need modification so desperately, then it's in the MFA that is pending, because this was as against the MC order where they filed the joint memo. So the question of asking a modification here when actually, as your Lordship says, innocuous, it doesn't make any sense. Nevertheless, even if they want, they filed the joint memo in the MC. MC is before the MFA court. Then in appeal, they can go and ask for that.
Plus, let me just clarify. Since the order in this WP says the visitation rights as per the joint memo be restored, it is this writ petition which clarified that. The visitation, because COVID-19 came, there was pandemic and no visitation was happening, and there was only video call rights given to the father. Subsequently, what happened was, then it was while disposing, the court said that since the situation has eased out now, let the visitation or the arrangement that the parties have entered into in the joint memo be restored. Hence, I'm coming before in that writ petition, I'm seeking a modification.
Wherever any change circumstances are there in these petitions, Parties are always at liberty to approach the court.
Milord,
It is always, basing on the changed circumstances, the court time to time can pass orders. Why should we?
Plus, the parties have already entered into a joint memo. They say that, if I may, but it's in another writ petition.
No, but the
in
joint
this-
memo, they've entered into a joint memo.
Yes.
In a particular proceedings.
Yes.
That proceedings have attained finality.
Yes.
Finality in the sense the court has passed a final order.
Yes.
Again, it's that it is appealed to.
Plus, but that arrangement is being continued. That arrangement is what is
So
being
if that
continued.
has to be changed, how will this court will change that arrangement?
Plus, that is why I'm seeking in WP 18604, where the court had directed that let the visitation rights, whatever is the parties have agreed as per the joint memo, be restored. Hence, I'm seeking in that. Because otherwise to go, I will not be able to seek that in the MFA at all. Because
not?
otherwise,
Why
plus
not?
that is a joint memo entered between the parties.
What can't be done in MFA? How can this court do it here?
Plus, it is this court that said, let the joint
If
memo
this court has said it or not, the joint memo is binding on both of you.
binding on both of them. Yes.
So he has mentioned it. The learned judge has mentioned it.
Yes.
If he has not mentioned it, still the joint memo is binding on you.
That's exactly why I'm saying I want modification of that joint memo in view of the changed circumstances.
How can it be? How is it legally permissible?
Well,
A
that
joint
is the
memo is
only-
part of a MC proceedings.
MC proceedings.
Correct.
That is before the MFA. No, in the
MFA
interest of the child, if anything has to be modified, the joint memo, the MFA division bench will modify that on your application. How can this court do it?
Not just
Because
that, it is my
because it's in
petition.
this court that the court said that as per the joint memo, let the parties
Whether-
continue.
Let us say, let us assume that this particular sentence is not there in this order. Still, you are bound by the joint memo.
Yes. Your Lordship, the reason
I'm-
this was
I'm-
passed was
I'm bound
what
by the
happened.
Joint memo. So in that case, just because he has mentioned, learned judge has mentioned about it in this order, it would not give any jurisdiction to this court to interfere with the joint memo, which is pending consideration, which is
In
part
MFA.
of a judgment and decree
Very
and
well.
pending consideration for an appellate court.
Very well. May there be just this thing that the petitioner has liberty to
will say
approach the.
No, in accordance with law, Your
No,
Lordship.
in accordance with law. No liberty is required. I'll say you have sought
Liberty-
for.
Yes, my lords.
And
Because
might
in
I
accordance
also
with-
just explain why that came? What happened was this,
No, we'll not
no,
go
the
into that.
COVID
Plus one,
excuse
this
was,
thing,
The writ petition is
Let's
disposed
let
of
the-
on 13 December 2021. And the court has passed the following order. Now when IA
let
1
the
of
observation be made that the
2023,
joint memo was in MC, so.
IA number 1 of 2023 is filed seeking for modification of the order dated 13/12/2021. Then counsel appearing for the mother submits that. As per the joint memo, they have agreed upon the visitation. Now in the changed circumstances, as it is not comfortable, as they seek a clarification, they need a modification in the said order. They have come up with this IA seeking modification of the order dated
Dated, my lords.
13th December 2021.
Yes.
It is submitted that in the said order, the court has observed that the arrangement in terms of joint memo dated 28/3/2018 be restored and the direction be issued to the court below to accomplish the pending proceedings within a period of 9 months. Then counsel submits that as there is a mention with regard to the joint memo, the same may be modified considering the changed circumstances. Then senior counsel appearing for the respondent husband submits that the joint memo is filed in the MC where the divorce is granted. The same is appealed and pending consideration before the division bench of this court. The joint memo, there cannot be any direction from this court, and there is no there are no reason that there is and the modification as sought for by the petitioner wife cannot be granted in this petition. Next part. Having heard the counsel, having heard both the counsels, the counsel for the petitioner and the senior counsel on the other side, peruse the material on record. The parties have filed a joint memo. The parties are bound by the said joint memo. No doubt, in the order dated 13th December 2021, there is a mention that in terms of the joint memo dated 28/3/2018, the parties have to, it is restored. But that doesn't give any, but basing on that, the application that is filed by the petitioner mother is not maintainable. If any clarification they're seeking, they have to seek the same from the court where the further proceedings are pending if the law permits. Hence, this court do not find any reasons to clarify the order, oblique modify the order dated 13th December 2021. Yes, next.
Serial number 25.2.
Yes, 25 point.
That is
25.2 and 25.3 are connected.
connected, connect, same order, my lords.
Yes, let's see. Yes. Let's see the operative portion of the order. Where is it? That is at page number 52. Visitation, the petitioner father is entitled for the visitation parenting rights of his minor son 30% during all summer vacation, Dasara vacation and Christmas vacation from 11 a.m. to 5 p.m. either in the petitioner's house or any place comfortable to both the parties to be chosen by both the parties. The petitioner is entitled for interim custody of the child on petitioner's birthday as well as child's birthday for 5 hours, and the preferred time shall be intimated by both the parties by filing a memo before the court. On any of two festivals celebrated by the parents from 2 p.m. to 6 p.m. What is that you want? Hmm. Overnight is one thing, and the father is granted only 30%. It should have been 50% according to you. Yes.
17/2024, this court on 24/6 had passed an order permitting the father to exercise the overnight custody of the child on Friday so-and-so, where he was permitted to pick up the child from school, drop the child at the mother's place by 7:30
In
on
the
Saturday.
original application, you asked for it.
Please, Your Lordship, it was asked.
You asked?
Please. We had sought for overnight custody. Please, Your Lordship. And then after this, Your Lordship, however, he has not stated in many words, impression of the court is that boys doesn't have any reservation to be with the father during course of the day. Father submits that on 3rd July is his birthday, so-and-so, so-and-so. Then the order came to be passed by Your Lordship. Father can exercise visitation rights on Saturday, that is 6th at 9 a.m. Father shall pick the player and drop him back at her place by 10 p.m. Boy shall go to the father on Saturday, and by any chance, if the order of the court is not complied, court will be forced to pass appropriate orders. 3/7 birthday of the father can pick up so-and-so, so-and-so,
Because I
birthday of
remember
the
all
child.
those orders.
Please, Your Lordship. And subsequently, overnight orders were passed. And they had also traveled to Chennai. There are several such orders. And Your Lordship has recorded also that there's complete comfort in both areas. Therefore, in this application, more than us, Your Lordship would know better. And in fact, the client has instructed him that they are completely open to whatever Your Lordship says, they will abide by that. So in this, there would be no argument at all, because this is the matter in which Your Lordship has spent a considerable amount of time. So whatever falls from Your Lordship, we will comply with that, Your Lordship. I'll leave it to them.
Yes, your lordship had also, when the settlement did not work out after a brief argument, when your lordship was presiding in the Dharwad bench, did want to say that I will not interfere and make that 30% as it is. However, from then on, it again continued for various settlement terms and all that. However much I have tried, your lordship is aware that the settlement could not happen, and I'm extremely grateful for the time that the court has rendered. Milords, may I submit, from the time of the birth of the child,
Yes.
The father has never had overnight custody or visitation at
We
all.
will not go into that aspect
Milords,
because he should have. He should
No,
have.
that's, we'll come to that, Milords.
Anyhow, he was not having, I'm
He was
aware
not
that
having, yes.
Order of the court, he got it. and
Milords,
it
that
went
is
on.
also, I would come to that, Milords. Father never had overnight visitation at all. As per the joint memo, the parties, the visitation of the child would be from morning to evening, once in a
Oh, having
week.
filed a joint memo, why again another GNWC is filed?
Milords, exactly. A joint memo is entered in MC.
Where is the joint memo? Is it there? in
But it
that?
is there in my petition. I am not sure if it's there in their petition, but 76, 78, Milords, if I may.
GNWC was already existing. When the joint memo was filed, GNWC was already existing. And regular visitation and maintenance was one issue. The overnight custody was another issue. So the
joint memo, what were
Your
the
Lordship, at
issues?
that point of
That's
time,
when-
child is very small. In fact, the other counsel, Mr. Arun Govindraj, was in this matter before my learned friend had come in. So he kept telling us, can he please cross the age of 11 or 12? And after that, he can come to your place. He's a little too small now. So let's just have another kind of a joint memo, which will take care of all of this till such time that it changes. So this is what it was. But the joint memo itself was being violated. And then these applications came about in the GMWC, but when this joint memo was filed, these were already pending, Your Lordship.
Well, the question that the court posed is, when there was already a joint memo in the MC proceedings, what was the need to file this application in the
Not
GNWC
application.
probably?
I said GNWC itself.
GNW,
The rights itself are decided. I thought the joint memo clarifies all the rights of the parties with regard to the child along with the.
No, Milords. Joint
matrimonial-
memo is with respect to the visitation rights to the father as well as the maintenance to the child. Both it says. However, may I add for the past 6 months, the father has not made any payment of maintenance to the child. Be that as it may, I'll come to that later, Milords. This joint memo was entered in the MC proceedings and the visitation rights were going on. Nowhere have they come up till recently, these proceedings, that there was a violation of any joint memo. The child continued to go. In fact, Milords, one more arrangement was once in a week that he goes and visits the child in the school, which never happened after few times, which never happened.
If I remember, by the time this case was taken up by this court, he was not meeting the father.
Milords,
He was not meeting the father.
He was not meeting in view of the recent change circumstances, modification, and they have filed the contempt and all of that, Milords. All of that, yes.
He said he is not meeting, he will not meet. That's what he said, if I remember.
Absolutely, Milords. Yes, that's right. And then there was mediation talks and all of that. And on my assurance and the efforts of the mother, the child was sent on the assurance that the matter would be settled within a period of 1 month.
But actually, it sends a different message. If you say that with the hope that there would be a mediation at the insistence of the mother, the boy is sent and the boy is accepted, whatever the mother
Which is a
saying.
fact in this case.
But that means in the usual course, the mother is not telling him what is supposed to be told.
Milords, that is not true. More importantly, what we need
in the
to.
interest of the child, whether the the settlement is going or not going.
Absolutely.
Still the child has to go.
Absolutely, my lords. In fact, let me again say, even before approaching for the MC and GNWC and all of that, when the child was barely few months or few years, 1 or 2 years old, the mother would coax the father to spend some time with the child because she is aware. She does not want to deprive the child.
Now for the overnight custody of the child, what is the difficulty of the mother?
Well, the child is clearly not willing to go.
Why did he go all the time?
Well, that I can produce the child before the court. The child can ascertain because the mother should not be blamed for what the child has made an opinion. Irrespective of all these, my lords,
At least this matter went on for 1.5 years.
That was for the settlement.
For the 1.5 years he was going on.
No, he did not go from past. He's not going at all.
That's what. And once the compromise talks have failed.
No, my lords, compromise talks failed. Please, let me just submit. Compromise talks have failed very recently. If I am not wrong, yeah, my lords, 28/4 before the vacation is when the last day of the vacation is when they had to give a check for 50 lakhs, which never happened.
Till such time he was going.
Plus, till such time, as per the joint memo, plus, may I just submit a mail sent by the mother to the school on the birthday of the father, my lords. Dear ma'am, Riyansh S. Keshav of 6C will be picked up by his father after school today. This was on 11th July. He will not be requiring the school transport for returning home. She has sent the child on the birthday of the father. This is last month, to spend some time with the father. There is a mail also. The father has picked up the child. It is not that he has not spent. And the father, as per the joint memo and other things, my lords, even observations made by the family court, the child has a separate iPad or whatever where the father contacts or video calls him and all of that.
I know what will be, whether he is going to comply with the order or not. If it is not complied, what has to be done is another aspect. The first one is what is in the interest of the child, what is the difficulty, why not overnight custody be granted, and what is wrong with the visitation, because it's a grown-up
Plus
one.
30%.
Why can't there be a 50% visitation for both the parents?
Because the father has never been proactive in the life of the child. In fact, the father himself, my lords, whether in the settlement talks or not, apart from that,
Why
by
is
their
he
own
not paying the maintenance?
Child is not coming, your lordship. The fees, everything, all that is being paid. That is no issue at all. With respect to child's not coming at all. Now it's blocked ever since that mediation failed, the settlements failed. And that was also only on the clause of no remarriage. And if remarriage is there, then handing over of custody. That's where everything fell apart. Now, after that.
Unfortunately, it is like this. Mother, if it is, as per her own terms, she will send the child. Father, if it is as per his own terms, he will pay the money.
No, it is not so. Even at this point of time, your lordship may kindly see, earlier it was never according to his terms, yet he kept paying. Now what he's doing is all the basic necessities of the child's taken care of. Even when the child says, I want this or that, whatever, all of that is also being paid. This amount that has to go to the mother, your lordship, at least if the father has to pay, least he can do is see the child, not allowing to see the child, your lordship. All that would be paid at one shot, your lordship. Absolutely no, but so your lordship, all of that will be cleared, your lordship. All we want is that if it is just put down ultimately, because
but how this kind of arrangement will go on? One day he doesn't come, you don't pay 1 month maintenance, or
no, it's not one day. He's not turned up at all, more than 6 months.
See that July is recently.
The school birthday one, this thing that was 2 hours. Absolutely not come home at all, your lordship. It's like, I want the money, but I will not give the child.
Contact from April.
No contact from
April.
He has video called him. He has not been coming. As per the joint memo, he's supposed to come and pick up the child on Saturday. He's not been coming. No, he has not been coming.
She's not willing to
In
send,
fact, the
your
first
lordship.
time, my lords, let me also, I'm sorry to interrupt, but when this modification application came before the coordinate bench the first time, the court did express, of course, after taking it in the chamber, that why is the child not going? I said, he's not been coming. He said, so where is the child? No, the mother and the child today are in the hospital because her father was admitted. He said, let me do one thing. I'll ask the father to go to the hospital. Please ask the mother if the child can be. I said, definitely. From then on, it did start. It's not as if the mother is keeping away the child. Why would she keep away the child, my lords?
I don't know what was happening for some time. What is not happening? Why is it not happening now?
Well, that's what I'm
There should
saying.
be some
Well,
logic
he
behind
has created a ruckus in this school also. Now an application was filed for change of school from Bishop Cotton's to whatever, Gopalan school, whatever, my lords. An order was sought by the family court. family court passes an order saying the father has to give his consent for admission of change of the school. He does not. Now she goes to the school, seeks the transfer certificate, admits the child.
If both the parties want to make their life miserable, court cannot avoid
That's
it.
exactly why Millards, the matter
enjoy.
was sought to be settled
Let
at
them
the
enjoy,
behest.
let them enjoy them have that solitude.
Because even as of today, my party is there. Of course, their party is not there. He travels half the month. He's not there. He's out of the country, not out of the city. He's out of the country itself because he has business dealings in Germany and other things as per his own this thing. Even today, if not tomorrow, whatever the terms were there, since sufficient time has passed, if there is one check for whatever amount that was agreed, we are willing to settle. We have no this thing.
What is the settlement?
The settlement was 1 crore. They went back on that.
Then again, the child will not come after the settlement.
Plus, it is not so. The child was sent. The child was sent. The child did go. Millards, he created a ruckus in the school.
The connection in the submissions, it's not going.
Look, it is not like that. He has also made a ruckus in the school.
No,
he has to win over the child.
He has made. No, he will agree for that amount.
Agreed.
How is it going to change?
Millards, may I submit? The amount of 1 crore is not for the visitation at all. It is for the divorce that already 25 lakhs is awarded. That's exactly what I'm saying.
Settle it in MFA. That you can settle it in MFA.
Look, I am just submitting the settlement that was spoken about and on the assurance.
Neither the father nor the mother are on the right track.
Because if the parties detract from what they have submitted to the court, is it fair, Millards?
Not detract from what submitted.
Fair.
They are completely on a detract. What is required to be followed, what is required in the interest of the child. Either of both of them are forgetting it.
Because they're just run. Even as the settlement talks were going on, the police were calling her to arrest her. That's not fair.
What I'm saying, if both of them want to fight,
we have to be fair before the court.
Of rest of their life, they want to be around the courts. Let them enjoy it. Let them enjoy.
I'm unable to understand what was wrong.
After spending this much of time.
Yes.
And if they feel that the problem is court's problem but not their problem, we can't help it. Let them know they will understand it.
I fail to understand what is the.
No, if they're not ready to understand, we can't help it. Well, the father doesn't understand that where the issue lies and what has to be tackled, and she knows how to deal with it, and it will go on forever.
In fact, even for schools and uniform, though they submitted that everything, nothing is paid for, Millards. Nothing is paid for.
I'll produce tomorrow. Kindly have it tomorrow. I'll produce all of the details.
Not tomorrow, Millards. Any other day.
There is nothing tomorrow.
No, if they want to seek, I'm not.
No, I don't want to seek. I'm willing to finish it.
No. I'm just saying not tomorrow. That's it.
Court is not inclined to go into any of it. Because this is not going anywhere. The agreed with orders passed in I number 11 in GNWC number 250.
So should I produce this where he was sent just on the 3rd of July? Should not.
GNWC number 250 of 2017 dated 13 January 2023, whereby the court has passed the following order, order 852, entire order extract. Both the father and mother are before this court. The father's writ petition is WP 7182 of 2023 and the mother's writ petition is WP 7678 of 2023. The grounds that are stated in support of the writ petition that is filed by the father are that the reasons recorded by the trial court are completely in contravention to the order dated 19/10/2022 passed by the trial court, wherein overnight custody of the minor son was granted to the father. The trial court has observed that I number 10 remained unchallenged as that IA is a consent order, as the said order was passed after talking to the minor's son, as well as the father and the mother. This court, give the other writ petition. 767. In support of the writ petition that is filed by the wife, that is filed by the mother. It is stated that the court ought not to have granted 30% of the vacation, 5 hours on the birthday of the father and the son, and also 2 festivals. The court has failed to see that the child is still of tender age and will suffer severe strain as a result of successful visitation. The child is not interested to go to the father's place as there are no one to play with him. The existing visitation arrangement along with the added visitation during vacations, festivals and birthdays create hardship and inconvenience to the mother as well as to the child. This court had interacted when the matter came up before this court. It is submitted that the child is not interested to see the father and the mother has no objection. Initially, this matter has come up before this court on 24/4/2024. From 24/2024 till till 25/3/2025, several orders were passed by the court. And in these orders, overnight custody is also given to the father. The father has an exercise of visitation. He has taken the child out of out of Bangalore. The father was also asked to pay the school fees. Father was asked to pay the maintenance. Both the father has complied with the same. And the child has he also has exercised the visitation. At one point of time, they said it is stated that if an amount of rupees and on certain terms and conditions, both the parties wanted to compromise the matter, then that could not, they could not come to a settlement. Hence, this court had on 1/4/2025 has passed an order that if the compromise petition signed by both the parties is not filed before the court, the matter will be deleted from the caption Part 3rd and will be posted for hearing before the regular court. Then again on 28/4/2025, an arrangement is made that the custody shall go on 11/5/2018 and 18/5/2018 as per the earlier arrangement. Then on 5/6/2025, the matter was deleted from the caption Part 3rd. It is also observed that the earlier arrangement of visitation rights shall continue until further orders. Today, when the matter came up for hearing, Then counsel appearing for the petitioner, mother submits that the father never had the overnight visitation. The boy never shown any interest. The father has never been in the life of the boy from the childhood. The mother is making all her best efforts to see that the child meets the father, but he is not interested. In fact, the mother has given a phone and an iPad so that the father can talk to the boy on video calls. In fact, without there being an order, on the birthday of the father, she has addressed a letter to the school that the father will pick up the child. It is submitted that from it is submitted that the boy is not interested to meet the father. The court ought not to have granted 30% visitation to the father, and the other and on the birthdays and all, the time that is granted by the father, the boy is not interested, and that is not in the welfare of the boy. Then senior counsel appearing for the respondent father submits that after the orders are passed by this court, the father has exercised the visitation and so many times, and he has exercised of overnight visitation, and the boy was also taken out of Bangalore. It is submitted that boy was absolutely comfortable with the father, and after the settlement talks are failed, from that time the child has never come to the father, and they come to the father except on the birthday of the father. He has not seen the child. It is submitted that from almost for more than a year, the matter was coming up before the court, and when the boy was comfortable with the father, there cannot be any impediment for granting the overnight custody. It is submitted that the court, by order impugned, had failed to grant the overnight custody to the father, and 50% of the vacation, instead of granting 50% of the vacation, court had granted only 30% of vacation to the father. As such, the said order needs to be modified. Next paragraph. Having heard the
30% from morning to evening was given, 10 to 5, 30%, not overnight.
Not overnight.
Not over.
30% of the that needs to be modified. Next paragraph. Having heard so and so, so and so. This matter is coming up before this court more than 1.5 years, and this court has several times interacted with the father, mother, and the child. And initially, when the child was reluctant to meet the father, this court has interacted with him, and thereafter he started going to the father, and considering the mother's request with regard that the father is not paying the school fees, on the directions of this court, the father has paid the school fees, and also he has paid the maintenance. Now it is submitted with the land council for the mother that from the last couple of months he is not paying the maintenance. The court had granted divorce, and also alimony is granted to the wife. Against that, both two appeals are filed.
Well, it's two appeals.
Against that, both the husband and the wife have filed appeals, which are pending consideration before the division bench of this court. The disputes between the parties, particularly with regard to the alimony, will be decided before the division bench. Coming to as far as this case is pertaining to the visitation of the father, while granting the visitation and while dealing with the case of a minor, the court would be looking at the welfare of the boy, welfare of the minor. That should be the concern of the court. There are no reasons, particular reasons for this court to give a finding, to come to any conclusion that it is not in the welfare of the child to, if the visitation is granted to the father. Now the boy is aged about
Well, it's 11 years.
13.
11 years.
He's 11 years. This court has interacted with him as a very intelligent child. Because of the choice he has, that either he can go to the father or he can equally, he may not go. Whenever boy of his age is trying to say that he will not go, it appears that the conduct of both the parties is also contributing to this. For that reason, this court had made its best efforts to see that the dispute can be settled amicably, and the boy can also, both of them can have best time with the father. It appears that both the mother and the father are not understanding the same, and they're still bent upon fighting their egos, and both of them have failed to realize that it would have an impact on the minor. Coming to the order impugned, the court had granted
Page. In their petition.
It is your petition.
Listen, in my petition, it's at page 100 and 200, my lords. 200. The relevant portion is.
Considering the step A, coming to the impugned order, the court had granted 30%.
30% during.
During summer vacation, Dasra vacation and Christmas vacation from 11 a.m. to 5 p.m. Considering the age of the boy and the fact that the earlier visitation had went on well, this court is of the view that both the parents can have 50% of the vacation on summer, Dasara and Christmas, and during the said 50% of the vacation, the father can have the complete custody of the child. Coming to the birthday, child's the birthday as well as the father's birthday as well as the child's birthday is concerned, as per the order of the court, the parties can decide with regard to the 5 hours and the preferred time. On all the festivals that are celebrated in the family, as per the convenience of the parties, on consultation, the father can have the visitation for 4 hours. When it comes to the 50% of the vacation, first 50% of the vacation, the father shall have. Yes. Accordingly, the petition filed by the father, that is WP number 7182 of 2023, is allowed. and WP number 7678 of 2023 is dismissed, and the order dated so and so is partly, is modified.
Your lordship might only seek indulgence. Vacations, if it could be mentioned as all vacations, your lordship.
That's what it is mentioned in the order.
Please, all vacations. And your lordship, and that portion with respect to the giving access to iPad, all of that, lordship, that it is the father who's only given all of that.
Whatever yes, I'll.
Please, sir, obliged.
May I make a submission, my lordship?
Yes.
My lordship, that's list to serial number 5, the dismiss for non-prosecution. So I am appealing for the respondent, my lordship. There is a amount, 10 lakh amount has been deposited to the court that we have to withdraw for that.
Which case?
Serial
Then where
number-
were you when the matter is
I
called?
was in some other court, my lordship. So I'm apprised, my lordship.
Huh?
I apprised, my lordship, I was in another court. I'm for the
List that matter,
respondent.
some amount is there, it seems. Yes, list this, the list that matter on, the matter in the, was dismissed for non-prosecution as there was no representation on behalf of the petitioner. Respondent has made a mention at the time the court is raising that an amount of rupees 10 lakhs is lying. This is matter on 10th September.
Much obliged, my lordship.
Number 34911 of 24. 34911 of 24. Serial number 5 in second list. 34911 of 24 ತಾನೆ? Yes, number.
Hello. Madam, list number 2, serial number 5, DNP.
ನಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ, ನಾವು ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದೀವಿ DNP ಮಾಡಿ.
Notification not is passed. So you give that file to.
ಇಲ್ಲ, ಅಲ್ಲಿ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ. ಚೆನ್ನಾಗಿ ಆಗಿರೋರು ಅಲ್ಲಿದೆ. ಇಲ್ಲ?
ಇವ್ರೆ ಅದು ಎಲ್ಲ ಫೈಲ್ ಪ್ರೊಸೀಜರ್ ಇಲ್ಲ. ನೀವ್ ಹೇಳಿ, ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ, ಏನು ವಕಾಲತ್ತಲ್ಲ, ನೀವು ನೋಡ್ಬೇಕಂದ್ರೆ ಫೈಲ್ ಹೋಗ್ಬೇಕು.